Please note that this content is for adults only. Viewer discretion advised. If you haven't yet, hit the subscribe, like, and share.
Hello everyone, guten Tag. Welcome back to another live stream with me, Giguere K. This is Grizzly True Crime, and we are here to watch day 6 of the Blaise Taylor trial happening in Tennessee. Day 6, right? It feels so confusing because we had court on Saturday, you guys. Day 5 was on a Saturday. If you missed it, you gotta go check it out. The state has rested, and that means today the defense is gonna be presenting their case. So let's see what all they bring, who they bring, and if Blaise Taylor will take the stand. I actually put a poll on Patreon. Make sure you check out my Patreon. You could just join the free tier as well, and to participate in the poll, for example. Let's see what you guys said there. Most of you said, 13% said, yes, I think he will take the stand. And most of you, 87% on Patreon said, nah, I don't think he'll take the stand. There's also a poll we've got going on this live stream which says, what do you think the verdict will be? Of course, at this stage, we still have to see the defense's case. We still have to hear closing arguments, for example. But you guys said 53% think guilty, 11% think not guilty, and 35% say not sure yet. Okay, well, let us see what happens today. Yeah, let's put the trial on, the sound on, everything's boosted for you. Thank you so much to Grizzly Cat for finding all these beautiful pictures and editing them of the victim, Jade Benning, and of course her unborn daughter, Ivy Blair. Shame. What a beautiful picture. I'm going to put this right here. Okay, so let's see where the court started here. Let's go forward now. We're already teleporting. Okay. They didn't have a judgment of acquittal on Saturday after the state rested. The state rested, the day was over. So I think today will be in time for some motions and then defense witnesses.
At this time, the defense would move for a judgment of acquittal.
Oh, there it is.
On a couple of grounds.
Man, you're a bit soft.
No prior attack would be able to hear or at least deliver.
Okay, so there it is. We see it in every trial. Standard procedure, judgment of acquittal. So let's hear what they say here.
On the evidence that's been placed before this jury for the following reasons. One, in regards to the 225-23 blood that was considered by the medical examiner in determining the cause of death. In that regard, the witness testified that, and when I'm speaking of the witness, I'm speaking of Dr. Bethune. Dr. Bethune testified that there was no way that she, well, I shouldn't say that she considered and had to rely on the summaries of the individuals who performed the test for litigation packet.
What are you arguing about? Chain of custody?
No, Your Honor, the state, Smith v. Arizona, in regards, there was a surrogate witness that was placed on the stand. After her testimony, it was developed that she had to rely on the summaries of the individuals that actually performed the testing on that vial of blood for 225-23 and work order number 231-26889. That is the very vial of blood that the medical examiner relied on in determining the cause of death for Ms. Benning. Given the fact that the expert who testified to the validity, the integrity, and the blood in terms of the cocaine being in the blood, that she was a surrogate witness, it should be excluded after her testimony when she stated that in the amount of time that she had to review all of the data, she had to rely on the underlying test and analysis. Additional to that, she actually testified, I did not look at each quality control. I was not able to actually check each batch With her not being able to do that, it violated Mr. Taylor's right to confront all of his witnesses and therefore violating the confrontation clause. As a result of that, anything that was relied on by that surrogate witness should be excluded and should not be considered. Without the blood listed in work toxicology report number 231268889, there is nothing that the ME has testified to that she relied on in order to determine the cause of death for Ms. Benning. In addition to that, there has not been one witness that has come and tied Mr. Taylor to any drug, any form of cocaine whatsoever. There has not been any evidence.
I mean, the defense is making good points. It's not their fault the state didn't really prove their case, in my opinion. You know what I mean? Because everyone's been asking, wait, was the paternity test done? We don't even know that. We don't know if a paternity test was done. Not that that really matters given the case, you know what I mean? Whether it was his child or not. If he's the one who killed Jade and the child, then irrelevant. Then he's guilty of that. But we don't know about that, and there was no connection made to him between him and the drugs. So they're making some good points. I don't know if the judge is gonna like it, but they're making some good points.
Presented to this court that Mr. Taylor bought cocaine, researched cocaine, did anything of the sort during the time.
Does there have to be?
We believe that there has to be a causal connection between Mr. Taylor and the cocaine in order to determine that
With
he...
just the proof based on who was in the apartment for the 3 minutes between the 911 call and the Ms. Benning's call, isn't it?
I would disagree in that it has not been established by any of the experts that the only period of time that Ms. Benning would have been required to take the cocaine, that it was only within that 3
There's plenty
minutes
of
of time.
testimony that would have been very quick.
However, they did not state that it would have been very quick after she took it, but we don't know when she took it, and we don't know who gave it to her. There hasn't been any
Be
evidence to
somebody in
suggest
the
that.
apartment, or we Danny, or, I mean, that's a jury question.
It is the defense position that no causal connection has been made between the cocaine and Mr. Taylor. As a result of that, in addition to the Smith v. Arizona issue, that there should be a judgment of acquittal, because without a cause of death, then there is no proof evidence that in fact Mr. Taylor could have caused the death of Ms. Benning. As a result of that, we move for a judgment of acquittal.
Okay. Or does the state care to be heard?
Your Honor, Dr. Mithun was very thorough in explaining that she did her own analysis. She was not a substitute witness, just reading from someone else's report. She did her own analysis. She formed her own opinion. She wrote her own report. It is not even a comparison. Her explanation about that there's no connection to Mr. Taylor and the cocaine, and the state submits that there is substantial circumstantial evidence of he is the person who put the cocaine in Jade Benning's drink. Her own words were that she just didn't know what it was. Dr. Carney gave very explicit testimony about timing and that it wouldn't take long to feel the effects. She described dizziness as being something that would be possible, as well as the person might be able to walk, but not for very long after ingestion. And she said that a time frame of approximately 30 minutes until Jade Benning would be in full cardiac arrest, that was consistent with everything that she knew, and specifically consistent with the other autopsy she reviewed. That was the only one that had circumstances similar to Ms. Benning's case. There is I would say, proof beyond an absolute certainty that Mr. Taylor was the only one with Ms. Benning in that apartment during that time frame. So the state would ask that their motion be denied.
Okay.
Oh my word, Jessica Duncan, thank you so much for the $50 super sticker. Holy crap. Thank you very much. Okay, so now let's see what the judge's decision will be on this judgment of acquittal.
All right, at this point, the court relies on the testimony that's been presented by the state. In light of that testimony, the court's discussed already the testimonial Smith v. Arizona issue. There's nothing the court's heard since that ruling that changes that. I mean, Dr. Midthune talked about each batch, but said that didn't affect her reliability of her testing. She looked at a number of them. I don't know if she was asked specifically how many, but, and in terms of the causal connection, something happened to Miss Benning in that apartment. There is circumstantial or direct proof that Mr. Taylor was the only one there, so that's not my role to judge credibility. If they believe Miss Jackson's statements, then the cited utterance from Miss Benning tells us who it was. So I'll go rule the motion for judgment of acquittal. Who is the defense first witness?
What type of James Smith you on?
James Smith. Is he here?
He is here, I understand. Really briefly, Your Honor, I think we need to...
Judge, say it more denied. Put your heaviest Tennessee accent on, sir. Denied. I love it, I love it. I love Tennessee accents. Okay. So, the defense said on Saturday, because there was court on Saturday, remember, that they plan on calling 10 witnesses, but maybe not all of them. So, I don't know. Well, let's not be caught in that movie again. We've heard that before. Remember the Tanner Horn trial? Sorry to traumatize you again, but they were like, oh yeah, we'll call like, I think it was 20, and it ended up being like double that. So, I don't know if 10 really means like 21. 21 witnesses, I'm not sure. But it should be, on Saturday they said 10 witnesses, and they don't even think they're going to call all of them. Okay. I also asked on Patreon who you guys think they will call. Do you think it'll be a private investigator? Do you think it'll be a forensic toxicologist? Do you think it'll be the current girlfriend if she's still dating him, huh? Can you imagine? Can you imagine if it's the current girlfriend of Blaise Taylor? Whoa, that'll be interesting. Anyway, we'll have to wait and see who they call.
test our computer system before we get the jury.
Oh, I thought that had already been done. The people were here.
But here. I think we're here. I don't think we tested it yet. I just want to make sure we get it tested real quick.
Turn it on.
Is that your computer?
Yeah.
Yes,
What's on your computer?
it's a PowerPoint that's on
Well, your apps are down there.
yeah.
Your Honor, while they're sorting that out, the one other thing I think we're in a
See
better,
where Mark is. What other thing?
I think we're in a better position to have a discussion with Your Honor about the jury instruction. Your Honor referenced 4210A. It doesn't have to be right this minute, but at some point when Your Honor's ready, we can have that discussion.
Do you want it in the jury instructions or not?
At this point, I think our position is we don't necessarily want it in unless there were substantial revisions to it, which we can discuss, but I think as written, we do not want that.
Okay. Well, it wouldn't all come in if he has motive and intent.
The other concern I will point out, Your Honor, is the language of that jury instruction uses the word crime.
That's why I asked you if you wanted. It could say crime or other wrongful acts.
Our position would be the word crime should be taken out entirely because there is no proof. of
I don't
crime.
know. That's what I said. Whether the jury thinks discussing with someone else about facilitating or causing an abortion is a crime or not?
I think there's specific case law that that's not.
So you want in there, if it says other wrongful acts,
I mean,
what word do you want in there?
the closest I think we would, I mean, I think that was our position on this entire form.
What do you want in there?
If Your Honor wanted to charge that, I think we would be comfortable with.
I don't want to charge anything. If it's up to you, I'm required by law to put it.
We don't want it.
Okay.
That's our position. Thank you.
What Mark from it? Thought he was here.
Nathan, we don't need this for the first witness, so we could get to this.
All right, get us Detective Smith.
Just a Grizzly Susie, that's a compliment. You said when Grizzly takes on the Tennessee accent, it makes my day because I don't hear an accent. It just sounds normal to me. Well, that means I'm doing it right. I'm doing it right. Everybody stand, please. Okay, the jury's not in yet. Damn, Marina said, I've been lurking for 5 years. Well, hello to you. Thank you for being a member for 5 months and for saying hi. Kimberlea is here, everyone, and you said, oh, I only watch trials here with all the Grizzlies. Nice, thank you so much. Okay, bring the jury in. Ready.
Sorry, let the jury step in.
Remember, he's out on bond, so he doesn't come in from jail every day. He comes from his mama's house. No, I don't know. I don't know where he's coming from. Probably there, though. He had pancakes with maple syrup this morning. He shall have salad with his truffle oil later. And maybe he will be served with LWOP tartar by the end of this trial. Who knows? Who knows? I don't know what the outcome's going to be. I don't really like that. There's a lot of suspense in this trial. It's like, is it going to be... I don't know. I have no idea yet what the verdict will be. Normally you kind of know. You kind of know. No, we don't know. We don't know.
Good morning to you, ladies and gentlemen. The jury let the record reflect all of the jurors are here and present, and the defense wants to call Detective Smith. You'll raise your right hand and be sworn.
Do you swear the testimony about to give to be the truth, so help you God?
I do. Remember that now, when I write like this, direct, it's the defense's case. So direct examination, the defense will be asking the questions. Okay, here we go. What, John Legend back on the stand?
Good morning, Detective Smith.
Good morning.
Can you please state and spell your name for the record?
It's James Smith, James Smith.
And where are you currently employed?
The Metro Nashville Police Department.
And how long have you been employed there?
Nearly 13 years.
Did you ever have an occasion to get involved in this case involving Mr. Blaise Taylor?
I did.
Were you the first officer on the scene at the hospital, the first detective on the scene at the hospital?
I was the first detective to respond.
Did you ever call Andrea Browning and give her permission to go into the house?
Initially, I did not recall that spoke. But yes, been talked about, yeah.
And would you have given anybody permission to go into the house? Is that something you would have done?
The only time that would be done is because I was not doing the search warrant, and the officer I had released, the officer, who initially was going to secure the scene or the apartment at that time. He had been released. The apartment at that time had been released, was no longer in police custody to be frozen and such. So to give permission to anybody, it would have been after that fact that I can't say they can or cannot go in there at that time.
And just to be clear, do you have any documentations or recordings suggesting that you gave someone permission to go into the house?
I personally do not.
And would you have given permission for her or any friends to enter into the apartment?
If given permission, it would have just been family. I would have given the family.
Okay. And did you give family permission in this case to go into the apartment?
Based off the recollection that was given to me, it would have been either stepmom or mother. But Ms. Browning would have been the contact.
Would an email that you sent refresh or aid in your memory for your testimony here on today?
Yes.
Have you had the opportunity to refresh your memory?
Yes, sir.
After refreshing your memory, do you have any recollection of giving Mrs. Benning's stepmother or any family members permission to go into the house?
Like I said, initially when I sent this email, I had no recollection or memory of giving anybody permission.
And when did you send the email?
This email was sent yesterday, Sunday, June 28th, 2026, around, it would have been 4 p.m.
And do you stand by that recollection?
Not with the information that was given to me this morning.
What information was given to you this morning?
You provided me a transcript. I still don't remember exactly giving the permission. Like I said, it wasn't in any documentation. I don't have a recording, and the last recording I have was speaking or interviewing anybody was Mr. Taylor. But it was possible that since you gave me information showing this transcript that from Ms. Browning that I had spoken to her.
Okay. So, is your testimony today that you called Ms. Browning and gave her permission to go into the house?
I would say it's possible, yes.
Based on what?
Based off the information that was given to me this morning.
And who gave you that information?
You did.
And the information that I gave you was what exactly?
Transcript from you stated Miss Andrea Browning testifying that I called her.
Was it Miss Browning or was it Miss Burks?
I'm not sure. I recall you saying Miss Browning.
It was Miss Burks.
I'm not sure who Miss Burks is.
Did you ever speak to a Miss Burks?
I'm not sure who that is.
That is Mrs. Benning's mother.
I spoke to her on the phone initially at the hospital. Again, I don't recall speaking to her after.
And in that conversation with her at the hospital, do you recall giving her permission to go into the house?
No, not at the hospital.
Right.
Any questions from Mr. Taylor?
With Sergeant Smith, correct?
Yes, sir.
All right. Sergeant Smith, the other patrol, the uniformed officers had spoken to certain individuals, including Ms. Browning, before you did, correct?
Yes, sir.
All right. And if the timing reflects that your conversation with Ms. Browning was approximately 1:45 a.m., does that sound accurate?
Yes, sir.
And again, that would have been after Officer Fish discussed.
Yes, sir.
Interviewed her. And so at 1:45 a.m. and thereafter, you knew that there was not going to be a search warrant.
Yes, sir.
Correct? And that there was not going to be any police presence at the apartment. Correct?
Correct.
And so legally, whatever was there any authority you had to tell them that they could not go into Jade Benning's apartment, secure it, and deal with it?
No, sir. Once it was released, I can't say who cannot go in there.
Well, when you say released,
Oh,
has anyone ever actually been there to put
No.
up crime scene tape or stand at the door,
no, sir.
barring entrance?
No, sir.
Okay. And so whether you told her that 1:45 or thereabouts, or later in a call, you had absolutely every right to go there.
At the time, yes, sir.
That's all I have.
Detective Smith, to be clear, yesterday in your email, you said you did not talk to anyone?
I said, based off my memory and recollection, I don't recall or recount talking to anyone about giving permission to enter the apartment.
And you are aware that your conversation with Ms. Browning, do you know if that was recorded or not?
The initial conversation with Ms. Browning at Vanderbilt Hospital is. Any conversation, again, the last conversation that's recorded in my interviews was Mr. Taylor.
And you would agree with me that nowhere in that recording with Ms. Browning did you give her permission to go into the house?
No. At Vanderbilt Hospital, there was no recording of me giving permission to anybody when I was at Vanderbilt.
And
Go ahead.
sorry.
You go ahead.
And outside of that recording, you don't have any documentation or recollection of ever giving someone permission to enter into the home?
I don't recall having documentation, or, like I said, Mr. Taylor was the last recorded interview I had.
And you do recall that a request was made for the scene to be secured?
I do.
Any other questions?
No.
At some point, it's a little bit vague to ask it like that. Good for the defense, though, but it wasn't a crime scene. They didn't have a search warrant. It wasn't a crime scene, so I mean, of course, the detective would say, well, you can go in there because it's not a crime scene. You know what I mean? Do you think that helped the defense's case or no? Do you think it helped the state's case or no?
Thank you.
Thanks.
Who's the next witness?
So it's kind of like making a big deal out of nothing. Obviously, in hindsight, we wish it was a crime scene immediately, right? And that they tested all the cups and everything, but that would be in a perfect world. It wasn't a crime scene at that time. So it's really, I don't think it made any difference either way, that testimony. I don't think it helped Blaise out. Blaise Taylor didn't help him there. Let's see the next witness. There's one down, maybe 9 to go.
We would call Sergeant Linsey Fish.
Do you swear the testimony you're about to give to be the truth, so help you God?
I do.
Good morning.
Morning.
Can you please state and spell your name for the record?
Linsey Fish, Lynseyfish.
And how are you currently employed?
I'm a detective with Metro Nashville Police Department
And how long have you been employed there?
since 2020.
And did you ever have an occasion to make the scene in an incident involving Ms. Jade Benning at Vanderbilt Medical Center?
I did.
And would have been around February 25th of 2023?
Correct.
And in what capacity did you show up on the scene?
I was a patrol officer.
Were you wearing a body worn camera?
I was.
Was it activated?
It was.
court officer has handed you a photo, and I want you to take a look at it. Do you recognize it?
Yes.
Does it purport to be a still image of your body-worn camera from that night?
It is.
And is it a fair and accurate depiction of your body-worn camera that you were wearing that night?
Yes.
Has it been altered in any way?
It doesn't appear to be.
Ooh, we're gonna see some.
Your Honor, at this time, I would ask that this be entered into evidence as a defense exhibit 3, I believe.
Yeah, we're just putting it in that
55, I'm sorry. Permission to publish.
Hold on.
Okay.
The judge says, okay. Caroline said 2 meanings to the term crime scene. The defense hopes to muddle it. One is informal, the place where crimes happen. The other is the place cordoned off by police to quarantine it. Yeah. I don't know. It's obviously up to the jury. I don't know if they made the impact they thought they would be making with that one, but let's see. I think they do make good points. I think the defense has some good arguments, but that one, I'm not so sure about that one.
Can you describe what you see in this scene here?
This is the entrance to the ER of Vanderbilt Hospital.
So this is can you circle this right here? That pole, can you circle it on the screen, please? What is that?
It's a form of metal detector.
And if a guest were to come into the emergency room, would they have to go past that metal detector?
They do.
You see this person with that mask on right here?
Yes.
Can you circle that individual, please? Do you know what that individual is doing?
He is the security officer for Vanderbilt and was checking people in as they go.
And that's what he was doing that night?
Yes.
And to the best of your recollection, was this individual alone, or was there another security guard also present there?
There was other security there.
And to the best of your recollection, were they doing their job?
To the best of my recollection, yes.
Okay, Donna Rabiri, thank you so much for your 20 New Zealand dollar sticker. And also to Pixie Dust for spoiling the mods with coffees.
Did you ever have an opportunity to speak with a Miss Brown that night?
Yes.
One second, I want to go right back to exhibit number 55. Can you tell me what, if anything, that security guard is wearing on the face?
The mask?
Uh-huh. Is that a mask that they're wearing in this photo?
Yeah.
What about the individual that appears to be checking in? Is that individual also wearing a mask?
Yes.
And so was that a standard protocol and procedure that night that people entering into the hospital with had to wear masks?
Yes.
Someone says I'm lost. There we go. Just a Grizzly Susie. I'm lost on this testimony. I think they're going this way because Keontae does not remember going through any metal detectors or anything like that. And Keontae on the stand said, well, I guess they weren't doing their job that night. So that's what the defense is attacking now. For some reason. I don't know where that will lead them, but we shall see.
Now, I just want to try to orientate the jury to, when you say you were one of the first officers on the scene that day?
Correct.
Would that mean that you would have come before any detectives would have arrived?
Yes.
Did you have the opportunity to speak with a Miss Andrea Brown?
I did.
And do you know who that is?
It was Miss Benning's stepmom.
And do you recall?
Roll up closer to the mic.
And do you recall while speaking to her that Miss Burks got on the phone?
I don't know who Miss Burke is.
Ms. Burks would be the mother of Mrs. Benning.
But yes,
She did in fact get on the phone.
yes,
And you were present for that.
I was.
And what, if anything, did you instruct them while you were in the presence of Mrs. Browning with Mrs. Burks on the phone?
I just informed them of what was going on and asked them if they had any questions.
And did they inquire about whether or not there was an investigation going on?
They did.
And what did you tell them?
I told them that there was an investigation going on.
Did you inform them that detectives will be coming out?
Yeah, I did.
Did you tell them that the house, the apartment, should be frozen?
I did.
Did you tell them that in being frozen, no one in, no one out?
I did.
And you came before Detective Smith, correct?
Correct.
And again, when you gave those instructions, Ms. Browning was present
Yes.
and Ms. Burks was on the phone?
Yes.
No further questions, Your Honor.
Questions from the state?
Okay. I mean, it's not very, it's not very clear, right? If the jury doesn't, which I'm sure they do remember, but if they don't remember, why on earth the defense would be asking this? It might just go right over their head. Like, what on earth are they trying to get to? Because even if Keontae had gone to the hospital and didn't need to go through a metal detector or whatever, what does that prove? What does that mean to the defense?
Good morning, Officer Fish.
Good morning.
You were just asked if you recall telling them that the scene should be frozen. Is that correct?
I do.
Okay. And if your body cam reflects you speaking to Miss Browning around 12:37 a.m., is that accurate?
I don't know the exact time. But when
But it was prior to Sergeant Smith.
Yes.
And to your knowledge, Metro Nashville Police Department was going to go out, conduct a search warrant, and freeze the scene.
I knew that that was a possibility.
And if Sergeant Smith's search warrant later got denied, and there's a possibility he told them they could go back to the apartment, would that make sense?
I wouldn't know that information.
Okay. Would it make sense if there was no search warrant and no one was freezing the scene, Metro wasn't there?
Objection, call for speculation. The witness says she doesn't know that information.
Okay, rephrase your question.
Officer Fish, if Metro Nashville Police Department has no legal basis for holding a scene, freezing a scene, if they're not conducting a search warrant, would there be any reason to tell the family that they could not go back in the apartment?
No.
Okay, those were my questions. Thank you.
Officer Fish, do you recall ever stating that you all had information that a possible crime had occurred?
I do.
And that's the information that you gave Ms. Brown, correct?
Yes. That the investigation was why the investigation was happening.
Fair enough. No further questions, Your Honor.
Any other questions?
No, sir.
Thank you. Please step down and be excused.
Yeah.
Who's the next one?
The defense calls Gutierrez.
Genevieve Green said the defense was better off not putting on a case if this is what they got. Yeah, it's a little... Defense, this is what you got? Yeah, no, just rest. It's fine. The burden's on the state. Melissa said, nothing burgers on the menu.
We'll move to Dr. Peters. What's the last name? Sheila Peters. Oh, there she is.
May we approach before?
Okay.
Okay, let's go forward a little bit. Stop it. White noise machine. Thank you so much all for being here. Happy Monday to you. Happy New Week. Let me show you my glorious new collection. Are you ready? I'm such a nerd with the stuff. Look at this. Look at it. Just look at it. Oh my word. Yeah. These Energel pens are my absolute favorite. You know, always have them, but I needed some more. Okay, I ran out. I told you guys I ran out. And somebody sent me a PayPal specifically to buy pens, and I said thank you to them in person. Thank you to that person. You know who you are. Nancy Brace, thanks for the delicious coffees. 5 delicious coffees. And to that person that sent the PayPal, I wonder, was it to me that? I can't remember. One of you said go and buy pens. I did immediately. I was like, oh, you don't need to convince me. I'm going immediately to buy pens. So yes, very proud of those. I'm already using a turquoise one here. Because of course I had to buy all of those and then, you know, a couple of extras. Don't judge me. We have to have spares just in case those run out, you know what I mean? Anyway, okay, now, are we there yet? Okay, here we go. Defense, what you got next?
Go ahead with your question.
Thank you. Could you please state your name for the record, please?
My name is Nia Gutierrez.
And Ms. Gutierrez, how are you employed?
I am a Tennessee licensed private investigator and a Texas licensed private investigator.
And how long have you been a licensed investigator?
In Texas for about a total of 7 years, and in Tennessee I'm coming up on 1 year.
We know when the defense puts on a case, they gotta have a PI. Here's their PI. Welcome, Ms. Gutierrez. I hope I spelled it right. Seeing as they didn't ask her to spell it out. Okay, we'll guess then. But okay, let's see what you got.
Did you recently move to Tennessee?
Yes, last year.
Okay. And what company do you work for in terms of for investigations?
Out of Texas, I work for Willis & Associates, and out of Tennessee, it is Covert Results.
And how long has Covert Results been in business?
Since 2017 or 2018, I believe.
Okay. Did you have an opportunity to go out to the Ontario apartment where Ms. Benning lived?
Yes.
And when you went out to the apartment, did you have an occasion to view the apartment where Ms. Benning lived?
Yes, I did, on the exterior with the door closed.
Also, did you have an opportunity to view the marquee for the apartment?
Yes, I did.
I want to draw your attention. Do you have with you photographs?
I have something else not to put photographs with me.
Should I have photographs?
Okay. I believe you should have that photograph in your packet there.
Yes.
Okay. Do you recognize that?
Yes.
Okay. Can you find that in your packet, and can I get my copy back?
I'm sorry, this picture is not in my packet.
Okay, that's fine. Do you recognize that photo that you took?
Yes.
And what is that a photo of?
It is a picture of the marquee of the incident location demonstrating the physical address of the apartment complex.
Okay. May I have it back, please, so that I can publish to the jury? Is it in the same fashion in the way that you photographed?
Yes.
And are you the one who actually photographed this?
Yes, correct.
Your Honor, at this time I'd like to publish. Is that in fact the marquee for the Ontario apartments or condominiums?
Yes.
Have you had the opportunity to view any photographs from 2023 or February in regards to the Ontario apartment complex?
Yes.
And is that marquee in the same fashion that it was in 2023?
Yes.
Could you please read for us the address here at the bottom of the sign?
It is 1522 through 1550 Lebanon Pike.
Thank you. Did you have an opportunity to go out and look to see apartment 107 where Ms. Benning was living at the time?
Yes.
And were you able to ascertain whether or not Ms. Benning's apartment had windows?
Yes.
Where were her windows situated?
On the rear of the apartment.
If I may, Your Honor. Was there anything behind that apartment where the windows were located?
There is a trailer type business, as a trailer service repair business at the rear of the apartment complex. It's rather large, and from my understanding, it's called TSR, and they repair trailers.
I want to first show you this photograph here. Do you recognize that?
Yes.
And what is that?
It is an angle from the rear of the apartment.
And are you the person who actually took this photo?
Yes.
And could you, for the jury, well, let me ask that it be admitted first, Your Honor.
Okay.
Could you, for the jury, please point out which window belonged to Ms. Benning's apartment?
It would have been, I'm not sure.
Mark.
I can mark on here? Sorry. It would have been this one.
Okay. And I want to now show you another photo. You can clear the screen.
Janet says, where the hell is the defense taking us? We're on a field trip now, and we don't know where we're going with this. There were windows. There was a marquee. There was a trailer repair shop behind the apartment complex. They're making a point without making a point. Yeah. Did you guys see that? You saw that window? You saw the marquee? Huh? Trailer company.
Oh, sorry.
Okay.
Got it.
There you go. I want to now show you this photograph. What is this?
This is a picture of the rear end driveway, you could say, of the apartment complex, coming in after you would come into the apartment complex and then turn to the left. It is a picture of the driveway alley behind the apartment.
And would Ms. Benning's apartment window be adjacent to that, I guess, would it be a pasture or field?
It would be, you could say, parallel, yes.
Okay, parallel, thank you. And if you could just orient the jury where Ms. Benning's apartment window would be located.
I can point?
Yes.
Okay. It would be this way.
And did you take this?
So the defense trying to say someone snuck in from the pasture? Huh? Somebody else could have been there. You can't say it was only the two of them. Okay.
Photograph.
Yes.
At this time, we would offer specific.
We'll just make a collective whenever you get all of them you got.
If Ms. Benning was to have a camera in her window, where would that camera, if it was facing out, where would it focus on? Where would it be directed towards?
Depending on the range of scope of the camera, it would have captured the entire back alley drive here, or maybe just her back patio, or to where a vehicle could be stationed back there, or all the way up into the trees. It's unsure.
Were there any other windows besides those windows that you saw in apartment 107 at the Ontario?
That is the only one that I recall.
I want to draw your attention now to another photo, if you can clear the screen. What is this?
This is an angle closer to the end of the parking where the truck repair service business is located, just below on the hill.
Is that also behind Ms. Benning's apartment and the view that would be out of the only window in her apartment?
Yes.
And what about?
But if the defense is trying to imply that maybe that's why the camera was pointed out the window looking there, well, her family and friends said that she did it. She always had it in the kitchen. I know she'd only been living in that apartment for about a month, but like, she had it in the kitchen so it could face the front door in case anyone came in, that she could see that. I don't know, man. Defense, wow, okay. Not starting off strong with their case at all.
This photo.
That is another angle showing the trailer service repair business.
Now, did you have an opportunity at our request to do any research in regards to the son of Miss Stephanie Franklin?
Yes, I did.
Did you determine a name for the son of Miss Stephanie Franklin?
Yes, the name is Jordan Franklin.
And were you able to ascertain whether or not Mr. Jordan Franklin was in fact a police officer?
Your Honor, to object to the relevance of this.
Your Honor, there's been testimony that a police officer gave Ms. Franklin.
Right, you asked all about it. A police officer told her to do X, Y, Z.
Correct. And if I may, I would like to.
We want to know too now. Now we're curious. We're invested, of course. So Stephanie, that's Jade, the victim's friend's mother, right? Said her son is a police officer. And he said, if you're going to go to the apartment, make sure you put gloves on, make sure you don't move anything, touch anything, whatever. So that's why they were all gloved up. So now the defense wants to know, well, is he actually a police officer? Okay, let's hear it.
What do you want to ask?
Did you ascertain whether or not Ms. Franklin's son was actually a police officer?
Yes, so to answer the question.
That would be based upon hearsay.
Care to be heard?
Yes, it's not hearsay. She did the record search herself, Your Honor.
Well, I know that, but wouldn't the information be an out-of-court statement offered for the truth?
I don't believe that if you were doing, nobody told her anything. She researched to see whether or not a T-code existed.
So
for
you
Mr.
want to litigate whether the gentleman was or wasn't a police officer?
I think that's very important for the jury to know, Your Honor.
And I object on the basis. It's hearsay.
I believe it goes on the effect of the listener.
Effect on the listener?
Absolutely.
Okay, it is hearsay, so I'll sustain the objection.
Also, it goes to 609 impeachment, which allows you to impeach with hearsay.
Based on reliable information.
Correct. And I believe that the information that Ms. Gutierrez received.
Do you have someone that you're calling from a police department saying he wasn't a police officer?
Yes, sir.
You do?
We have researched and looked
No, I'm
at.
saying, do you have a person from that department?
Ms. Gutierrez called that
I'll
department
sustain the
directly.
objection.
And, Your Honor, if I may, through this witness, introduce this judgment.
Now, I certainly object to that.
Okay. The
It's-
judgment about.
It's a certified copy in regards to
Okay.
Mr.
Have
Jones.
you looked at the certified copy?
I'm not sure which one
Yes,
is
sir.
using. We have the one,
Here we go. I gave it to you last week, but I'll give you one.
but may we approach?
Okay.
Okay. No, they're so confident in who they found. What if there's someone of the same name that's not a police officer or what? Interesting. Maybe he's retired. I don't know, but I want to know anyway. Just tell us everything. That's a long sidebar. Oh man. Okay, here we go. Thank you, Marincha.
Okay, and get those, I think, maybe 5 photos.
Okay, so that went nowhere. Marinche Greef, thanks for the ZAR 14 South African rands. Really appreciated.
Those that you asked her about. Get those and we'll make them 56 collectively. Okay, any other questions?
Not of this witness at this time.
Okay. Any questions from the state?
I request Jinx.
Any statements you have from this particular witness?
No, Your Honor.
Okay.
And may I see the exhibit,
The photos?
the collective exhibit? Yes, sir.
Okay. Yeah, that's all right.
I believe you said that you were employed by Covert Investigations. Did I get the name right?
Yes, and Willis and Associates.
Oh, okay, okay. And is that based in Texas with an office here, or is it totally Texas?
The Willis and Associates firm is based out of Houston, Texas, and Covert is here out of Nashville, Tennessee.
Okay, and so when were you retained? When were your Covert or?
Are you asking if I've been retained through which firm?
Yes.
Or, okay. Okay, well, I've been retained under Willis and Associates since before my move to Tennessee on this case.
I was just trying to get the time line down. And with respect to this particular case, when were you retained?
Covert Results was retained at some point on the case after Willis and Associates, but is my understanding, to my knowledge.
When were you retained on this case?
You start billing.
I'm billing under Willis.
When did you start?
Early 2024.
And what is early 2024?
I would say probably March.
Do you have records of that?
Yes, according to timesheets that I turn in, correct.
And do you have those with you?
I do not, but I can get them if needed.
Did you have any other involvement as an investigator with this case prior to, when you say early 2024?
No.
Were you familiar with this apartment complex prior to being
No,
retained?
I was not.
Now, Ontario is an apartment complex on Lebanon Pike here in Nashville, Davidson County, Tennessee.
Mm-hmm.
Correct?
Yes.
And this sign is at the entrance, correct?
At the entrance, correct. Main entrance.
And Miss Benning's apartment that you were directed to
Mm-hmm.
is essentially in the far back corner, correct?
I would say the center far back corner building.
Well, I mean, council's seen this photograph. They put this view. Actually, it might show better, but you have the ability to touch this.
Mm-hmm.
Where is the sign that we just saw?
It would be right about here.
Okay. And Miss Benning's apartment would be in that general area, correct?
No, that would be the entrance to the breezeway to her apartment, but not on that corner.
Okay, well, would you circle in what part of that corner it is?
Probably right here towards the center, somewhere in that section.
All right. Yep, another one that's a little bit further out. And this is a larger view of the businesses in the area, correct?
Yes.
Okay. And the truck repair place is in the top of the picture, would that be correct?
Yes.
And now on this picture, could you circle what you say is Miss Benning's apartment?
You want me to circle it on here?
Yes, please. And again, circle the entrance.
Where the marquee would have been?
Yes. Thank you. All right, tender these photographs as the next one, 58, 57.
There are two.
There are two, yes.
Okay, just make a collective 57.
And this is part of Exhibit 56 that we've previously seen. Would you circle again the, what you say is the window to Ms. Benning's apartment? No. The next window over, is this also not a part of her apartment, or do you know?
I don't recall. I have to look at a bigger angle. But it is possible.
Okay. And obviously, as we see in this picture, the blinds are closed all around, correct?
Yes.
You never went in this apartment, did you?
I did not.
And the photographs that you took, do you know when those were taken, the date and time?
Can I look at my notes, Your Honor?
Sure.
On June 21st, June 24th, and June 26th, just this recent, I visited the property.
Okay. This month,
Correct.
had you visited the apartment complex?
I was going to make it
prior to
smaller,
that?
otherwise we'll
I
get
had not.
blind. Like they're just keeping it on that very white screen. We're going to go blind, or I have to go fetch my shades on my words. So I'm just making it smaller for now, okay, until we can see something again. Missy JF said witness testimony, such as that by Najaya regarding the words of Jade, the last words of Jade, is evidence. Witnesses testify to what they heard and or saw or have knowledge of otherwise. Yes.
Judge, those are my questions. I'll
Okay.
submit these.
Any other questions?
No, Your Honor.
All right, thank you. Next.
At this time, Your Honor, we would submit the judgment.
Listen, defense. You were doing okay. You were doing fairly well, poking holes in the state's case. You should have just said defense rest if this is what you're going to put on. You've had 3 witnesses, and we've learned nothing. Nothing at all. None of that helped at all. It would have really just been better to just rest. But let's hear this next judgment.
Okay.
The judgment for Keontae Jones for a conviction of theft on September the 1st of 2022.
Okay. Mark that as 58. Who's the next one?
The defense will call Dr. Sheila Peters, Your Honor.
Okay.
Dr. Who now? Are they calling a toxicologist? Who are they calling me? Oh man, are they going to call someone just about the chain of custody again? To say that, well, what, the label didn't have the right Sharpie used or what? What are we going to say here? Oh my word, yeah, Stefan said yes, weak case defense. You know, defense judgment. They just said that Keontae was convicted of theft in 2022. He said, not to his knowledge, when asked on the stand, that he wasn't convicted. Maybe accused, not convicted. So, I don't know.
Your Honor, yeah, it is with my approach.
Okay.
The way the judge. Okay. All right. Yeah, Stefan said if the defense really had something damning, the PI would have presented that. Listen here, truffle oil, boy, you're going to have to get your ass on the stand. I'm just letting you know. If you have any chance, you're going to get on the stand, make up some bullshit. Don't do it. I'm not encouraging him. I'm just saying. You could be there saying all sorts of cuck. You know, you can't lie on the stand. You can't lie on the stand. I won't do you any favors, but just get your ass on the stand. We want to see. You're not going to speak at all? Yeah, my word. Okay, wait, I can go forward. All right.
Do you swear the testimony you're about to give to be the truth, so help you God?
Yes, I do.
This is witness number 4 for the defense. How many witnesses did the state have in the end? Let's count. There was 19 at Dr. Alex Krotolski, 2021. 22. Do we end with Dr. Kerry? I don't think so. I will count for us and let you know.
Can you please state and spell your name for the record?
Sheila Peters, Sheila Peters.
And how are you currently employed?
I am an associate professor at Fish University, and I also operate a private practice.
A private practice in what?
Clinical psychology.
Did you have to go through or undergo any schooling for that?
Yes.
What's
We are objective. They're not calling her as an expert.
This is background information, Your Honor, if I may.
What must I put a title as there? Heh. Okay. That's a good pause. there. A private practice in criminal psychology and a professor, right?
Okay, go ahead.
Did you have to undergo any schooling for that?
Yes.
What kind?
Undergraduate degree, as well as a master's and a doctorate.
From where?
Undergraduate degrees from the University of North Carolina in Chapel Hill, my master's and my PhD from Vanderbilt University.
Dr. Peters, have you ever been employed with the Tennessee Titans?
Yes.
In what capacity?
As the team clinician.
And in that role, what were you expected to do?
In that role, I was expected to provide support and assessment for players, coaches, and the entire organization.
And when you say support, what, if any, difference is there between support and clinical work?
My role was to help anyone that was experiencing any kind of distress and determine what their best treatment would be.
Did you ever come to know Mr. Blaise Taylor?
Yes.
How?
During the playing season, on average, I would attend one practice a week, and I would see him as I would see other individuals coming out to practice.
And in those general interactions, what was, if any, your impression of him?
Your Honor, I object to that.
Impression?
We're not having.
They were co-workers, Your Honor. I'm just asking her what was their impression, her impression of Mr. Taylor.
With a time frame?
All right, I'll sustain the objection.
I thought she said she studied criminal psychology. I didn't hear clinical, I heard criminal. Were my ears just... were my ears a little biased, or what? Is it clinical? Clinical psychology, is that so? Sorry about that. Studying criminal psychology. Well, you're in the right place, ma'am. We've got a criminal right here in the courtroom. How about you study him now, right? Okay, I'll change it to clinical. Sorry about that. By the way, I was so busy counting witnesses as well. There were 26 witnesses, of which 2 were recalled, meaning Detective Reese and Detective Pfeiffer. 26 for the state, and now it's 4 so far for the defense.
When did you ever interact with Mr. Taylor in 2022?
Just cordial hello. Mm-hmm.
And did you ever interact with him in 2023?
Yes.
And what was your interaction with him?
I was asked by the...
See, we all heard criminal. Okay, well, what we can do is just go back and see. How about that? There you go.
Currently employed.
I am a associate professor at Fish University.
And
I also operate a private practice.
Of?
A private practice in what?
Clinical psychology.
Clinical, it still sounds a little bit like criminal. Clinical psychology. Okay, sorry, man. Carry on.
Yes.
What dates would that be?
March the 3rd and March the 8th.
And when you interacted with him, what, if any, impression did you have of him?
And again, Your Honor, I object.
To get an impression, she'd have to be declared an expert in what?
I'm not. I'll rephrase my question.
Okay.
What, if anything, did you think of his demeanor when you interacted with him?
Your Honor, I object to what she thought about it, because that would be a clinical
She
assessment.
could describe his demeanor. What was that?
He was concerned about the situation.
That would get into hearsay.
Yes, sir.
So she just described his demeanor as concern, Your Honor.
Okay, concern. All right, then what's your next question?
And the second time you interacted with him, when would that have been?
She said that already.
Well,
March 8th.
March 8th.
Yes, sir.
And what was his demeanor like when you interacted with him on March 8th?
On March 8th, he was troubled because Ms. Benning...
Okay, see, you can't get into things he said, and you relied on those to come to that opinion.
Your Honor, I thought she testified that he was troubled, not that he said anything.
If she was about to say that, because of something.
Oh my, let me just quickly let you guys know, for those who might not know why the date's relevant. Jade Benning was poisoned with a lethal dose. It was a huge amount of cocaine, and her baby died, right? Unborn baby, which she was 5 months pregnant. So she was poisoned on February 25th of 2023 and rushed to the hospital, where she was then declared clinically dead but kept on life support. The life support machine was turned off on her 25th birthday on March 6th of 2023. So the dates that they're asking this clinical psychology associate professor about would be March 3rd. So it would be after Jade had been poisoned and she was in the hospital on life support, and on March 8th after she was dead. Like the life support was turned off, right? So, ma'am, I want to know, how much were you paid to say this? Okay, sorry.
Do you know why he was troubled?
And Your Honor, objection.
That would be based on hearsay from your client. She says he was troubled. So what's your next question?
And were you there to support him?
Yes.
And how did you do that?
Your Honor, I object to the relevance of her support.
Your Honor,
Did you counsel him? That's a yes or no.
Yes.
Okay. What's your next question?
and as a result of your interaction with him on March 8th, what, if anything, that resulted from that interaction?
Your Honor, I object to that.
Let the lawyers step up.
Let the lawyers step up. I love it when the judge says that. Let the lawyers step up. Come here, get your asses up here. Now you people, you stop your nonsense. I just wish we could hear that sidebar. I think it'll be so good. Okay, Simply Lolly said, someone is now saying the state's objecting too much, but people are complaining they weren't objecting enough. Which is it? I'm going to pick that they were not objecting enough. Okay, that's which it is for me. So I'm glad that to see them objecting today. Ma'am, did you give him a blanket, a powdered donut? He didn't like it, does he? He likes truffle oil. Oh, my word. She's not enjoying her time on the stand. She's like, I could be anywhere else right now. Mm-hmm. Oh dear.
I'll sustain the objection.
Dr. Peters, do you know if Mr. Taylor remained with the Titans after March 8th?
I don't know.
Do you know where did he go, if anywhere?
Sometime thereafter, he went home.
Do you believe that was a good decision?
Well, Your Honor, whether she believes it.
Okay, I'll sustain the objection.
When you encountered Mr. Taylor on March 8th, was there anything out of the ordinary with him?
No, it's been asked and answered.
Okay. How would she know anything?
Did he have his pacifier with him? Ma'am? Did you give him? That's him. That's him, you guys. That's him. If you missed it on Saturday, that's definitely him. Did he have a pacifier? Was there anything different with him?
Things out of the ordinary unless it comes from hearsay.
Well, based off of the impression that she would have got in observing him and interacting with him, what his demeanor may have been.
She's described that as trouble.
She did, but not in relation to what would actually happen when he left. So I think it's a little nuanced there, Your Honor.
Okay, well, I'll sustain the objection.
During your time at the Titans, did you ever have any personal problem with Mr. Taylor?
No.
No further questions, Your Honor.
Any questions from the state?
No, Your Honor.
Thank you, ma'am. You can step down.
Ma'am, did you like driving all the way here? I don't think she liked it. She looks like she could be my espresso friend. If you were on Patreon and you heard my Marisha story time about the double espressos and all that. This lady, I could tell. You and me, ma'am, we're going to be there together at the espresso machine, aren't we? She looks very Italian, even though her name is Sheila Peters. Bye, ma'am. Thank you so much.
Your Honor, this defense will call Dr. Melissa Giguere.
A doctor is next. And what are you going to testify to, doctor? What kind of doctor are you, huh?
Your Honor, at this time, pursuant to previous discussions, sake of request and carry out, because we have no report.
All right, ladies and gentlemen, the jury appeals step down the hallway just briefly.
Ladies and gentlemen of the jury, go the hell to your room. This judge wouldn't just say go to your room, he'd say go the hell to your room. Get your asses out of here. We have things to discuss outside of your presence. I'm going to give this defense a bollocking now. Okay. Go have some tea.
What is it? Hang on a second, ma'am. What is this witness being offered for?
This witness is being offered in regards to the NMS reports. To the NMS reports that were tendered to the defense in regards to the blood and urine of Ms. Benning. And the testing of that blood and urine that went to the cause of death in this particular case.
And you're wanting her declared an expert in what field?
And laboratory testing of toxicology.
Is she a toxicologist?
She is.
Okay. And the state's objection is what?
That we have no report, we have her CV, but no report to know what the parameters of her.
Do you have a report from her?
She didn't give a report. She looked at the evidence.
Notes. Do you have any report? No, I'm asking you, do you have any information from her that would be considered a statement?
I don't, Your Honor. I asked her.
I'm not talking about you, I'm talking about your firm, your counsel.
No, I am the firm counsel. We don't have anything. I've met with her on several occasions. I have my work product, but I don't have any notes from her.
So she's never emailed you or anything like that?
Of course. But it wasn't a report.
Her notes
regards to what time is the Zoom call, or are we?
She didn't have a report.
No.
So what do you want me to do?
We would hear her testimony out of the presence of the jury for the court to determine whether it will materially assist the jury
A
in
voir
basically
dire.
a McDaniel hearing.
A Daubert hearing. Oh no.
So you're thinking this particular witness isn't qualified as a toxicologist?
No, it's the substance of what she testified about that we have no knowledge. She just now says about NMS. Well, if we'd had a report, we might know whether to have had.
Some people don't do reports for tactical reasons.
Yes.
Judge, you're talking about yourself. Some people don't do I'm going to answer like that from now on. I don't do reports for tactical reasons. For tactical reasons will become the end of some of my sentences. I'm going to take that and put it in my snark box as well.
And here, since the witness has a notebook with her, that might be some, if nothing else, jinx material that we would.
What is all that?
Your Honor, it is my brief notes to prepare for testimony today and the NMS reports that were provided.
Okay. Do they have a right to look at that?
Sure.
How long do you need to do that? See, the jury's back there thinking, I won't say what they're thinking.
Say it, Judge. Say it with your whole chest. Judge, what were you going to say? I mean, the jury's back there thinking, huh? He's like, I won't say what they're thinking. Are they thinking what a shit show? Are they thinking, what's the tea? Here's some tea we're having here, but we want to know the tea in there. Are they thinking the judge is shouting at them? What are they thinking, Judge?
Prior to the last trial, when we had this come up, certainly recall that the court said witnesses would be excluded if they did not prepare a report. And here we are now without a report.
I don't know if I said that.
As well as counsel saying that they were only intending to call Eric Devlin.
Well, I don't know who that is. I mean, this person's listed on this witness list.
We have provided the state.
Lena Gill.
We have provided the state a full list of all of our experts and a brief summary of what they are to testify about. The rules and the statute does not require that every expert draft a report. Any notes that Dr. Giguere may have, I don't have those notes, and they are more than willing to look at whatever notes that she's made in order to assist herself in this testimony in the same manner Dr. Bethune had to give me notes when she turned over almost 10 pages of notes to me.
Do you have all of your notes pulled out?
They're right here, sir.
Do you want to look at those, the state want to look at those before she testifies?
Yes, Your Honor.
Okay. Run copies of those, Mr. Evans. And of Dr. Bertolone, Dr. Larkin, and Dr. Linsey. How many of those do you plan on calling?
All of them.
Do they have notes?
I can find out.
Do they have reports?
They do not have reports. All of our experts, Your Honor, reviewed all of the toxicology reports in this case. There were almost 13 toxicology reports in this case that needed to be interpreted. There were litigation packets that went along with those toxicology reports that were out of the purview of counsel's knowledge. We're not scientists, so we had to actually confer with experts in order to understand the science in this case.
Sure.
And so we hired experts to assist us to do that.
Could you have someone get from those other 3 doctors their notes that they would be using to testify?
I certainly can.
And get those to the state?
I certainly can.
All right, go ahead and do that. How long is the state meeting?
We were very much under the impression, based off of Your Honor's prior rulings in the hearings, that if they did not provide us reports, their experts would not be allowed to testify. We would have had Dr. Mithun stay so that she could be in the courtroom and listen to this, so that we could recall her as a witness. We are without our experts, which is exactly what we said when we asked Your Honor to exclude them if they did
I
not
think I
provide
can
a report.
exclude them when they don't provide a report. The rule talks about turning over a report and discovery if there is one.
And Your Honor, the state didn't give us notes of all of their experts.
They got the
I don't know.
litigation packet. That is their
We
note.
So you
asked
had-
them.
Ma'am, prosecutor lady, gentleman, don't get whiny now. the whiny's not a good look. Because of litigation packets. Hey, stand your ground. Stand your ground.
1,300 pages.
We asked for that litigation packet and paid for it ourselves. The state did not provide it to us. We provided it to them.
Do you want time to get Dr. Carney or anyone else up here?
Judge, our toxicologist is in Pennsylvania.
We never said we
I
want.
didn't ask you to say anything. So what do you want me to do? Declare a
Dr. Mithun can watch with us. You're welcome here. You could see it with us. We're a little behind because we want to skip over lunch, you know what I mean? We'll catch up. You can watch with us if you like, and then join on Zoom.
mistrial. Delay it till next Monday.
Would Your Honor allow us to contact Dr. Mithun and see if she is available to watch it by video so we can at least confer with her after this witness testifies? If she was present today, she would be allowed in the courtroom.
Sure, she can go on, as I'm understanding it, live streaming and watch it.
May I step out to get in touch with her to see if
Sure.
she's available to do that?
She's probably watching it anyway.
Get those other
Dr.
notes.
Mithun,
We'll be
reveal
in
yourself.
15-minute recess.
We know you're a grizzly. Get your ass in here. Imagine if she's like, I'm here. Wait, what? Hi, Dr. Mithun. Marion, thank you so much for becoming a member. Oh boy. Let's go forward now. Let's see how long. Damn. That's more than a half an hour. Holy crap. It's like a 45-minute break right there without lunch. Oh, crap. Okay. And we're back.
Are we ready to hear the jury out? Whatever her name is? Yes, no, maybe? Is the state ready?
Yes, Judge, we were just, honestly, to expedite the process, we are no longer asking for the jury out. We have our toxicologist that's on a link, and we won't, if Your Honor is going to allow the witness, we won't object.
Okay. If you want to be heard on your qualifications and all, then I can do that.
Not as attorney.
Okay. And then if Dr. Mithun is to be recalled,
I don't know. I haven't heard anything. I really know nothing.
Which means, Your Honor, we would like notes and emails as well, please.
what are you talking about?
I said, if she is, so that we can get ahead of it, we would like notes and emails as well, please.
Notes, emails about what?
Her testimony.
So, Dr. Mithun is going to be recalled. I don't. The prosecutor says, I don't know, Judge. We haven't heard anything yet. And then the defense says, well, if that's going to happen, we would like notes and emails on that. And the judge says, what are you talking about? What are you even talking? Oh my. Notes and emails about what's going to happen there with Dr. Mitten.
She would be, as you said, offered as rebuttal.
And I would like it.
Raise your right hand. We'll just bring the jury down.
We just got handed, are these more notes for her?
Shut the door there.
Judge, you know you want to say, shut the damn door there. Shut the door there. Slam it.
Did you give this earlier when we were in here, all of your notes?
That I had with me? Yes.
I have 4 pages that she handed us.
What is all of this?
I just got handed this.
We printed what you asked us to print, the notes.
For this witness?
Yes.
I thought she provided them.
You wanted emails, so by you.
No, I didn't want emails.
You asked.
I asked her for notes.
She gave her notes.
What are these?
My emails.
I didn't ask for emails.
These are not emails. I just got a whole stack of notes.
What is all this stuff?
That was you had asked earlier if I had sent her work product of what I was doing as I was reviewing the data, and that's what that is. That's what I sent to her a long time ago prior to preparing for testimony. This was my analysis of going through the data.
So she did give you notes.
Sounds like a
Let me see what you have. I don't know what you have.
That's not.
That's what you emailed them, and somebody printed these out for me.
It's not a report. There's not an opinion in it.
Your Honor, the state renewed our objection to this witness.
This is the exact same thing that is a snip of the litigation package. It's all it is.
Okay. Can you determine whether most of that is from your witness's litigation package?
There's only, I think, the last 3 pages of this. This is
And
all.
then what's the
notes.
other stuff?
May I explain to her what she's looking at?
I'm asking
The judge is trying to hold it together because this is all falling apart now.
counsel.
Okay.
If you look, all of this are snippets of the litigation text.
Is all of this snippets from the litigation package?
All of it is derived from the litigation package.
And then
What do you
there are
mean
notes
derived from?
on top of it.
It's notes on top of it of what I was
From
seeing.
who?
From me. As I was
Why didn't you
looking.
give us that earlier?
I didn't have it, sir. I don't have
See,
it.
this is what hide the balls off. You know, I got a jury back here, I guess I'll direct myself to you, that's thinking I'm an idiot because of this trial. The procedure, the logistics, and they're back there wondering what in the heck we're doing. That's why, you know, the intent of Rule 16 is not hide things.
I'm getting the notes in the same manner that they gave
Why
them
did
to
they
me
give
with
them?
Dr.
I'm not worried about how they
McCoy.
gave them to you. I'm dealing with how you gave them to them.
Well,
Do you think, Mr. Brand, Rule 16 doesn't include providing these notes pre-trial?
No, he did, and so.
No, he didn't. Y'all didn't. I'm asking him, do you think Rule 16 would include, when it says copy, photographs, documents, reports, and provide the other side, if you've requested discovery? Did that include this stuff?
No, Your Honor.
How so?
Because I think this is probably James material, under 26.2.
But they're reports from what you're proposing to be an expert.
I don't think that's a report. I think it's her working notes as she's reviewing the material, which could be James material, but is not a Rule 16 report.
See, that's the problem with efficiency, which I hate inefficiency.
I appreciate it.
Me too, Judge,
So,
me too.
You need additional time now?
Oh,
Yes,
no.
I would like for my expert to be able to have this. I just got handed it as she was.
Can you email that to your expert?
Completely disorganized. Judge, I submit that what she has provided is a report that she provided to the defense, and she just said it was a while ago, and the defense did not provide it. We filed a motion to exclude it and asked Your Honor to exclude any witnesses that had not provided us with a report pre-trial.
They're saying that's not a report.
I mean, do we need to have a jury out to determine if it is? If it is a report, is Your Honor going to exclude it?
Sure.
Then I would ask the witness, there be a proffer to the court for the court to make a
Inspect
determination.
and copy or photograph books, papers, documents, photographs, tangible objects, or copies or portions thereof, if the item is in the defendant's custody and intended to be introduced as evidence in their case in chief.
This is not being introduced in our case in chief.
That makes no sense.
Well, it's not. It's not being introduced for our case in chief.
So you want to orally ask her all about it and then just... I'm not moving
in
to
the same manner
introduce.
that General Norman did.
I'm not dealing with that. I'm dealing with, have you complied with Rule 16?
Yes, I have.
So you're not going to ask this witness to introduce anything?
No, I'm not.
I don't believe you.
So what do you want, General Norman?
Well, honestly, I gave somebody my paperwork to go copy it and send it to our expert.
I thought you got an email with that in it.
I haven't even had a chance to look at it, but what the little I looked at, it looks like she typed up a report.
It's not a report.
Where is that? Where's the copy I gave you?
Here it is.
Stefan says I smell some
What
dirty
page
tricks
in
here.
that are you thinking is a report?
There's one that has like 7 or 8 pages and then a couple of pages of litigation packet in the back.
So I'm not worried about the litigation packet.
I'm not either. It's everything that precedes it.
It would look like, I don't know, what, page 47, 48, what are all these notations from the litigation packet?
Yes.
Page 50, 51, so that's just a summary of what she's looking at. 69, 75, 81.
Susan Hartman says, please defense rest now. They're not gonna.
How, Ms. Hollins, is this not a report telling you what she's finding in the medical records?
She is regurgitating what is in medical records. It is not an opinion. She's not a doctor. So there she can't give an opinion on a medical record.
Well, it's saying here,
And neither are we planning on introducing it.
page 75, instrument had an error, incorrect vial, not on our case. What's she reporting to you?
What's in the litigation packet? That is not her opinion. That is directly taken from the litigation packet.
Okay. What do you want to do, General Norman?
Judge, I mean,
Witness testifies.
I think the witness should be excluded.
Okay, other than that, what do you want to do?
I would ask the court to give us 5 minutes so I can at least have the paperwork in front of me before she starts testifying.
Did you get this document through an email?
I don't know. She handed me documents. She emailed me documents. I'm
It
asking
was
that
an email
all.
to the court.
I asked
Were you
all
not
of it
in
be
on it?
printed. I'm saying I don't think they're the same things. What she handed us and what she emailed us, they are printing it right now.
Oh dear.
The emails that I sent over are nothing but logistics. I sent them over because they're emails.
Sent them to who?
To Joe.
No, I'm not talking about emails in the past. I'm talking about, did you email this packet to the state?
I don't know.
Yes, Your Honor, I believe that the packet that you're holding is included in email to the state that has
Did you get this
several
by email?
Word documents.
I received an email with 7 attachments that say summary of lit package, which sounds like a report. If she is not introducing anything, then our
Do you
request.
want to forward this to your
Yes.
Dr. Mitchell? Can you do that?
I have forwarded the email. I'm asking that the printed documents, which don't appear to be exactly the same, be scanned in so we can send that, and that's happening right now.
How did I get this if it's not included in an email?
I'm saying she handed us documents and the emails look like there's additional things.
Who handed you documents?
They did, right when she was walking out
Was
to the
this
stand.
packet sent to the state as an email?
Yes.
Yes.
Do you have that?
Yes, Judge, I received it a few
Okay,
minutes
can
ago.
you forward that to your expert?
I did.
Okay. All right, so do you need additional time?
I would like to have a copy, but I guess.
Oh, okay, give that to the state. So do you want additional time?
No, Your Honor.
All right, let the jury step down.
All right, everybody stand, please. Jury's coming in. We're steaming ahead. Wow. That was interesting. Defense, what you trying to do there? Yeah, Stefan said, now I really want to see this doctor. Me too.
Judge, just before they get out here, the state is going to object to her testifying to anything related to any report that was not introduced as evidence in the state's case in chief. She cannot introduce NMS reports that have not been introduced.
Okay.
And so,
These two binders?
no, those are the medical records.
Okay.
So their NMS did more testing than what was introduced in our case in chief, and I'm objecting to her testifying to any reports that were not testified to by Dr. Mitten and entered as evidence because it's irrelevant to this proceeding to talk about other tests that were not presented to the jury.
Okay. Do you agree with that, Ms. Hollins?
I do, because we're only
Okay.
talking about the two.
Good, then we don't have a problem.
It's going to make me need to get a coffee. Oh my word. Coffee at 7 p.m. Let's just wait for the doctor to get on the stand. The jury to get in the room. Damn. Almost there, almost there. Jury, are you so excited? Are you ready?
All right, thank you for your patience, ladies and gentlemen of the jury. Ma'am, if you'll step up, raise your right hand and be sworn.
You swear the testimony you're about to give to be the truth, so help you God.
Yes.
This way. All right. Okay.
Good afternoon, Dr. Giguere. How are you?
Good, how are you?
I'm good, thank you. Could you please state and spell your name for the record, please?
Dr. Melissa Giguere, Melissa Giguere.
And how are you employed?
I am currently an independent contractor for forensics toxicology and science.
And where are you in terms of company that you work for? Who do you work for?
I currently work for a company that I own. It's MG Forensic Consulting.
And how long have you been a toxicologist?
I started doing toxicology in 2014.
And where did you go to school?
I received my Bachelor of Science at the University of North Texas, and I also received an Industrial Master's from the University of North Texas in chemistry. An Industrial Master's is different than a regular Master's because I did not have to do a thesis. I had to be working in the field and had to write my paper in regards to what I was finding and doing the lab work in the field. And then in 2023, I graduated from Oklahoma State University with a Doctor of Forensic Sciences with an emphasis in toxicology. It is not a PhD, it's a professional doctorate. The difference between a PhD and my doctorate is I didn't have to write a dissertation. I had to be employed in the laboratory, and all of my papers were based on data that I produced while working in a laboratory.
And how long would you say that you worked directly in a toxicology laboratory?
Just over 10 years.
And have you been peer reviewed with your work? And have you also peer reviewed others and their work?
Are you referring to peer reviewed and just releasing my data and someone reviewing my work prior for release?
Yes.
Yes, I've done both ways.
At this time, we would tender Dr. Giguere as an expert in laboratory toxicology.
Any questions on that request from the state? All right. Letitia of the jury would still have to give an expert opinion in her field. Like I told you before, you could place such weight on it as you choose.
And do you have a curriculum vitae in regards to your training, experience, and education?
Yes, I do.
At this time, Your Honor, I would tender Dr. Giguere's CV.
All right. You want her to see it?
No, I just tender.
Okay, just give it to the clerk for 15 minutes.
Dr. Giguere, have you had the opportunity to work in labs that are accredited by the ANAB?
Yes, I have. I did my full 10 years working with an ISO ANAB accredited laboratory.
And what exactly is ANAB?
So ISO 17025 is it's an international standard that people who do qualitative, quantitative results have to follow this standard. It is, if you look up pharmaceutical companies, petroleum companies, they follow it as well. So then you have ANAB, which is a subsidiary more for forensics that you have to follow. And so it gives a little more guidelines to be more for science versus petroleum or some other company that could have ISO. But then it goes a little further, it goes into ASV, which is an American Standards Board, and they produce guidelines and standards specifically for forensic toxicology. So you have a blanket overview and then you kind of narrow down into a funnel from there.
And can you tell us some of the things that are required in order to be accredited, such as chain of custody, such as keeping things stored at proper temperatures and things of that nature?
Sure. So the accreditation is very, the ANAB standard itself is very bottom line. It's very minimum, and it says you have to maintain a chain of custody. You have to monitor your refrigerators, and it should be kept between this temperature to this temperature. But you get those more finite details in the American Standards Board standards, those ASB standards. ANAB is more of a general, it's you have to do this, but you should try and go better. It's the bottom line of what it is. And so you have to maintain chain of custody, you have to document all kinds of everything in a forensic laboratory.
You have to, the bench notes that as you're working through a case and you take a bench note, you write down it's oily or it smelled funny or whatever, that has to be maintained with the case file as well. It also goes through guidelines about who's allowed to work on it based on credentials. It goes through who has access to certain areas. It restricts that. It doesn't restrict it, let me clarify that. It dictates how you should document who has access. It's more of a documentation aspect from A&AB versus the recipe on how to do things.
And why is that important?
Forensics is the way I look at it, has three pillars. You have integrity, you have chain of custody, and then you have unbiased opinions. And you have that as a three pole and a stool. If you lose one of those, then you kind of wobble and you kind of can lose the reliability of the forensic analysis that you have. And so those guidelines between ASV,
like the defense's case, little wobbly, little shaky,
A&AB and ISO all help to make sure that that stool is good and stable and it can be reliable and accurate at the end of the day.
So I want to draw your attention to the NMS lab report number 231-26889. Are you familiar with that toxicology report?
Yes, ma'am.
Do you have a copy of that report with you?
Yes, ma'am.
How many reports were issued under that work order?
I just have the one that was originally provided to defense that was dated 5/16 of 2023.
Yeah, why can't the judge say, we already heard this thrice? We've heard it over and over.
And have you recently been made aware that there was a new report issued on June the 10th of 2026 in regards to litigation packet 231-26889?
Yes, you informed me of that.
I want to talk to you about whether or not when you did your analysis, well, let me ask you this first. Did you do an analysis of this particular toxicology report?
I wouldn't call it an analysis in the sense of science. That's doing actual chemical extractions. I did do a review of the data.
Okay.
Sorry.
Excuse me. I need to get with your terms. So tell me, what, if anything, did you learn after reviewing the data in regards to work order 231-26889?
So when I first reviewed it, what first caught my eye was we can see at the bottom it says specimens received, so that's what I go to look at. Typically, if you're looking at anything for blood,
Sorry.
oh,
It's not working. Just get it. Don't worry, I can use this. My computer doesn't like that. Can I switch? We're going to end up having a problem with it, so don't worry about it.
My witness is not in the feed. It keeps hanging up and she's not able to view what's happening.
You can view what's happening on YouTube. Yes, you can. Stop trying to get on Zoom. Just go to YouTube, Grizzly True Crime, okay? Come watch with us. The defense should have just rested.
said it's on the witnesses end that he can hear.
It's not that she can't hear it, it hangs up, it just lags and freezes up, so it's not just hearing, it's freezing.
That is her internet and her buffering.
You want to go out and call her and see where she might be or relocate?
Oh dear. We need to get Dieter in there. Dieter, you gotta help Judgement then. Her internet is buffering. Maybe mine's gonna start buffering soon too. Oh my, is that an outage? An entire outage in Switzerland, just like that? Boom, gone. What happened to G? Gone, sorry. Whoops, I'll be back for the verdict. This defense case, oh my word. Do you think they're gonna do this today and tomorrow? Wow, we're on witness number 5 for the defense. They said they might not call them all, but they think they have 10. So, ma'am, how much did the defense pay you, huh? It's a valid question. Listen, state, you better ask it. There you go. See, Ken, you know things. How much the defense paid for testimony. Scott says, crazy. She interrupted her own witness. KK on YouTube said, please, doctor, just join Grizzly to Crime so we can get on with this trial.
Connor, is there any way that Dr. Midday could just have an audio line? I mean, I'm happy to do it on my own cell phone.
Ladies and gentlemen of the jury, if you'll step back down the hallway.
Oh, crap. Ladies and gentlemen of the jury, I am mortified and I'm setting you out, all right? Go eat some more cookies, we'll call you back in.
I don't know of any way to do a Zoom link and do additionally what we're talking about doing in this trial. Is she somewhere that she can relocate or get better internet service?
She said she tried it on Wi-Fi and also her cell phone. She was in the car driving and drove to the location so that she could do this. She said,
just go on YouTube.
If she could just be on a phone line so she can hear what is said, that would be sufficient. Is that a possibility?
I don't know how well she'll be able to hear, but we call her from that phone right there. As long as she's not speaking.
She wouldn't be speaking.
You want to come punch in her number?
Want to come punch in her number? Or just tell her to watch on freaking YouTube. That's the easiest way. You can do that on data.
Hit speaker.
Hello? Interesting day we're having so far, huh?
Toxicologist, this is Carrie.
Dr. Mizzen, this is Jean Norman. Can you hear me?
I can, yes.
So I have you on the phone at the court.
Okay.
Can we ask the witness to say something to see if she can hear?
Can you hear me, doctor?
Yes, I can. It's a little difficult, but I can hear you.
Okay, can you turn the volume up on all the mics?
Could we get the witness a megaphone? Can you imagine? Get a megaphone. All right, Dr. Melissa, toxicologist lady. Okay, now you speak real loud into that megaphone. You hear? Can you imagine?
All right, can you state your name, please, ma'am, for the record?
Melissa Giguere.
You'll have to speak up into that mic.
Melissa Giguere.
Can you hear that?
Yes, that's much better. Thank you.
All right, bring the jury back then.
Everybody stand, please. Juries come back in. Oh boy.
Judge, Dr. Mendon couldn't hear the report number. Can we just let her know that we're talking about 2312688?
231
688
26889
7442.
Okay.
Oh, says this guy. Is that so? Should my internet be? You're enabling this idea. I see. You want my internet to go out. I don't think your internet going out from the heat wave in Wales is affecting the lady in Pennsylvania, but you never know. It could just cause an entire outage in Switzerland. And then, what do you know? We won't be able to watch the defense's case. What a pity. What a pity. That'll be so unfortunate. Yeah, Stefan's like, I like the entertainment factor in this trial. Mm-hmm. I hope that Dr. Mitten sorry, it's a very naughty wish, but I hope she forgets. She's on speakerphone and is like, oh my, she must say like, no. You know, while the defense is trying to question their witness. No, that's absolute bullshit. Okay, ma'am, you're on speakerphone. This trial's in Tennessee, by the way. Dr. Mitten, the state's expert, is in Pennsylvania, is what they said. So she can't be in the courtroom right now, which is why they've used the court phone to literally phone her, because she was trying to watch the feed, but not on YouTube. I don't know why. Somehow being linked in here and couldn't see, drove somewhere to try to get better internet. It didn't work out. They've literally called her. Okay, she's on speakerphone. She's on speakerphone over here. They did a little sound check. I think they need a megaphone. Everybody gets a megaphone, except the defense attorney. She's loud enough. Anyway, so here we are. Tennessee versus Blaise Taylor.
Dr. Giguere, we were talking about litigation packet 231, toxicology order 231-26889 from NMS. Can you tell the jury what sample of specimen is this referring to?
You'll have to speak into the mic.
It's referring to the clear plastic top tube with 1.75 mils that was collected on 2/25/23 at 22:31 or 10:31 p.m. labeled hospital blood. And it also includes a clear top plastic tube, 8 grams, collected on 3/7/2023 at 13:34 or 1:34 of liver tissue.
Now, we see there on this report that number 1 is a clear plastic tube, which is self-explanatory. But could you tell the jury what is ID 003, homogeneous container?
So as you heard from Dr. Methune, that's where you take it and you blend it essentially and make it so you can, in analytical chemistry, you have a thing, it's called an Eppendorf pipette, and you have to draw up a specific certain amount for the test to be accurate and based on validation. And so you have to make it to where you're able to draw a liquid into this little tip to be able to start the extraction. So the laboratory took, I don't know how much, usually it's documented, but you take a portion of that, you weigh it on an analytical balance, and then you mix it, in my experience, we've mixed it with water, and we put it through a blender, better way to think of it, and you hit go and it blends up the tissue to make it to where it is more pipetable for the equipment.
And we see that on item 2 and 3, it notates liver tissue. Do you know whose liver that this report is referring to?
I do not, because the labeled as number is the same. So I would think that I interpreted this when I was first reviewing that the liver was from the same person with the hospital blood.
And whose hospital blood does that belong to?
Based on the review of the medical record, that it was tied to a Jade Benning.
Have you since learned who the liver tissue belongs to?
Yes, it was discussed that it was belonging to the fetus of Miss Benning.
I'm telling you, man, this judge is going to lose his mind. This witness is speaking even softer now. Ma'am, the other expert, are you scared of her or something? Probably, you know what I mean? The other expert is on the phone trying to hear you through the speaker. Why are you speaking softer? I'm telling you now, we're going to get you a megaphone. That's what I was calling about. I called Walmart. Tennessee's nearest Walmart. Hello. Do you have megaphones? You got some megaphones? Okay, can we just get one in here for this witness? Thank you so much.
Have you, well, in preparation for litigation, is there something that NMS will provide to attorneys if the attorney requests that?
It's called the NMS litigation packet. You've heard about talking about litigation packets.
The answer would be either yes or no.
And loudly.
Did you get that?
Yes.
And
come on, man, what is going on here? What is happening now? Why are you speaking like that?
can you tell the jury exactly what a litigation packet is?
Sure. So a litigation packet is a copy of the report, followed by a copy of their receiving data, where they start their chain of custody. It also includes the summary of who would have touched the sample along the way. It also includes the, if there's a disposal, there's a communication log, anytime that there's a communication regarding to that particular case. Sometimes there's also emails that are included in it that are not in the communication log, just within their own departments. Also included in that are all the testing that was completed for that case. So in this case, I believe it was around 1,900 pages to review. You have every test that was ran on it. You have all of their standards, which are the calibrators, which allow you to put a quantitation number to something.
We know. We actually had the toxicologist describing all of this. I'm not really trying to snark at the witness. It's more the defense strategy, but like, come on, man. We do not need to hear this for the 4th time. We heard from the, sorry to say, actual experts. We heard from them. Okay.
It also includes the quality controls, and it includes this case specifics data.
And did you have an opportunity to review the litigation packet for toxicology report 231226889?
I did.
What, if anything, did you find as a result of reviewing that report?
That it, looking at the, and I don't have it up here, I didn't bring all of it, but the request was signed to be relinquished from the medical examiner's office on 3/31. It was received at NMS, I believe, on 4/4. With any kind of blood sample or even just tissue, anything that's biological, it needs to stay refrigerated. For multiple reasons. It helps to slow down any kind of growth or breakdowns, preferably to be frozen, but it helps to reduce that. And then looking at when it left the medical examiner's office, I presume it arrived with the body. Part of my past experience is I did medical examiner work, and we would get antemortem tubes with our postmortem samples to look at and compare. And when we would get that, they would be multiple tubes to choose from. And so I don't know if there were multiple tubes sit in this case and this is the one that they chose. But it was collected on 2/25 and it doesn't, and as far as I can tell, arrived to the medical examiner until 3/7. So I don't know how it was stored, who had access to the sample. It was collected for medical purposes, so I don't know what was done at the hospital for testing, opening, who had access to it there, how much blood was removed, did they spin it down at all, anything that could have happened to that tube prior to it arriving at the medical examiner's office.
So thank you. So are you?
Okay. Tell me that you're regretting saying yes to the defense without telling me you're regretting saying yes to the defense. How much is this worth it, ma'am? How many dollars are we talking about there? Curly Toes Productions, welcome to membership. Grizzly Diner Banana said, in G's accent, oh my word.
Stating that you found that there was an issue with the chain of custody with this particular sample.
Yes. And the medical records also state that they couldn't identify a chain of custody, which is why they contacted the PD to have the PD come draw their sample to establish a chain of custody.
Absolute bullcuck, man. Ma'am. Talking bullcuck over here. We've already cleared this all up.
So, did you ever find in your review of any of the materials anything that could establish a chain of custody that would be sufficient, in your opinion, in regards to the ANAB standards?
The laboratory maintained a chain of custody, and that's where the chain of custody started.
What about previous to the time before it got to the laboratory or arrived there?
I don't believe I've had any documentation for that.
Was there anything else that you noticed about this laboratory report that you found issue with?
Yeah, tell us. While the other doctor listens in.
I notated that there was no seals on the tubes when they arrived at NMS. There was no evidence tape over it. There was nothing to seal it. Not saying it was open and spilling everywhere. I'm not saying that. The sample would have been closed because there was notation of no spillage. But there was nothing over top of the tube and a date and an initial to make sure that it hadn't been tampered with or had anyone had access to it prior to it arriving to the laboratory.
So you're trying to say the doctors, nurses, toxicologists put the cocaine in it or what? Because we've been over this a million times, okay?
That's something that ANAB requires of an accredited laboratory.
No, it doesn't require it to be that. It's just required that they document how it was received.
What do you find is best practice when you're dealing with these types of forensic toxicology tests, especially in criminal cases?
In my experience, we've received our samples for forensic toxicology to be sealed, dated, and initialed by whoever collected it for the integrity of the sample.
And was that done here?
It was not.
What type of tubing was the blood or the vial of blood? What type of tubing was it packaged in?
It was in a clear plastic tube, which would have no preservatives. So if there was a dirty collection, meaning they didn't have the site clean and some bacteria got in, there's nothing to even slow down bacteria growth or bacteria formation. And there's also nothing to slow down or retard any of the degradation of any of the drugs that would have been present.
Okay, they found a lot of cocaine in the blood. You know? Like over 7,000 nanograms per milliliter, of which the highest cases normally with an overdose, for example, they said was what, like 1,000? Okay, a lot. We're not looking at bacteria, ma'am. This is frustrating. Judgement, Dax, thank you for being a member for 16 months. You said, it feels like the defense case has been going on 16 months already. Couldn't stand this nonsense without you, Giguere, and the Grizzlies. Thank you so much for your support.
Are there, if you can educate the jury, and we've all had our blood taken before.
Yeah, educate them.
Are there different types of tubes that are utilized to preserve whatever the sample is, whether it's blood, urine, whatever that is? Are there different type of tubes for that purpose?
Yes, there's different color top tubes. Ones that I'm familiar with from working in the laboratory, we saw tiger top, we saw blue top, purple top, and those are all unique to the medical field of what they're looking for to test. So each of those have a different preservative in them depending on what the medical need is out of that sample. The most common one used in forensic toxicology is the gray top tube because it has potassium fluoride or potassium oxalate and sodium fluoride, and both of those help to slow down or retard the formation of bacteria, as well as help to preserve the blood specimen as best that it can.
We know, we heard from the experts. Thank you so much. Judge, please just snap at it. Bets George, thank you so much for your South African Rands 14 ZAR. I really appreciate your support.
Now, was this sample actually preserved with the proper tubing?
Not for forensic testing.
So, did you find that as a result of the issues, well, let me ask you this, were there any other issues that you found with this particular vial of blood?
I think that those are the main ones that I found.
At some point, were you able to ascertain the levels of concentration for this particular vial of blood in terms of what it was looking for? What exactly was this test looking for in regards to this toxicology report, I should ask?
So it was looking for cocaine in the products, which is what it's listed as, which is the cocaine and the metabolites. And the blood was also looking for designer opioids, which are going to be looking for your more typical illicit fentanyls and illicit opioids. This did not look for the actual drug of fentanyl.
And so are you stating that where we see the testing designer opioids, that does not include fentanyl?
It does not.
Did you see anywhere in this particular report where it was asking for a fentanyl test?
I do not, and they also didn't order a general screen that you typically see with forensics post-mortem that we saw in the liver, which is a very broad, looks for multiple substances, and I believe there was a note in there that it was a direct reflex for cocaine and the designer opioids because they were nervous about the volume of blood that they had left for testing. So they directed the sample instead of taking out of the normal flow of how a sample would have been received and processed.
I think she's talking a lot of bullcat.
And were there results as a result of the testing for this particular report? Did it yield any results?
It did.
And what results did it yield?
We have benzylecanone, which is the first major metabolite out of cocaine.
Louder.
Cocaine, which is the parent drug. And then ercanine methyl ester, which is a secondary metabolite out of the parent cocaine.
Was there anything else of consequence that resulted out of this blood as a result of the testing that was performed?
So the things that are reported are things that are above their what they call the LOD, the lower limit of detection, or the LOQ, which is the lower limit of quantitation. I'm not sure, it was not provided their SOP or their validations for these methods, so I don't know if those are one and the same. Some laboratories, their LOD and LOQ are the same. Then what that means is that the instrument cannot look below that quantitation level or that limit of detection and be reliable. And so I don't know if that included that, but in my review of the data, I actually did find that there was some of the metabolites that were present that were just not above the reporting limit, so it wasn't reported, but there was presence of an indication of in the data.
And what exactly did you notice that was present in this particular report that was not reported?
So in this, it would be the item number is 1A1, And I can identify it because it has a 001. So if we go back to the first page and we saw that the clear top tube had 001 in front of it, that is, as I review the data, everything that I find that has 001 is tying it back to that specific item. So I'm not mixing up that with the other liver item, or they're homogenate. And so I was, there is presence of coca-ethylene in the windows. And if it's not there, then the window should be just a flat line. There should be no coloring of the little mountains or peaks in there. But the
is this?
No, that's 285.
I apologize.
That's okay.
Let me make sure I have the right one. So, did you find, in fact, coca-ethylene in that report?
I found indication of. I will also say, though, that the if you'll pull up so I can up or down. Sorry. Over to the right. That's the comforter.
Okay.
And so the ion ratios, though, on this are out, however. And what that is important to also note that even though it is in the window, the ion ratio is out. So it was below the reporting limit, and it had another criteria that was also out for the reporting limits. But this was a very low sample, and it was very, I don't know what all had happened to it prior to, so if we would have had a full sample, I don't know if those ratios would have been able to be in, because I would have had the full sample instead of having stuff removed, because I don't know what the hospital took, and I don't know what the hospital did to that tube prior to it being there.
Okay. And so did you in fact find a notation or an indication, if you will, of coca-ethylene?
Yes, it is present in both windows of the, there's a transition, you have a main transition and you have a second transition, and it looks at, for lack of better understanding, you have my water bottle as one transition and you have this cup as a second transition. You look at this ratio of the height between the two, and that's what it's talking about the ion ratio. That ratio needs to be consistent to call that drug. But just because it doesn't have the ion ratio, it should lend to further testing to look and see if it is actually present or not.
Okay. Would this be the correct?
No, that's 183.
Oh, okay. Sorry about that. So, but you can tell us that it was in fact an indication of coca-ethylene in this report.
There's indication in both windows, yes.
Now, you stated that the ion ratio was out, is that right?
Yes.
And so how can you then tell this jury that coca-ethylene, there was some indication of it?
The ion ratio being out doesn't mean that the instrument didn't see the analyte. The instrument saw the analyte and was able to generate a indication or a peaks in the window. If it wasn't there, it wouldn't have a peak in the window.
Okay. And did you in fact see a peak in the window in this particular testing?
I saw indications of yes.
Okay. What does that tell you in regard to whether or not coca-ethylene was present in the blood of Miss Jade Benning?
As I said, it would just draw me to do further testing.
We're at the coca-ethylene again. We're at the coca-ethylene. Oh, man.
With the ion ratios being out below the reportable limit, it would definitely cause me to run the test again, see if we can do, you can do microing, you can pull it down and reconstitute it and make it at a stronger concentration, and then rerun it and see if we would be able to obtain a value or not, to prove if it was there or not.
So if I draw your attention here at the bottom of page 3 of 4 of this report, do you see where it states coca-ethylene here?
Yes.
And is this a confirmation test?
Well, we're looking at the liver. You need to move up a little bit.
Sorry about that.
Okay, yeah.
Okay.
So this would be a confirmation because we can see that it's the liquid chromatography tandem mass spec, and that's where we're able to get the two different windows to see the transitions based on the instrumentation selected here. If this was a screen, it would have been an ELISA or an immunoassay type test.
So before they move to a confirmation test, what type of test do they perform first?
Typically, you would do a screening test, but in this case, I believe it went straight to confirmation. So they skipped the screening test and went straight to this test to look for the drugs.
Judge. The judge is all of us and the jurors right now, isn't it? I think that I hereby speculate the jury looks like this too right now. Maybe they even like.
Thank you. Are you familiar with coca-ethylene or the metabolite coca-ethylene?
Yes.
What is that?
It's a metabolite that is made only in the presence of ethyl alcohol and cocaine at the same time, and it's made in the liver.
And is there any other way, to your knowledge, that coca-ethylene can be formed in anyone's blood or urine or any matrix that you know of?
No, and that's what makes it unique about coca-ethylene, is the only way it is produced is with mixing cocaine and ethyl alcohol, or what we would call alcohol in our normal language, and it has to be at the liver at the same time.
And there was indication that here.
Yes.
Did you find that there were indications, and just so that we're clear, at what time was the blood sample taken for toxicology report number 2312689?
We've been over that 4 times.
2:25:23, 22:31 military time, or 10:31 p.m.
And did you have an opportunity to review the medical records in this case?
I did.
And did you find in the medical records in this case an actual urine drug screen that matched the date and time in this toxicology report?
A urine drug screen?
Yes, well, the urine was taken from Ms. Benning. Did you find that in the medical records?
Yes, I saw urine was taken. I don't have it in front of me. I don't know the time, but I know it was taken on 2:25.
Did you find that it was consistent with what you saw here?
This was a blood.
In terms of this report.
So this was a blood sample. So
I'm sorry, not urine, blood. Yes.
So I did see in the medical records that there was blood taken. There were several orders of blood being ordered at the 22:31 in the ER medical records.
Yes, that's my apologies for speaking that. Now let's go now. You were talking earlier that I had showed you the comforter. Do you remember that?
Yes, ma'am.
And that would be toxicology report 231298285. Do you remember that?
Yes, ma'am.
I want to show you now what would be considered the data from that report. Would that be consistent with that?
Yes, this is a summary page of the coca-ethylene.
And the comforter in this case, would that be the comforter that was recovered from Ms. Jade Benning's home?
According to the documentation provided in the literature packet, yes.
And did you learn that on that comforter that Ms. Benning had vomited on that comforter, according to what was told in the facts of this case?
Yes.
And as a result of that, did NMS perform testing on that vomit?
Yes.
And is this a result of the testing that was performed on that vomit?
It's one of them.
And did they find in that vomit coca-ethylene or an indication thereof?
So, yes, if I can, just to help the jury to see what you're looking at besides just a bunch of numbers.
Oh, yeah, the jury needs your help.
Oh, sorry, switch the other way. Sorry. Yes.
Okay.
If you look at line item number 43 and 44, and what I'm looking at to identify this is the 007 number, and if you would show the cover page so that the jury can see where that number comes from.
You can go ahead, Molly.
Okay. So they extracted at the same time controls. So the low control is labeled 003. The case blank, so that would have been based on documentation. It was taken from an area completely away from where the vomit stain was, but of the same material in which they were extracting for this case to look at the vomit, and that was listed as 004. And then you have a high control, and that's listed as 005. And then they have a lab blank. So they took another piece of fabric or something from a case unrelated completely to this case and extracted it in the same manner. And that was listed as 006. And then 007 is the case sample. So that would be where the vomit would be taken from the stain and where the vomit is to believed. And so that is how I then correlate looking at the data. Where we see the 007 1G1. The 1G1, all that is showing is the extraction vial that had been labeled so they can go back to their reports and such. And then the 1+99 is the 100 times dilution. And then the one below it, the 1+9, is the times 10 dilution from the original extracted liquid that they pulled off of a material.
Sorry, I'm trying to get a word in. Anna Carlson, thank you for being a member for 3 years. Oh my word, thank you for your support. You said, I've been a member for 3 years from Letitia's trial to this one. Hey, we might have to redo that Letitia one, hey? Probably. Oh no. Also, defense, I don't think this is none of this today. Their case has not been effective. Before they started their case, I was a little on the fence. I thought they poked some good holes in the state's case. And I'm like, I don't know if this guy's going to be found guilty, but you know what? You know what? If this is your case, defense, yeah, no, he's guilty. Very, very guilty. Okay. He's going down.
And if you look under where it says nanograms per mil, where you see the 2.8, 2.6, we see that there's actually some values there. And if we scroll all the way to
hey,
the far
state,
right,
can you object? Hello.
this one
state.
actually has the ion ratios in, and if at the top it'll say ion ratios out, yes means that they're out, and then if it says no, it means that they're in. So
do you see that there?
yeah, so if we down a little bit, up, and then we want to look at the 1.9.
Let me scroll.
Yes, there we go. You can just see all the no's on the side.
Okay.
So
and you said the 1.9?
The 1+9, so vial item 43, go up a little bit. Up.
And state, go ahead.
So the 05 is that.
Question the credibility of this witness. Ask how much she was paid. Go for it. You know? They haven't asked it with any of the witnesses so far. Grueler.
Is showing you that high calibrator. So they ran a calibrator at the same time as they ran the case sample to make sure that their calibrator is still reporting and responding the way they intended it to respond when they did the original extraction at the very beginning. So that's just the checks and balance for them.
Okay. And so is the ion ratio that we talked about before, is that present in this particular test?
Yes.
Okay. And what does that tell you that is different than what the other test told you?
That this one would have been reported had it been above that LOQ or LOD. This is a reportable value.
And this was in fact found in the vomit of Miss Benning on the evening of 2/25/23.
It was found on the comforter.
Thank you. Was there anything else of value that was found on the comforter from Miss Benning?
That was found on the comforter?
In the vomit, yes.
No, I think that was it. That it was there, but it's below the reportable limit, and so it wasn't reported.
Mm-hmm. 8Leon404 said this lady is a total squawk box full of nothing sauce. Now there's some snark for you.
And what exactly would that have been that was there but was not above the reportable limit?
And that would the fentanyl as well. And so
Is this the, you'll look here at the number here?
Yeah. So 007, so that indicates us that that is the case sample. We're not looking at a blank. We're not looking at a QC. And the 1+1 is a dilution of some sort that they're doing. I'm not sure what the dilution is, other than because they had to extract it from a solid material, probably into a water with some steps that they did. And then if you see the two windows on the top where it says fentanyl quant, the two on the left is the deuterated internal standard. So that is something that was put there to know that the instrument is responding correctly and is doing what it's supposed to. The two on the right under fentanyl quant is the sample of the unknown. So if you look at the one that's below it, it's hard to read because it's blurry. It says norfentanyl quant. That second one, how it just has a squiggly line and there's no actual peak there, then that's not there. But if
you give us a minute to see if we can fix it so that it can.
Yes. But you just need to see that those peaks are there. That's what the indication is. If it's not there and it's not indicated, then you would have what you look like there at the norfentanyl. You have to have both transitions for it to say that it is an indication that there is something there.
Okay. And so did you find that there was an indication of fentanyl in the vomit of Ms. Benning?
Yes, and I believe the concentration was very low.
Now, speaking of concentration, as a result of the type of testing that was performed on the vomit, are you able to quantify that vomit?
No.
And why is that?
The method that was used was a detective method, so you can't have the validation that needs to go through to do any kind of method extraction and method development for the instrument. It's a two-part, but they kind of go into one. A validation is at least 16 experiments. It looks at precision, it looks at bias, it looks at extraction recovery, and all of that has to go into how they are able to report at the end of the day based on the reliability and such of the sample. And so if you have a qualitative assay, it is just that. It's present or it's not. You cannot assert any kind of number to it. And in this particular case, you really can't because the curve failed. Meaning you can't take, a curve is created with known concentrations to make a linear line. I like to kind of help you guys have an idea. If you remember, have kiddos that have elementary school and you were given an X and Y and you had two of them you had to find and you had to count across on your X and up to the Y or either way to find it. Think of that line as the calibration curve, and then the unknown is that X or Y that you're trying to track over to it. So if that curve is not successful and does not pass, then anything on that cannot be reliable. And so then you switch it to qualitative, and qualitative is just there. Quantitative is a number. And so it's present or it's not. You cannot put any kind of faith into the numbers that are produced from that report.
And so are you telling the jury that when it comes to the vomit, there was on Ms. Benning's comforter that there was in fact an indication of fentanyl, and there was in fact an indication of cocaethylene?
Quantitatively, yes.
Now, the blood that was taken, as we were discussing previously, in regards to the litigation report 231268889, I asked you whether or not there was a corresponding date and time of blood collection for Ms. Benning. Do you remember that?
Yes, ma'am.
And that was in fact at the hospital for 225 at 2231. Is that correct?
Yes, ma'am.
Did you have an opportunity to look in the medical records to determine whether or not Ms. Benning had been given fentanyl at the hospital prior to that time?
There is notations in the medical records. It says that it was pulled, and then it says it was wasted, and so I'm not clear if it was given or not.
And that's something for more of a medical professional to discuss, but
yes.
I just wanted to know whether or not you had the opportunity to review that.
I did.
Okay. Let's now discuss whether or not, or tell me this, what does it take for you as a toxicologist that works in a laboratory to review records if you were to look over someone's work in order for you to sign your name to it? Can you tell this jury what all that would take?
Objection, Your Honor, to the relevance.
May I respond, Your Honor?
I'll overrule the judge. Go ahead.
So in my experience working in the laboratory, we've had people leave and had to review their work and whatnot. For myself to put my name on a report and take responsibility for that work, I looked specifically at the QCs. I looked at the calibration data or the qualitative data, whatever it is. But I looked at the entire case, and many times I would actually go to the instrument and I would look at the raw data. So there's printed computer data and then there's raw data. Raw data is what is done in the software. That's well above my knowledge. As it comes off the instrument and it computes it into the computer. The reason I specifically would want to go look at that raw data is an analyst can manipulate that data and then it will print, and you don't know in many cases if that data was manipulated or not. So if I'm going to be putting my name on that paper, I want to make sure that that data is true as it is on the computer. I want to look and make sure that the entire batch had consistent results. So when you look at the lit packet does include the calibration and the controls, but we're only getting a snapshot of just this case. In many of these samples, there was hundreds of cases ran at the same time. So if you take a 35 millimeter film strip and you take out one picture, but what happened before or what happened after it, if I'm putting my name to sign out that case, I want to know that everything was before it, there was no problems with the instrument, there was no delays, there was no other issues, and correspondingly after it as well. And so it takes time to go through that data. Even doing this for 10 years, it still takes some time to review all of that.
And did you have an opportunity to look at the litigation packet as it relates to the litigation packet we were speaking of that ended in 889?
I did.
Do you remember how many pages of documents was that litigation packet?
I believe this one was around 1,900 pages.
1,912. Do you remember that specifically?
Yes.
Okay. And in your opinion, in order for an analyst to be able to review 1,912 pages of data, how long would you say that would take?
Just to review the lit packet and not look at the entire batch would take a significant amount of time.
Okay. What would be a significant amount of time?
To tell you, it took...
Man, that was explained already why it took 55 minutes. Oh my word. Really? Does the jury really? Do they really need this? Defend your client, yes, but do they really need this? We've heard this over and over again. Oh my goodness. Stefan said, I think the other doctor stopped listening and he's talking to another patient now. Maybe she's having a nap in the car.
Me almost an entire day just to go through just the lit packet myself and to look at everything and look at the controls, look at the responses, look and see if there's indications in the windows, and look at the entirety of just the lit packet. That's not looking at the entire batch.
And would you believe that you would be able to look at 1,912 pages in a fashion that you could sign off on it as having reviewed it in its entirety in less than 55 minutes?
Me personally, absolutely not.
We know
Do you
you
know
wouldn't.
any-
Oh, sorry, that was too snarky, right? Yeah, we know you wouldn't be able to in 55 minutes because you're not using the same methods as the experts. Okay.
Situation in your experience as a laboratory toxicologist, with all that you know that it requires, any situation where that could be done, based on your opinion?
It would be difficult to do a thorough review before putting a name on the bottom of it and taking true ownership of that data.
Now, let's say
True ownership
that
of that data.
there was another packet that you needed to review, and that packet was over 2,600 pages. Given the same example and having to review both of those packets in less than an hour, would you believe that that would be possible?
Not to review the entire litigation packet and to do a thorough review of it.
Can you tell this jury exactly how many people actually have to perform testing in order for a toxicology report, let's say for 231-26889, the one that's 1,912 pages? How many people perform tests in that litigation packet?
For NMS specifically, because every laboratory is different, NMS specifically, there was, I believe, 4 to 5 people who handled something in the preparatory of that sample. So from my understanding, I don't work at NMS, but from doing review and talking to colleagues that work there, it starts off with one person who receives the package, and then it goes to another person who does an aliquot. So it's a big science word. An aliquot is a sample of the whole. So if you think of a piece of pie and you take your slice of pie out, you've taken an aliquot of pie.
We'd like the pie.
And then
we would like to have a piece of pie. Yes, please. That's my favorite part of this testimony so far. What flavor is it?
Put the rest of it aside. And
No.
So it's easier to maintain and move through. Doing 130 samples in one batch is significant.
I'd prefer the 130 samples of pie, please.
Significant number of tubes you would be having. And then it goes to another person who preps the sample, and then it goes to another person who does the extraction for the sample, and then someone puts it on the instrument, and then someone reviews it coming off the instrument, and then it goes to the review person after that, and then it appears with Dr. Methune to release the report to the customer at the end. So it goes through multiple hands along the way.
I want to show you an example of both of those packets that I just discussed with you about the review.
Okay, Steph's 2 times pause up said, why do I feel like we are just rehashing the same info? I understand the whole point is that they have different points of views, but we've already heard this, and I'm sure the judge is just dying for an objection. Please state. Okay, let me not swear. FFS. Object!
Of those packets. Can you see these packets here, or do I need to move them over there?
I can see them.
Okay. And so...
Okay, now you guys are making me hungry. Stop it! Christy Hayes said, or coconut cream pie. Yes, please. Brenda said, chocolate pie for me. Huh. Sar said, key lime with meringue for me, please. Oh, my word. Britt Black said, apple a la mode. Okay. Italiano also wants pie. Damn, you guys have got... You got some flavors going on here. Jeff Sneaker Arena said, peanut butter silk pie. You see how the defense, you see how it's going? We're all talking about pie now. Yeah. Maria said, I like apple pie. J. McCarthy World said, can we have pumpkin pie? Yes, please. Hokuto Tube said, cherry pie. T. Marozinski, just Rozinski, right? Did I say right? T. Rozinski said, banana cream. Oh my, okay. Yes, please, all of that. 133 samples,
this is
please.
the data that is compiled in 2 of those packets. In your professional opinion, Dr. Giguere, can you review adequately everything that you explained all those individuals who had to run through this testing and perform some of the data that goes along in here. And I'd like to just show the jury and orient them to some of the data that you must review.
Objection, Your Honor. This witness cannot authenticate the data, and I object.
I'm not asking her to authenticate it.
I'm asking that anything be shown to the jury that has not been
Okay,
admitted
you're
as
just asking to show.
I'm just asking a question.
You've already asked that question about the volumes.
Yeah, a million
And so,
times.
this is just an example of all the data that's compiled in those litigation packets. It's not.
It is.
And does a analyst who signs off on this packet to sponsor that all of this information is correct, would they have to review all of this paperwork and data?
In my opinion, yes. Before they put their name on it.
Can you do that in 53 minutes, Dr. Giguere?
Not unless you're a speed reader.
Thank you. I'll pass through.
And maybe they were speed readers. Even though they explained exactly why that was so. Okay, state now, just absolutely grill the cuck out of this lady for a little bit.
Yes, Judge. Because of the circumstances, can I have just 5 minutes?
Okay. If you'll step down the hallway, ladies and gentlemen.
Oh dear. And I think they took way more than 5. They did.
You're wanting General Norman just to speak with Linda.
Yes, Your Honor.
And is that going to be the case, or is she going to need to listen to Dr. Mario Bertolone, Dr. Kelly Larkin, and Dr. Linsey?
I believe that Dr. Carney is our expert that would be for the other 3. It's just Dr. Mifflin with this person. If I could just have a few minutes to speak
For this person.
Okay. All right, we'll take a 5-minute break.
Okay, a little recess and let's go forward. Ready?
Am I talking into the microphone? Okay.
Excuse me?
Am I talking into the microphone loud enough?
Yeah.
No. Judge, why are you lying? Why are you saying yeah? No. We almost got you a freaking megaphone. There was some lady in Switzerland calling Walmart in Tennessee to see if they could organize you a megaphone. The fact that you're asking means that you know that you're not speaking loud enough into that microphone. Okay.
We know.
Okay.
Toxicology, this is Gary.
Dr. Mifflin, can you hear us?
Yes, I can.
Thank you.
All right, let the jury step down.
Everybody stand, please. Jury's coming in. Now, seeing as you're all talking about pie, Stefan helped me out with Swiss pie. But so far, what I've discovered here in Switzerland is something called Voire. Oh, those are so good. It's pie-like. Kind of like milk tart. Huh? It's like a little bit creamy. And then they put like plums or apricots or rhubarb or things like that. Oh my goodness, it's so good. Or here in Switzerland, they have things called tort. And the raspberry tort is so good. It's like a pie with a little grid like that. And they make little ones. And it's got like raspberry jam type stuff in the middle. And then the crumb stuff, the covering, I don't know what you call it, the pastry, there you go, is like nutmeggy. Very nice, very nice. Switzerland's got some really nice, it's the French influence, huh? Pies. Yeah, Stefan says Voire. You see, you guys can look this up if you want. It is very good. If you ever visit Switzerland or you get them there, wherever you are, Voire is the way to go.
Ms. Collins, let's see those
Hi, the Gemini bots. Okay, if you guys don't know why I keep saying that, you know that Google owns YouTube and that Google also owns, you know, Gemini AI, right? And so YouTube now has Gemini monitoring all of YouTube, kind of running the show, which is quite scary for content creators. Just what you won't be able to reason with like a human being if something goes wrong, if something's reported. It's like all AI now. Point being, when I say the AI bots are listening, they're literally, I'm sure you've seen on a live stream, there's like a little, almost like a little star. I love that feature though. You click it and you say summarize the video. Saves me so much time. Some videos I don't need to watch then. Just summarize the damn video. Okay, we move on because I'll read it quickly. You know what I mean? Anyway, so when I say the Gemini bots are listening, that's what I mean, because they're listening to see how to summarize this timestamp if anybody were to ask, what is everyone talking about right now? And if anyone joined our chat now and then they say, what are these people talking about now? You know the answer is going to be pie. They're all talking about flavors of pie. Yeah, I think it's based on the Toxicologist mentioning samples of pie, and we're like, that's where we went. Crochet Mama, welcome back. I'm sure you remember before, right? Okay.
Would they be exhibits?
No, they're already a part of the list. I gave it to Ms. Pendleton.
Yeah, but there was one for the hospital blood. I didn't get that.
Oh. That one was actually the hospital urine, not the blood.
Okay. Y'all have a seat.
What the judge means is sit your asses down. Here is a picture of Voire that you can get in Switzerland. Voire. That's a plum one. You get plum and apple and apricot. Yeah. The Voire is one of the most beloved and versatile baked goods in Switzerland. It's a cheesy, buttery, custardy. It's got a custard type of texture. So there you go. Now you know.
This is the, I didn't show them this. This is the
So you asked her about something, but you don't have that paperwork?
My witness answered my question. You can ask the witness.
All right, so are you needing something or are you ready?
No, you're ready.
Okay.
Sorry, announce your name.
Dr. Giguere.
Dr. Giguere. Okay. Dr. Giguere, do you actually do any lab assessments?
What do you mean by lab assessments?
You know, do you go to other labs and do you perform an assessment of the lab?
Oh, nice.
When I worked at the laboratory, I did the internal auditing of our own laboratory. So yes, I did do assessments. I don't do external assessments.
Okay, so you are not trained in assessing and reviewing another laboratory's standards and processes?
If you're asking if I am been through the ANAB assessor training, I have not.
You have not been through the ANAB assessor training?
I have not.
But you are here testifying about the processes of NMS labs.
Yeah.
I'm testifying to their data, yes.
Okay.
I do like the slow snark. The way the the way the state is like, oh, it's not coming across as like aggressive. It's very nice. It's like, oh, so you don't actually go and visit other labs, do you? Oh, this is quite fun. Okay.
But you are not trained as an ANAB lab assessor, correct?
Correct.
Okay, and did you know that Dr. Midland is trained as an ANAB lab assessor?
No, that's great.
So she actually goes to other labs outside of her own lab, and she audits them for their standards and accreditation. And she has been trained in that. Did you know that?
No, I didn't.
Okay. You referenced that you reviewed the first hospital blood and you were talking about some seals. In your notes that defense counsel provided just before you testified, your notes under the report from Forensic Medical 2312-6889, you list what samples were submitted, and it says blood in parentheses Jade, liver in parentheses Jade, liver in parentheses baby. These are your notes.
Can I see that? Because I don't have a copy of that.
Sure.
Sure, have a look at your chicken scratch. Right here, ma'am. Oh, sorry. Yeah, no, that's great. Sure is.
Okay, and what was your question?
Your outline of notes, you list blood in parentheses Jade, liver in parentheses Jade, liver in parentheses baby, correct?
Yes.
Okay, so those are your notes reviewing these laboratory results, correct?
Yes.
Thank you. So apparently you are not aware that Jade's liver tissue was not submitted for testing, correct?
No. When I made that you're referring to, that was my work product. That was just stuff as I was looking at it, and I didn't know if that was Jade's or if it was the baby's, because there's two listings for the liver. There's the homogenate and then there's the liver. So I didn't know what was what at the time when I made that list. I had since got clarification, and that is an older work product that I had. So that was not updated prior to my testimony for today.
You didn't update it when it was clear that it was only fetal tissue that was submitted. It was documented in multiple different places, but you didn't notice that. Going on to your comforter testimony, which again, you are not trained in any type of assessment for another lab, but would you at least agree with Dr. Mithun that reviewing data from your own lab is a different process than reviewing data from an outside lab? Would
Yes,
you
it
agree
can
with
be.
that? It doesn't take as much time because she is familiar with all of the NMS processes. Do you agree with her on that?
That could be true, yes.
Okay. And Ms. Hollins took all this paperwork and stacked it up. The litigation packet is in no way, shape, or form required or relevant to do a specific case review. Don't you agree?
No, it should be.
Now, you were doing a case review to assist the defense with litigation. Dr. Mithun was looking at testing of a very specific case. She was doing a case review. You don't agree that those are two completely different things?
I think both reviews should be equally the same, because as maybe I am reviewing for the defense, she's reviewing for the prosecution, and it should look at the entire batch and all of the quality controls and all of the standards and all of the paperwork to make sure that there is nothing that was missed within the other people's reviews.
Dr. Giguere, you are very aware that what Dr. Mithun did was a separate forensic analysis. She wasn't doing it for the state. The state made a request that it be done. It is completely different than what you were doing for defense counsel.
We're both reviewing the litigation and reviewing the data to look at the accuracy, the reliability, and the dependability of that data.
Were you in the courtroom when Dr. Mithun testified?
I was.
Okay, and so her explanation for why she did not need to review the litigation packet, you think that's insufficient because you would do it.
Her testimony was she only looked at the case data and she looked at the summary pages. She did not look at the controls, she did not look at the calibration, and she did not look at any of the case blanks that was within that run to assess if there was any carryover issues or any other instrumentation issues. She did look at a very specific part instead of looking at the completeness of the run.
So you must have missed the part where she testified that she had been reviewing the data in the casework for all of the reports since at least October of 2025.
I'm going to object to argument, Your Honor.
Okay, she's asking, do you recall that?
I recall her testifying to that, yes.
And you also said that you were not sure what the dilution level is.
Which one are you referring to? There were several that had dilutions.
On the comforter
Okay.
samples, you're saying you don't know.
I don't know the factors in which they did the dilution. So when I worked in a laboratory, if we ran a dilution, we had to document, we took 5 grams to 15 mils of water to make that dilution, and we recorded that math. So anyone who was reviewing our documents could go back and know what factors and what dilutions we were doing and how we came to get to that dilution. All I have on this is a 1+1. I don't know the amount that it started with, and I don't know how much of the liquid solvent would have been added to it to allow for the dilution to take place.
Okay, well that is what the dilution level is. If it's 1+1, if it's 1+9, it's 10. If it's 1+99, it's 100. And that is what is listed and documented in all of the NMS values.
I don't know the math.
You didn't understand how to interpret and do the math of 1+99.
No, I understood.
Okay, she can ask her question. Go ahead, you were answering.
No, I understand that it was not documented on where they derived to get to the 1+99 or to the 1+1. I don't know where she started from to get to that. So in my laboratory, when we would do, in this case, like the liver, we would take 5 grams of the liver plus 15 mils of water to get a 4 times dilution. That math was not provided for the dilution, so I don't know where it originated from.
So you're saying you don't know that it was a 10 times dilution and a 100 times dilution, that you couldn't interpret that?
That's not what I'm saying.
So what are you saying?
I don't have anything else.
Just briefly.
Brief, okay.
Very I wanted to just clear something up real quickly. If you remember, I asked you originally, were you aware of who the liver belonged to? Do you remember that question?
Yes.
And what did you say?
Originally, I did not.
And why not?
Because of the way it was written on the submission form and the report, it had the same medical examiner number. It was later on that I learned that it may have been maybe marked wrong. It was the liver of the fetus, not of the decedent, as it appears on the report.
I want to show you
Oh, we're sipping from the cup now. No longer the water bottle.
as it is listed here. Does it say who the liver belongs to here?
It does not. In my previous experience working in a medical examiner office, if they come with the same labeled as number, it's from the same person, versus if it would have been the fetus in the laboratory I was in, it would have been given a daughter number or a separate number so that the testing could be separated.
And that is for litigation packet 231268889.
Yes, ma'am.
And did you see anywhere else where the liver was associated with the fetus of Miss Benning?
Only in the autopsy report.
And I apologize, my PowerPoint didn't work earlier, so I didn't have my paperwork, but you had asked me to give you this document so that you could assign the numbers to the vomit on the comforter. Do you remember that?
Yes, and it was to help the jury understand how I was able to look at the data and relate the data that was produced to the corresponding sample that was run at the same time.
And
So,
is this the data that you were speaking of?
yes, so if you see where it says sample ID in the 003, and the next column labeled as low control, and then it has the description of what that control or that item is, that's where I was using that report to look at the data to correspond the data to the appropriate item number.
Okay. And if you were to turn to the next page, because you were citing 007.
Yes, and you see where it's created from the fabric of the area with the visible stains, and it's labeled as the case sample.
Was there anywhere else on the comforter outside of the vomiters where fentanyl was found?
Yes, it was found in the case blank.
And would that be 004?
Yes, and again, the case blank is taken from the comforter, separate away from the stain of which they were testing for the case sample to make sure that the material was responding the same way.
And should fentanyl have any indication on the case blank? Or were they expecting in the test for fentanyl to show up on the case blank, if you know?
I would think no, because it's called a blank, which means it should be negative for any analyte in what you're looking for. It didn't say blank plus fentanyl, so.
Any other questions?
Just briefly.
Okay.
Again, Doctor, you were here when Dr. Minton testified, correct?
Yes, ma'am.
And she testified about fentanyl being found in a very low number across the fabric, and she talked about the fact that that was kind of noise an issue, and it did not mean anything. The level was so low. Do you recall that?
Actually, I think her testimony was that it was present and that it wasn't the noise because she saw both of the peaks in both windows and the ion ratio was in.
And she said there was absolutely none of it in the vomit, but it was something that showed up across the entirety of the fabric. Do you recall that?
I don't. I believe her testimony was that it was...
So my question was, do you recall that? So you're saying you don't recall that that was her testimony?
Not that that was her testimony.
So she already testified about this, but you do agree that when you are looking at any of these levels, and you've talked about different levels without giving a ton of specific information, but it is a multi-point inspection. It is not just saying one value, one peak. You have to look at multiple variables that have to be present before it can be reported out. That's the entirety of the standardization and accreditation process.
Object to counsel testifying? Is there a question?
I asked her if she agreed with that statement.
Go ahead. Do you understand the question?
No.
You don't understand that when you are looking at lab values or a peak, that it is a multi-point inspection. You are looking at multiple variables, and you have to have multiple things present before you can report out that it is a substance that you are finding. That is part of the standards and the accreditation process. If you report it when you don't have multiple variables, that would not be standard process and your lab would not be accredited. Do you agree with that?
I agree that there are multiple facets that need to be met for a analyte to be reported, and that's what the validation process covers. But there are also...
Oh, is YouTube having an outage? Oh.
It also has both transitions.
The camera or the court feed just got stuck for a moment there.
In both windows, and I believe her testimony said that it was present in the vomit.
Well, actually, the standards is part of what's in the litigation packet, which is part of the reason Dr. Minton doesn't need to review it, because she's familiar with the standards of NMS. So you didn't review the standards of NMS laboratories, what you're saying?
They weren't provided in the litigation packet, ma'am.
I don't have anything else.
Okay. Thank you, ma'am. You can
Oh my word, a huge applause. We are done with that. That was the 5th witness, right, for the defense? Yes, that was witness number 5. I think they said on Saturday, right? They said they're going to call maybe 10. They don't know if they call all 10. Janet Murphy says YouTube is sick of this questioning, right?
All right, ladies and gentlemen of the jury, we're going to break for lunch. Just remember what I've said about not discussing the case, forming any opinion, looking things up, all of those admonitions. We'll be back here at 1:50.
Did he say 1:15? 1:15. That sounds almost like 50 to me, but 1:15? Or what is it? It might have actually been, it could be 1:50, 1:50, huh? If it's 1:15, it's right now. That's why I'm asking. We could just teleport right through that. But if it's 1:50, yeah, we got 35 minutes to go. So, all right. Ready to teleport and wait? And this is, we started an hour late on purpose to, you know, teleport like right over, skip over the lunch break. But no, then the defense brought all their nonsense. And the state needed a break. And their expert had to be called on the phone. All that took a lot of time. Yeah, he said 50, didn't he? Damn it. Judge doing a stretch. Everybody stretch.
Okay, and Ms. Hollins, you said the other 3 expert or doctors that are listed here will be testifying, and then what about the other 1, 2, 3, 4, 5 people?
We will have the 3 doctors, Your Honor, and then, we'll have 3 doctors, and then we need to read into the record the deposition of Alyssa Smith. And then also we would have our forensic telephone digital person.
Excuse me?
Our forensic digital person? Who is that?
Our forensic, what now? Oh, digital person. The judge is like, excuse me? See, 5 more. Unfortunately, 3 of those are doctors. Oh no. Are they actually doctors? What kind of doctors are we talking about, huh? Dr. Google? Digital forensics, huh? What you got there?
Eric Devlin.
And you provided a report from Lena Gill. We don't have anything from Eric Devlin.
As soon as he was going to testify to the report from Lena Gill, but
from where?
Lena Gill, but she's not testifying, and so we will provide the report from Mr. Devlin.
You have the report from Lena Gill?
I have a report from Lena Gill.
Okay.
I do not have anything from Eric Devlin.
Well, they're going to have a surrogate witness.
I'm not going to give potentially object, but.
Okay. They're objecting to Mr. Devlin.
Why is that? He was noticed as an expert.
In video surveillance is what we were told.
He's a digital forensic expert, and we provided his CV.
Okay. You're wanting him to testify about what?
The telephone of Miss Bennett.
What telephone?
I'm sorry, Miss Bennett. Miss Bennett's telephone, yes.
Judge, I would ask for a jury out before they submit text messages to be introduced. The ones in the report.
Are you talking about the ones that have already been introduced?
No, these are others.
Crawling to the finish line.
From the time period that we are allowed to reconstruct.
About what?
So the state has put on evidence.
About what?
Yeah.
It will be about Ms. Benning dating other men. It will be about Ms. Benning's involvement with drugs.
Ooh.
And it will be about Ms. Benning's involvement with drugs during her pregnancy.
Oh my word.
Judge, the majority of the report is completely
completely outside of January and February of 2023. They went all the way back to May of 2022 before she had ever even met
Okay.
Mr. Taylor.
So there's an objection about the relevancy, so we'll need to hear
We
from
will
Mr.
stay, will represent to the court that we will stay within the time period from when Ms. Benning met Mr. Taylor until February 25th.
The state has an objection to relevance, and I would ask for a jury out before she is allowed to call a witness,
Okay.
especially based
Have
on
you got
what
the
happened yesterday.
text you're wanting to show Mr. Devlin?
Yes,
Have you given them to the state?
we're adding a few, so based on the state's,
Have you given them to the state? Well, we're adding a few. That doesn't sound like you gave them to the state. So they're like, we're going to do a whole lot of victim blaming. That's what we're going to do. We're totally going to throw this victim under the bus in order to protect our client over here. Okay.
presentation of evidence in their case in chief. We are adding.
So they've got everything but the few you're adding.
Exactly.
Okay. And
Just
how do
like-
you define few?
I'm not sure. I'll check and see where we are in a few minutes.
I mean, 2 or 50?
It will probably be more like 30 to 40, I'm sure. Because they provided us with 30, and then when we got to trial, it was over 100.
Judge, I provided them updates. Mr. Brandon, I communicated. I sent him information.
Okay, you better get them printed out real quickly. So you have the 3 doctors and then Mr. Devlin. Is that it?
And the deposition of Alyssa Smith.
And who is Alyssa Smith?
She was the EMT that worked at Vanderbilt when Ms. Benning arrived at the hospital. She
And
is the
is
one.
that, okay, I got it. Is that not the video?
Oh my word, so I think this defense case will go on, hey, today and tomorrow at least, hey, the whole of tomorrow, I think. Which means Wednesday could be the day for the verdict. Because that could be what? Jury instructions, closing arguments, huh? What do you think? Wednesday or Thursday? Isn't Friday a holiday? Isn't that speculatively why the judge is like, did the Saturday court thing? Anyway.
Okay, you said read into the record.
I wasn't sure how the court did it, so it doesn't matter.
If you have a recording, would just play it on your through a thumb drive.
And then we also have Dr. Bruccoleri.
Judge, before you write, the other doctors, are there any notes?
I thought they provided those in the emails.
They don't have Larkin.
We only have Larkin.
Is that the only person that has notes?
So I did, Dr.
That's just a simple question.
Here we go
I thought
again.
you said you were going to have all of the others provided.
I've been in court, so I don't know the update of where they are.
All the
So
people that keep running in and out the door, did they get them?
if you give me an opportunity to ask them, I will.
Okay, go ahead.
So the 4th of July is on a Saturday, huh? So, but is Friday a holiday too? Because of that, is it? Is that so? Yeah, it's a Saturday, exactly.
I'm not going to wait with this jury here on stuff you haven't provided.
That's right, Judge. Don't waste the
Won't
jury's
come
time.
in.
This won't come
We're
in.
not offering anything into evidence.
Oh my word.
But they're entitled to Jeep's material,
I'm giving it to you.
and that's it?
That's it. That's all I have. She hasn't
That's
sent
it.
me anything.
She who?
Dr. Linsey.
Is she here?
Oh, she is. You know what? There is a article that she sent.
Has your staff asked her if she's got notes?
That's right,
Yes,
Stefan.
they did.
And she doesn't have any?
That's what she provided.
Those are allegedly.
It's like the same issue again. Like the experts they want to bring in, where are their notes or anything? Now we're going through it again. It's like deja vu, oh my word. Stefan said, they said it's a 6-day trial. I want a verdict today.
Okay. So what do you want me to do?
I want you to exclude her as a witness. These are not notes. There's a couple scribbles on a piece of paper.
Okay.
Oh my.
Well,
These
You
are
can
multiple
do your
sections.
Perry Mason moment with her.
Thanks, Judge.
So they have everything that these individuals are going to say that they notated. Is that accurate?
So I don't have their notes. They've given me what they have.
Has your staff gotten everything from these additional 3 people that would be considered notes and or reports?
Your Honor, as far as I know.
I'm not asking you. I'm asking the people that are here being paid to represent Mr. Taylor. Do they have it or not?
I explained to you that I gave them what they gave me. And I have to ask Ms. Lewis, because if I'm in questioning witnesses.
You were going to ask Ms. Lewis.
Well, you stopped her from answering.
I'm not asking her. I'm asking you. Do they have everything that these 3 people have in terms of notes?
Yes, they do. Thank you. You're right.
So they do? Okay,
Yes, they do.
certainly. So if something else comes in, then other than what they've got, you got a problem.
Yeah. Well, we have Devlin, of course.
Excuse me?
We have Devlin with the report. We have that. They don't have to make notes to testify.
Get them the text that you're adding, the few 30 that you've added, so we don't have to delay the jury trial anymore.
Let's recess.
And the judge glides out of the courtroom. Get your cut together, defense. Let's listen in. I'll skip forward now. We're just listening in if there's any hot mic moments here. Could be interesting. Pernille, if you hear something interesting, let us know. Like this audio is still going. What we serving for lunch? Hot mic.
Right. Blind testing. That's what Karen was like. I didn't know. It was just a liver sample. She was like, I found out after when Dr. Carney called me about the results. Right. So there's a Tom over here, Dr. Carney.
Deanna B says, fast forward please. To what? Half an hour of silence, of staring at the wall? That's all. We're going to have to wait for half an hour. So we might as well listen to the hot mic, okay?
It was in the email you sent that said, I don't think they printed this out with you. she just handed me stuff and it's definitely not
It was so hard to beat because nothing had headers, nothing was organized.
Stop it, I feel naughty, you guys. This feels naughty. Look, they're streaming it. I don't know what to say. We're just listening and making sure we don't miss any of the, testimony. Okay, keep going.
She wasn't like just great there.
You're all tired.
It's still on audio right now. That's not fair. I think that needs to be said.
Oh dear.
I was going to see more quickly. I'm glad I did. 30 more text messages.
Jenny Lynn said eavesdropping never feels good, but it's public record. That's right. And we are here to observe public record. If it's on the record, we're going to listen to it. Might be important. I think they might be done now. Not yet.
Let me look at my Why are you still recording us?
Camera person, huh? Oh. Why are you still recording us, huh? Because he's a Grizzly and he knows this is important. Okay? It's public record. Yeah, but that's not fair. Why are you recording us? Because Grizzlies want to know. There's some lady in Switzerland there and she's got a stream there. There's over 5,000 Grizzlies that are really interested in what you have to say. So I showed the seal and then I just kept the mic on. Thank you, sir. We appreciate it so much. Thank you very much, sir. Okay, let's go forward. And as usual, so that there's no weird like skipping later or something, let me just refresh the feed entirely. Oh dear. Interesting. All right, so now, what is the time now? It is currently 1:34 p.m. in Tennessee. We've caught up. We've skipped over as much lunch as we possibly could. So we have like 15 minutes. Yeah. 15 minutes together to discuss the case or whatever you want. Do you have any questions at this point? Did something change for you? Meaning, do you think he's guilty? Do you think he's not guilty? What do you think the jury's gonna think? I know we could do a poll. We did one earlier. I want to wait. We did one literally when the defense case started. We'll do another one later, after the defense is rested, which might be tomorrow at this rate. Right? 3 more doctors, some other deposition of a paramedic that was at the hospital, and the digital forensics person, and they might just bring in some, I don't know what text they're going to bring in. But okay, things to victim blame with. All right. So, Simply Lolly said, hey, State, just please don't tell the judge. We don't want the stream cut. Okie dokie. I mean, we could always chop it out later if we need to, but just for now, just let us keep streaming. That was public record. Okay, Hillary in South Carolina said guilty. Dinah B says not guilty. Sarah said no one else has a stronger motive but him. Guilty. Oh, so many people. Maybe we do need a poll. Okay, wait. I'll do one now and we'll do one later. How about that? Okay, hold on. Poll. Start a poll. I'm going to say, what would your vote be? Vote B. Based on the state's case, okay? Based on everything you've heard. Guilty or not guilty. That's it. Those are your options, okay? That's it. Choose. You must choose. Oh, man, that judge. Mrs. Adelson, you are no different to any other criminal defendant at a trial. And you must choose. That was some of the best, right? That was the Donna Adelson trial, in case you don't know what I'm referring to. That was a good trial. Oh, my word. Okay. 80's mom said Jade's own words and ex-girlfriend testimony. Tell me, yes, if you think this is a good one. We've got the poll going, okay? Now, in the chat, also say, if you think he's guilty, what do you think the most damning evidence is? If you think he's not guilty, why do you think so? You know what I mean? Is there reasonable doubt, and why? Okay. Let us see. So anyway, said if they wanted private consult with each other, they would wait to discuss it in the office. You're like, leave the room and go to lunch. What are you doing discussing it in there? We want to listen. Hoskins Bunch said, as a Nashville native, the way this case has been handled has almost been embarrassing. If he gets convicted and appeals, I'm afraid he'll get a new trial. Oh man, will we have to do it again? Oh, can you imagine? Can you imagine? You said so sad for Jade's family. Okay, Midnight Blue said Grizzly polls are usually correct. Well, we're an international mock jury, you know. Ooh, look at that. What would your vote be? 89% so far say guilty. And then there's that 11% that says not guilty. Ooh. So that means it could be a hung jury. Could be, depending on what the defense is still to present. Will they weaken their case? I don't know. Will they make it worse for themselves? And the closing arguments, even though I know closing arguments are not evidence, it does help when they summarize everything, give a timeline, do all of that, right? Stefan said, the phone call, what did you put in my drink? LWAP. Right? Because if it's like, if the phone call to the friend said, I don't know, just another question. The point is, what did you put in my drink? I knew it tasted funny. You did this because you didn't want the baby. Whoa. And then they actually, based on the forensic toxicologist reports, all the testing they did, everything, said that the substance was ingested and in a drink. Oh, wow. Yeah, okay. Well, it would have been orally ingested. That's what they said, right? Stephanie Brown said her best friend's testimony was so damning in the corroborating phone call. Nikki Lewis said, where did he get the C from? The state has not answered all the questions. Yeah, you know, the thing is, the state, sometimes, they don't answer all the questions, right? Like the Matthew Paul trial. That one was dicey. But, he was convicted. I think there is enough circumstantial evidence to convict this man, Blaise Taylor. I think there is. And especially since his ex-girlfriend, took the stand and brought in that testimony about him wanting to put abortion pills in another girlfriend's drink. Ooh, that you add that with the friend's testimony. Wow. Baby Kisser said the amount of cola. So you think he's guilty because of the sheer amount of the substance, right? Thank you so much for your sticker. Okay, let's see if it's shifted. Ooh, 90% guilty, 10% not guilty. Okay. Yorkie servant said Najaya and Apple, those two testimonies. Honor, XOXO, said the fact that he never even mentioned the phone call to police is suspicious alone. And the fact that she was found lying face down, face down, so like on her stomach when he knew she was pregnant. So he didn't help her at all. You know what else? That the call, he hung up. When she called her friend, he hung up on the call. And then when they spoke later, he said, I'm going to call 911. That's weird. Instead of saying, I don't know what's going on with her. Can you help? Can you call 911? What must I do? And he called his dad first. I must get my list out again. Okay, I've got my list here. I've actually got it right in front of me here. What we all want to know was there a paternity test done? We now know that why there was no camera footage from Jade's apartment is because she didn't have an active or current subscription. So that's why. There was only a live feed. But the camera was moved, and that's interesting. And also his cell phone evidence, where the hell are those devices? They had things from the iCloud account, but the devices connected to that iCloud account, they don't have that. So that, to me, is also interesting that he moved out of state and changed all his devices. And where are those? Did he burn them? Did he get rid of them? What did he do with them? Because they didn't trace them. They didn't find them. Scott, 88, SH, said, all that summing up makes him so guilty. So what I have scribbled here is that he cut all connection when Jade got pregnant. And he said, like, really, he wanted nothing to do with it. He wanted to have her to have an abortion. She said she's not going to. He cut contact. And then he reconnected after New Year. So like, Happy New Year, let's get to know each other. That could imply, you have to put this all together, but that could imply premeditation, just like with other girlfriends. Because so far the pattern is he doesn't have any children. Every girlfriend that he got pregnant, he wanted them to have an abortion. He even had the ex-girlfriend that testified, Apple Denny. He had her book an appointment for another girlfriend that was pregnant. She herself got an abortion. She booked an appointment for the other girlfriend to get one, and that other girlfriend eventually went. Huh? That's quite hectic. Jenny Lynn said, manipulation tactics to talk her out of the pregnancy. No recent drug use. Bestie's phone call, not taking action the moment she said she couldn't feel her legs. Right? And when she said, you're scaring me, and he's like, you're scaring me. Okay, also the missing cup. Interesting. Very interesting. But damn, the police did not do a good job on this case. That lead detective is like, there was an email chain, and I didn't know that I could have access to all the surveillance until it was too late and everything was recorded over. We were like, okay, so reconnecting, then date night. For him to consent to date night and the paintings for the nursery and all that, when really he's in love with some other lady, Xavier. He's saying to her, we need to be together, please, like I want to be with you and everything. He wouldn't want her to find out about this, but there he is at date night. You know what I mean? And put that with the timeline of Jade's mother saying that Jade was going to go public with a pregnancy on her 25th birthday, which was on March 6th. Days away, a week away, that she was poisoned on February 25th of 2023. Ooh, that's hectic. Okay, here's another one. I've got all the red flags here for you. This is what I would say would lead the jury to vote guilty. Reconnecting with her, the date night, then the painting, and him being like, I would have painted a dark hole. Dude, oh my word, okay. Him saying to Dispatch that she's having an allergic reaction. Him telling his mother that Jade died from COVID. What? Okay. Him referring to Jade as his girlfriend, where Najaya said that she'd never heard that before. Like, why is he suddenly saying girlfriend? Okay. The camera was moved to the bedroom facing outwards. Okay, that's weird. However that happened, freaking weird. The friend then moved it back in case, she said, and that depends if the jury believes her or not, right? It's up to them. She said she moved it back to the kitchen so it could point to the front door in case he came back in and then, I don't know, try to clean up or do something. She was found unresponsive on her face. So that means he didn't even turn her over. He didn't try to help her. And yet when the paramedics were there, he tried to interfere. Then he's trying to interfere. And they were like, he was in our way the whole time. Like, don't touch her, sir. Like, get out of our way. Okay, the cup was washed. There was a cup that was on the table in Jade's photos. It was found next to the sink and washed with no evidence on it. His devices connected to his iCloud account gone. He moved to Utah with that woman that he was so in love with, the one that he actually previously asked to get an abortion, which he did. But so that's from dating from like 2015. But he was with Xavier in Utah. Moved out of state to be with her. That shows some motive. Then we've also got the substance being liquid and the timeline of how fast that would react. And we have the timestamps of Jade taking photos, a series of photos, right, with her phone locked, but then swiping the camera, right, and then taking a lot of photos, and the final one being marked for deletion, and then within seconds her phoning Dozier, and Dozier overhearing her saying, "What did you do? What did you put in my drink? I knew my drink tasted funny. You did this because you didn't want the baby." And then her speech suddenly slurred. She could actually not, they couldn't make out what she was saying after that. And then she was found unresponsive just 20 minutes later. That timeline of how fast the substance reacted is interesting. And he was the only one with her at the apartment. Then, of course, Jade's call, yes, to Dozier, that's like very strong evidence for the jury to consider. The timing of the reaction, the photos, and then Apple and Xavier, that he wanted them to have abortions too, and everybody wanted them. Also that he went to work and was acting like nothing was wrong. Like it wasn't even, he didn't even say anything, not that he didn't actually share personal things with his colleagues, so that might not count for anything. But still, he didn't like book off, he wasn't so distraught that he couldn't work, he just carried on with his life, you know what I mean? And then packed up and moved to Utah. Okay, so that is what we have. Now, add to it, if I missed something, please add to it. Let me just quickly see the time. Yeah, they're coming back in like 3 minutes. Okay, let's see. Okay. Missy J. have said the closing arguments will piece the entire puzzle together. Jenny Lynn said there's a lot of circumstantial evidence, and for me, that's enough. All right. Let's see. Desert Dwellers Glisten lol said, and that awful painting that looks like an empty sonogram, but it's supposed to be for the baby's room. Right? Okay. West London, yeah, he was saying that she ate something bad, right? That she ate bad food. I mean, sir, she is a chef, okay? People literally stopped by to get her food because it was so damn good. Bad food? Allergic reaction? I don't think so. Okay, let's quickly see. I'm just looking, yeah. West London said bullet points. Angela 2K1 said, I still don't think he meant to actually kill Jade, just Ivy, sadly. I agree with Stefan on that one, that I do think he probably tried to... I understand that he could be stupid and didn't know it's going to be like that. Like, oh crap, I thought she's just going to have an abortion. Like, what's going on now? You're scaring me. Because maybe he didn't quite calculate that. However, I think because he's done his homework about what to put in someone's drink to cause an abortion, I think he did some Googling. I think he definitely did his homework before... I'm speculating here. In my opinion, I think he did his homework before doing what he did. And he may have even arrived, yes, with that cup. Maybe it was a smoothie. Maybe it was from a juice bar. Maybe he arrived with something in his pocket, like a little liquid something, you know what I mean, to put in the drink. Maybe when she went to the bathroom, he found his moment. And I also think, so I do think he intended to kill both, because if he had caused an abortion and she knew that her drink tasted funny, can you imagine? Oh, can you imagine? He'd be in trouble anyway. So, I think, though, he did not anticipate that she's going to call her friend. That threw it all off for him. I think he would have just left her there and left the apartment and then been like, what? I don't know, she was fine. She was absolutely fine when I was there. That's probably what his plan was, allegedly. Okay. Now, Samantha Fernandez said, guilty the phone call, having the ex call to schedule the abortion. I'm a little nervous. They made a lot of mistakes in the investigation, but I think the evidence will hopefully outweigh it. Yeah. I think it could. I really think it could. Joe Hoffman said a timeline in closing would really help. It really would. I really hope the state focuses on a timeline. It will help a lot, right? Okay. Now, I do understand people that have doubt, right? People that have doubt wonder, why did they look at the friends, right? I understand. They look at the friends and they say, well, why did they want to come over anyway? Why that night? Why when she was having date night? Why would they come over? For food. She was a chef and her food was so good and they were just like making Alfredo and it's like, can we come over? Can we get a plate? So they came over, got a plate and left within half an hour. But I know that some people think, what if the friend brought, let's say, the juice with something in it? But now, why would the friend do that? Why would the friend do that? Some people think, based on the comments I read, some people think that the friend, the best friend of Jaya, right, was, I don't know what, jealous or something. I have no idea. Because she said that she wanted to be the dad of the baby. She wanted to move in with Jade, and then Jade ghosted her. And that she went ahead and got her own apartment, 2-bedroom. So, I've even seen comments where people say maybe the drink was dropped off by the friend and intended for Blaise. Oh my word, can you imagine? Plot twist. Wait, what? So, who knows? But I think if we follow the common sense, even though there could be some doubt, I think everything points at Blaise, especially with his own damn behavior, like that, saying allergic reaction and then telling his mom she died of COVID. That's weird. That alone could maybe sink you, dude, because it's so weird. Why would you do that? Why would you tell your mom she died of COVID? Strange. And I do wonder, did he go to her memorial service? I don't think so, but did he? Was he in the hospital any other days besides that first day? I don't think so. I think not, because they said family wasn't allowed. Non-family wasn't allowed, right? Okay. So, a lot of cases are resulting convictions based on circumstantial evidence. Most, actually. Rarely is there the smoking gun. However, in this case, Najaya's testimony and that call that Jade made, she could have solved her own case, right? Okay, let's quickly see the poll results. Look at the camera shaking. What would your vote be? Okay, now 89% say guilty and 11% say not guilty. Only 1,254 people have voted. I don't know. I know some people can't see it on certain devices or on your TV or whatever. But if you can vote, vote. Melina, I hope I answered that question for you. You said if not him, then who? I think I answered that one, right? Thank you so much for your sticker. Hokototu said, for me, the best powerful witness is her best friend's testimony. Let me see if that, yeah, look at this picture that Grizzly Cat found for us. Look at this picture of Jade with her best friend Najaya. It's such a beautiful picture. Look at this one. Wait, I'm moving it. Sorry. There you go. There you go. Jennifer said, and her bestie wanted to meet Blaise, so I don't think it's weird. Joanne says, no way her friend did it. No way. I think if you really had to say, shame, which just feels horrible, but was it the friend or was it Blaise Taylor? Let's say if it comes down to those two. There's so much pointing at him, right? I think he's going to win the Al-Wap Tartar served to him with truffle oil, if you had to compare, because what he did, the allergic reaction, and then the 911 call by calling his dad first, and then interfering with the paramedics, and then telling his mother she died of COVID is so weird, so strange. Okay, so I'm gonna put this picture right here. We're almost through the lunch break, and we're ready for that afternoon session. Stefan said the phone call is direct evidence, like an eyewitness, and so powerful. And imagine if it went to voicemail, then it would have been recorded. I'm glad that Najaya answered, right? Someone said in chat yesterday, it's a pity that she answered. It's like not her fault, but it's a pity she answered. Otherwise, it would have been a voicemail. But I'm like, damn, can you imagine that would have been a voicemail, right? Then they would have had that. But either way, they have it through what Najaya said, but some people doubt it because they say it's just her testimony. How does anyone know? Well, you can see the timestamps of the call being about 6 minutes long, right? But do we actually know what was said? No, there's no actual solid proof of that besides Najaya's testimony. Okay. That is a good question. Now I can't remember either. Who did? Debbie in Indiana said, who testified that he said that to his mom? I can't remember. I don't remember either now. Was it in opening statements? Could have been an opening statement. Did someone testify to that? I can't remember. That feels like weeks ago at this point. Kathy Luna said, I take pain meds. Within 15 to 20 minutes, I start to feel them. Okay. Thank you, Kathy Luna, for your sticker. All right, so they're coming back from lunch any minute now. It's 1:55 p.m. 1:55 p.m. Butterfly Girl 822 said, only mention food, not a drink, which is how it was consumed. The defense saying that she infused her food with mushrooms. but they imply psychedelic ones, right? And MJ, and I'm like, okay, so you think she like stirred in some cocoa into the Alfredo? Oh man. Smofio, I don't know how to say it. You said, anyone thought about the best friend's guy friend jealous of their close friendship? I mean, that doesn't make any sense to me, right? I don't think Keontae, I don't think they would be, I don't even know what the defense was trying to do. I do not think that he's got anything to do with this. Rome Withy Abrego said, I think best friend was trying to protect Jade's heart because they both knew Blaise was not going to be a part of Jade's or baby's life, right? Kimberlea said, and it cuts both ways. If she's so familiar with drugs like the defense is saying, then wouldn't she know the amount and not put that much, right? Thank you so much, W. Bone, for the 3 Big Bear coffees for the mods. Thank you so much for spoiling the mods. Oh, he's going to get a fright. If he's found guilty, which he just might be, and he is sentenced to either life with the possibility of parole after serving 51 years, and maybe the judge does like for both, you know, because you've got 2 counts of first-degree murder, 2 counts of felony murder. The judge could say consecutive. Whoa. Okay, so if he is at any point eligible for parole, it should be, according to these charges, Tennessee law, it would be 51 years. Or he could get life without parole. He's going to get the biggest fright of his life. I think so will his mother, who's been in the courtroom there every day, right? So it does sound like he's not going to testify, even just based on how the defense said the witnesses they have left. Could they just hurry it up, please? Thank you so much. We're kind of ready now. We're ready for the finish line. Hokuto Tube said, we won't finish today unless the judge goes overtime. And we know he likes to do that. Sure, this judge. It's been a very tiring trial for me, especially because of my time zone, you know what I mean? When the judge goes to like 6 or 7 Tennessee time, I'm like, sir, you have to add 7 hours to that. If it's 7, 8, 9, 10, 11, 12, 1, 2 in the morning. Then I still got to do timestamps and wind down, sir. It's all good though. I love watching trials with you. Are we there yet? Are we there yet? Hello. Jurors, get your ass in here. We are so ready for you to come back. Mary Freyer said he's either guilty or the unluckiest guy in the world. Lacey Lovett said, I wonder how Jade's mother feels about the best friend not calling 911 and calling Keontae instead. Well, I mean, at that point, I don't know. Maybe they really, I mean, they don't know what's going on. Like, why is she talking like that? What is going on? We just saw her. We just saw her like 2 hours ago. Right? Okay. Let's see. Ashley Kane said his own ex-girlfriend and what she went through, and also he showed up out of the blue. She was perfectly fine raising this baby by herself, right? And if so, I think he was so scared that Xavier would find out that he got Jade pregnant. I think he was so scared of that and child support and just this haunting him. Like, oh no, like what if she tries to contact me, or what if anything? He had to. Well, with everyone that he got pregnant, he's like, oh, I have to sort this problem out immediately. Okay. He did not say that he's not taking the stand. They have not asked him yet. He might take the stand. Right now, we don't know. Kim R16 said, we love you, G. Oh, thank you so much. Kerry Lewis RN said, I don't think the judge is biased. I think he snarks to both sides, in my opinion. I also don't think he's biased. I don't know. What do you think? I think he snarks to wherever the snark needs to be, he does it. He dishes it out left and right. Tweezy222 said child support for sure. Yeah, I think he was very nervous of that. And especially of Xavier finding out, because he had Xavier get an abortion. And he had Apple also do so. Maybe others too. And therefore, if Xavier, who he was very, I would say, in love with, based on the messages, based on how long they dated, on and off and all that, If she found out, I think he's like, I can't lose her. I can't lose her. Let me sort this problem out and pack my baggies and go to Utah with her. Oh my word. I wonder what she's thinking now. I was hoping actually the defense would call it. That'd be interesting. Okay, let's see the vote. What would your vote be? 89% guilty, 11% not guilty. Pretty much where we stand. Which, that, if the jury's like that, that could result in a mistrial, because it could be a hung jury. But you never know. We don't know what the jury's going to decide. Some trials surprise one. Jacqueline M2112 said, I don't think the judge is biased, just want to put up with the defense BS. Shelky said yes, snark to both sides. Yeah, the judge said I'm a bottom line kind of guy, and he despises inefficiency, which is what's happening now. Right, look, they're back from lunch, but now what? Grizzly B23, welcome. Karen Thomas said, this judge is the best ever so far. Snarky Southern gentleman. Okay. Did I leave out any red flags, any evidence? I think we pretty much went over them all, huh? You hear the sirens? You hear that? Yeah. Blaise Taylor, that's for you.
Or who is the next witness going?
Alyssa Smith.
Okay.
Judge, we have experts here because they said they were calling experts. That's a deposition that's recorded that can be played at any time.
It is an order that I wanted to go before my next expert.
Well, you said your other person was next.
We would request a jury out regarding Dr. Larkin, as we were provided with
Okay,
notes.
hang on, you're jumping to something else on me now. So you want me to order the defense who to call first?
Your Honor, I'm simply asking that we have a jury out about this document that we just received.
Let's go back a second.
The judge, wait, go back a second. Peanut Family says, can you make an extra video? Hell no. The state has a job to do. I'm sure they're extremely capable of doing it. And while I say that, if anybody ever decides to email the judge, the DA, anybody in any trial, do not mention me or my channel, okay? Because, oh my word, sometimes I'm like, I'm gonna hide under the table. Please don't do that. Okay, when they're like, oh my word, Grizzly, I emailed, I've solved the case. No, none of that. Do not bother them, okay? We are here to watch together, to talk to each other. Do not bother them with emails.
You objecting to them playing the deposition at this point?
Yes, because we just asked Dr. Carney to leave her job and come over here to assist us with our defense experts, and they said that's who they would call.
You did say that.
I never said who I was calling that, sure. I said I had experts today that I was calling. We have not stated who we were calling next.
So you want to play the deposition, which is a 50-something minute long.
Yes.
You want her to go, so you want me to order them to do that?
But I mean, 15 minutes isn't a lot, state. It's okay. Let them play the freaking deposition and get the show on the road. Real Happy 33 said he was not a football star for Tennessee Titans. No, he was a scout for the Tennessee Titans. He was a scout. Previously, he played some football, but he was a scout for the Tennessee Titans, and then he moved to Utah.
Judge, I'm simply asking if we could have a jury out so Your Honor can make a determination if Dr. Larkin will be allowed to testify, because we just received a report that we have not had. It has an opinion and a conclusion about the cause of death of Jade Benning.
I haven't even seen that, Your Honor. So if she gave him
Look at the judge.
The report, it's
Wait,
not something
your staff
she gave
said
to me.
they had everything.
That's been emailed. When they said that they emailed that over, that is what they emailed over.
When?
This morning, I don't even know this morning.
She
Let me see
prepared
what
it
you're
for her testimony today.
Is it a report?
Yes.
Yes.
Is it a report?
Let me take a look and I'll let you know.
Okay.
Well, I'd ask the court to make that determination.
received it. I'm sorry.
I gotta get the definition of what a report is first.
Mike?
It was definitely her opinion, but this is not something that we've had in the past. This is something that she formulated for her testimony.
When?
I'm assuming, I would have to ask, probably yesterday.
Okay. Letter, is it a she?
Yes, I'm
Letter
sure it's yesterday.
See if Dr. Kelly Larkin is out there.
No, she's not here yet. She is my last witness. So I was under the assumption that I could call my witnesses in the order that I wanted to.
That's normally the case. I was just trying to help do this jury out here while Dr. Carney was here.
She's not here yet.
So let me have that, make a copy of that. Can Dr. Carney come back? Who is Janice Linsey?
She is a toxicologist.
And who is Dr. Mario Bertolone?
He is a toxicologist medical review officer.
And they're going to be testifying about, someone said, the cause of death?
In regards to Dr. Larkin, yes.
And Dr. Kelly Larkin is...
Or we can rest.
She is an ER doctor, a medical doctor.
Not a forensic pathologist?
No.
And you want to ask her what you just found that out, what her opinion is today, so what are you wanting to ask her?
I want to ask...
What is her opinion?
Her opinion is that this was more in line with a fentanyl overdose and what she's seen in the ER as opposed to a cocaine overdose.
What in the hell, defense? You're gonna dispute everything that we've heard from the forensic toxicologist? That's it? You know what she said? It's more a fent OD than anything else. Okay, but if so, what kind? Because we know that she got the medical grade fent at the hospital. We know this already. That wasn't an OD. Moving on. If it was the street type, then okay, we're still looking at Blaise, because then he is the one alleged to have put the cocoa in the drink, which could have the F in it. Please, Judge, just deny it all.
Based on levels of fentanyl that are not reported?
No, based on the symptoms that were explained.
Symptoms.
Come on. Come on. You can't just base it on the symptoms that were described. There was further testing by forensic toxicologists, a panel of them. You can't just get some jackass up there saying, well, based on what I heard that was said on the call with the timing of the speech being slurred, I think, you know what I think? It's more... What? What do you think? There were tests.
Okay, so back to my question, whether Dr. Carney is available prior to Dr. Larkin testifying, if she does.
Judge, are you asking if she's available tomorrow based on...
No, we're going to finish today. I'm talking about today.
Oh. Did you hear the judge? Oh my, Judge. You don't know that. You don't, do you know, have you met the defense? The judge is like, oh, we're going to finish today. No, we're not. Sir, I got some news for you. No, we're not. Unless you're going to go until 2 a.m. Tennessee time.
She will move things to be here.
Okay. All right. Well, I guess We've got an hour-long deposition.
Oh,
Where
man.
the
Again, I hoped I heard wrong. I hope that when they said 50 minutes, I hope 15. 50-minute deposition. They're just going to play that? They're just going to play that? Oh, man.
few extra text messages that you're wanting to introduce to the phone. Do you have a copy of those?
Yeah, they're putting it on a thumb drive now.
It's where?
They're putting it on a thumb drive. So
I'm talking about copies, hard copies that I can look at and see if they're relevant.
we don't have a printer here, so we would have to go back to
We
the
don't have a
schools
printer
office.
here.
We do, but it's not paper. So we don't have paper here. So we have to go to Ms. Riddle's office. This is
Here,
not our
there's
office.
just some paper right there. So get,
No, that's not. Thank you.
no, it's just 30. So get those printed out now, delivered in here to me, so I can look at them, so we don't waste more time. So we've got potentially, I don't know, I guess Dr. Carney, she can be available for 4 o'clock or something. I don't know. Okay.
My goodness. The defense. Okay, defense, you're up there. You're in the rankings there
And
for
on the
defense attorneys with the most stamina.
deposition, the court reporter made me aware that there's an objection on page 28 about an exhibit, but then there's nothing else. The testimony just goes on without an issue. Is that accurate from the state's perspective?
I've not looked at that in a while. I do remember I objected one time, and I don't feel like it was worth rejecting it.
Okay.
That was your question.
Have you reviewed some record before your testimony when it just went on? So that's, I don't need to make a ruling on that.
It's not my it's my understanding you do not.
Okay.
I don't know if the defense was asking for that.
We're not.
Okay, let the jury step down. Yeah. go
Just
ahead.
to clarify for Dr. Carney's schedule, Dr. Larkin will be here at 4 o'clock, and we're doing that at 4 o'clock.
I'm just guessing. I don't know how long or how many the text messages will come in with Mr. Devlin. I don't know how long Bartholomew or Linsey will take. I don't know. Are they here?
Tell them, defense, tell them.
Dr. Larkin is our last witness.
And where is she?
But defense attorney, Ms. Quinones, you know that it's going to take long for all of them. You know how many questions you have. Just tell the judge, we ain't finishing today. I'm letting you know right now, we're taking today and most of tomorrow. And then the state will have rebuttal witnesses. Okay, then we can maybe call it a day. Wednesday could be closing arguments and a little bit of deliberations, which I think could go on for a while. Right? We shall see.
She should be here 20 minutes or so, maybe by 3. But she's our last witness.
So maybe it's 5 o'clock. I don't know.
Judge, these are the messages they gave me previously, and they said they have 30 more. Just for
Actually, it's
reference.
not. It's probably shorter than that.
Can you get me someone on your
They're bringing it now.
staff? Give me what you're trying to introduce through Mr. Devlin. Can they get that?
They're getting it now.
Okay.
Judge, before the jury comes in with respect to the witness, Dr. San Bartolome, this morning we discussed notes, anything, information, like we were advised, the court's hearing that everything had been sent, and at 1:52 this afternoon, we received yet another packet of notes.
So,
Dr. San Bartolome.
once we were finished, yes, they
With
were
your
wrong.
staff
They were wrong.
Let
And
me
once
see
we were
what he's
finished,
got there.
I went and I spoke with all of my experts, and out of abundance of caution, I asked them to turn over everything they had. I was following what the state had been doing. So I
We're
didn't
not
know
worried
that this
about what
was
the
something.
state's been doing. We're here to what you're doing.
Well, I have to follow the leader over here, so. if
No, you have to
they're
follow
going
the rules.
They do too, Your Honor. It
Well,
should not
then
be
let me know
one-sided.
if you think they haven't.
I mean, the defense is saying that she's trying to follow the same standard that has been set for the state. Okay, I can get on board with that. But at the same time, I also understand the judge's snark. Teresa Palomi said, "Hi, G, what a case. I can't stay. I'll watch later on replay. Just stopping in to say hi to you and the Grizzlies." Well, hello there. Thank you for your support for 13 months. There is so much uncertainty in this case, it keeps me gripped. I don't know what's going to happen.
I'm sure the court would know that her team had it apparently at 10:03 a.m.
Have you seen this, Ms. Holland?
No, I haven't. That's not my witness. Can I see it?
It's not what?
Is that Bartholomew? That's not my witness, so no, I haven't. But I'm sure Mr. Joyner may have.
Bartholomew is not your witness?
No, he's Mr. Joyner's witness.
Okay, I thought you were speaking for everybody. Has anybody to the west side of me, to my right, in a southwesterly direction, including the individuals seated at defense counsel table, had this?
No, I'm not entirely sure what that is, but I did receive the email at 10:03, which I did.
Why didn't Ms. Hollins know that you were, why didn't you pop up and say, hey, wait a minute, whoop, whoop, wait a minute?
I could have, Your Honor. I didn't check my email, unfortunately.
So you didn't get that until when? Or when did you, I know it was sent 10:03, when did you get it?
Probably whenever we was anticipating breaking for lunch, Your Honor, I double checked my email.
Anticipating, when was that?
We came back at 1:50, so it had been around an hour before that.
Okay, so when Ms. Hollins was saying that's it, and confirmed with Ms. Miller or whoever the young lady is, that that's it, you knew it wasn't?
No, sir. I did not know it was.
Oh, I thought you said you had looked at it in anticipation of lunch. Let me see if that. Is the defense anticipating getting into information in this document?
What information specifically are you referencing, Your Honor?
The sensitivity of identifying a woman with a substance abuse use problem is 80 to 88%, and sensitivity is 35 to 37%. I have no idea what that means, but that's what I'm asking about.
It is my understanding that Dr. Mario has treated pregnant women with substance abuse issues. Substance use issues, rather, not abuse, but substance use issues.
So, what does that have to do with this case?
We have a pregnant woman who we believe had substance use issues.
And then he's going to say what?
He's going to opine as in his professional opinion about whether or not being pregnant is a barrier or an automatic stoppage to a person using substances.
Well, everybody in the nation knows that.
It's not like when it comes from an expert, Your Honor.
Judge, this goes back to our previous objection.
So you're wanting, hang on, you're wanting this jury to hear from Mr. Dr. Bertolone that pregnant women should not use drugs, alcohol, or illicit substances?
No, not that, Your Honor. There's been an assertion in the state's case in chief that once Ms. Benning became pregnant, any prior use stopped.
Do you have proof from Dr. Bartholomew that she did?
That she did stop?
No, that she did use.
We believe that she continued to be involved in
Does he know that?
Yes, he's reviewed the records in this case, Your Honor.
What record?
He's reviewed medical records, he's reviewed text messages, he's reviewed...
What medical records show that she was using drugs?
Medical records show the absence of a test while she was pregnant, Your Honor.
Absence of a what?
Testing, drug testing. Actually, there was testimony
Does that mean she used?
No, that does not mean that she used, but she did have propylethylene in her system, which suggests that she could have.
Everybody, they're saying she used too much cocaine.
Yeah, but they were silent on alcohol, Your Honor, and there's propylethylene in her system.
Yeah, and that can be argued for the jury. So what does Dr. Bartholomew have any information directly about Ms. Benning's drug usage?
He has direct information that was derived from the text messages in her phone, that was derived from the medical records, specifically regarding the OB/GYN records, where
they didn't do it, so that's just a non-issue. What else?
For Your Honor, those two things are central to our defensive theory. If the state is willing to allege she could have not taken the substance because she was pregnant.
Yeah, she could have taken a substance.
I know, Your Honor, that's not the argument we made.
Does the state agree she could have taken a substance?
Anything, there's no evidence, there's no proof about that.
Does the state agree that Ms. Benning could have taken a substance?
And this witness would not materially assist the jury?
The answer is yes.
In understanding that.
Okay. All right, we'll have a jury out as to whether he has any relevant information.
Oh, my.
And whether this should have been provided to the state.
Your Honor, I just received a text from Mr. Wiseman in regards to his witness, Dr. Bruccoleri.
Well,
He is asking if it's possible to put his witness on prior to the planning of the deposition. I told him that I would speak with the court. She should be very short. And
that's
so,
up to you. You said it had to be this deposition next.
I just didn't want it to be Dr. Larkin for certain, but I can accommodate
You said
Dr.
you wanted to
Bruccoleri.
put this deposition on next.
I do.
So
I
you
don't
want to
mind
call Dr.
Bruccoleri.
Bruccoleri next or the deposition?
If you'll allow, I will let him know that he can bring her over. She's very
She's
short.
not even here.
No, it seems like he's
Okay,
at
bring the jury down. We'll play this deposition.
Oh, my.
One last thing, do we have anything from Dr. Jancy Linsey?
We just turned it over.
This is unbelievable to watch. Wow, quite a tense situation. Very disorganized, hey? This judge, oh man, he's getting so frustrated.
Is that the notes that you were throwing around?
Those are not even notes. Those are articles that she relies on. It's not jinx material. It's not anything that we are turning over or trying to admit, but out of an abundance of caution, we turned it over. So you have what we had.
So no notes or no reports?
We gave you notes as well.
It doesn't matter what's been said, it could change.
notes?
They're not supposed to be, they are.
But of who? It doesn't say.
They're from Dr. Linsey. That's what you asked for, that's what you have.
That's the jury stepping in.
All right, everybody stand, please. Jury's stepping in. Oh, crap. This is going to be a wild afternoon. And a late one. Got a hot mic again. What is he saying? We've got a hot mic from the state's table, and we've got Blaise speaking to a defense attorney. I didn't get any arugula with my salad for lunch. Now everybody, what we're going to hear now is a 50-minute, we're going to watch a video. I don't know if it's going to sound like we underwater. Deposition of, I believe they said an EMT, a paramedic, speculating about the symptoms rather than what happened after that was like, oh, relying on the evidence, if I heard that right. But 50 minutes nonetheless.
Who's the next witness on behalf of the defendant?
The defense calls Alyssa Smith by deposition.
Okay. All right. Ladies and gentlemen of the jury, the witness, by agreement, their deposition was taken since they were unable to be here this week or some reason that the party's aware that they couldn't be here. So that's going to be played for you, and you can analyze that testimony as you would if the person was here and live and in person.
Yeah, why could they not be there? Thank you, Orange Cat Wrangler. Oh boy, here we go.
Judge, I'm sorry, we had a recording done of this witness. I don't know. I think this is the
What did you say?
That's not how we had the deposition recorded, but if it, I don't know if it's.
That's the court reporter's recording.
Correct. We had somebody from our office that came and videotaped it.
Is this not, okay?
I don't know. I haven't seen this, but I'm sure it'll be fine.
Oh, all right.
Just for the record, this is the deposition of Alyssa Smith related to State versus Blaise Taylor on Friday, April 17th, 2026. Ms. Smith, could you please state your full name for the record?
Yep, Alyssa Smith.
And could you spell your first name for the court reporter?
Alyssa.
Ms. Smith, where are you employed?
Vanderbilt Lifeline.
And you said Vanderbilt Lifeline, is that correct? Can you explain what is Vanderbilt Lifeline?
We provide pre-hospital care across a bunch of different service lines, from events to flight to ground transports.
And what is your position?
I'm a critical care paramedic.
Can you explain what the critical care paramedic does?
We provide life-saving interventions in a pre-hospital setting.
And that pre-hospital setting, can you describe, are you on an ambulance or some type of vehicle, or where are you normally physically working?
In my current role, I could be positioned on an ambulance, or I can just be in a venue. It just kind of depends on my assignment.
And would you ever sometimes be at Vanderbilt University Medical Center?
Working currently, no. We're not working at the hospital.
And how long have you been in that position at Vanderbilt?
In my current role since fall of 2023.
And prior to fall of 2023, what did you do?
I was working in the ER at Vanderbilt Adult.
And what was your position in Vanderbilt's emergency department?
Paramedic.
And can you describe what was your role in patient care when you were a paramedic in the Vanderbilt emergency department?
We were mostly support for the nurses. Anything that they would need, IVs, medications, we would work traumas, anything that would come in. We were just kind of support for the doctors and nurses there.
Okay. And that position is an EMT position, but it's a position at Vanderbilt Hospital. Is that correct?
Yeah, it's a paramedic position.
And so there are other paramedics that would work for National Fire Department with ambulance services. Is that correct?
Mm-hmm.
Okay. And specifically, were you working in that position as an EMT at Vanderbilt Emergency Department in February of 2023?
Yeah, I was working as a paramedic.
And were you working specifically on the night of February 25th, 2023 into the early morning of February 26th?
I was.
And while you were working, were you involved in providing any patient care to patient Jade Benning?
I don't remember.
In preparation for testifying today, did you review records to verify whether or not you were involved in any patient care related to Jade Benning?
Yes.
And were you involved in any way?
Yes.
And specifically, did you ever administer fentanyl to Jade Benning? And did you review records related to whether or not you administered fentanyl to Jade Benning?
Yes.
And in the records, there is an entry from February 25th, 2023 at 23 and 27 hours that indicates that fentanyl was dispensed. Did you review those records?
Yes.
And can you explain what does it mean when a medication is dispensed?
When we are pulling it from the medication dispensing machine in preparation to either have it on hand to give or to give to the patient.
And did you locate in the records whether or not you actually administered that fentanyl that was dispensed at 23 hours and 27 minutes on February 25th of 2023?
No.
And no, you didn't review the records, or no, it wasn't?
It wasn't administered.
Okay, so it was not administered?
No.
Did the records indicate what happened to that fentanyl that was dispensed?
It was wasted.
And can you explain why would it be wasted, and what does that mean?
Yes, on the note on the document, it states that patient condition changed.
And so that fentanyl specifically was not administered to the patient, is that correct?
That's correct.
If I can have just a moment. Thank you, Ms. Smith. I don't have any other questions.
Ms. Smith, good morning.
Good morning.
My name is Letitia Quinones-Hollins, and I'm going to be asking you some questions. If at any time you don't understand anything or feel like I need to rephrase, please let me know, and I'll do my best, okay? I want to talk to you a little bit about your background. Are you from Nashville?
I'm not.
Oh, where are you from?
Arkansas.
Okay. And what part of Arkansas are you from?
Jonesboro.
Very good. When did you come to Nashville? When did you come to Nashville?
Fall of 2021.
Okay. Did you come here to go to school?
Yes.
And what school did you attend?
Nosy College of Art for my bachelor's in photography.
I'm sorry?
Nosy College of Art.
Nosy?
Nosy.
Spell it for me.
N-O-S-S-I.
Oh, Nosy. Okay.
Yeah.
College of Art.
Mm-hmm.
And you got a degree in photography.
Mm-hmm.
Would that be bachelor's?
Mm-hmm.
And what did you do after you graduated? What year was it that you graduated?
May of 2025.
So just last year. Congratulations. How old are you?
Thank you. 26.
26. And so then if we go back to 2023, were you in school then?
Mm-hmm.
You have to speak out loud so she can see.
Sorry.
That's okay. Yes. Okay. And what year were you then?
What age was I?
No, what year of college were you?
Okay. I started in fall of 2021.
Okay. And went straight through. Okay. When you were doing your studies at Nosy College of Arts, did you get any type of training, any medical training there?
From the college, yeah.
Okay. And did you get any type of medical training?
Yes.
And where was that?
Arkansas State University.
Okay. So I'm assuming before you came to Nashville, you were also in school in Jonesboro?
Yes.
At Arkansas State?
Yes.
And what were you studying there?
That's where I obtained my EMT basic and my paramedic license.
How long does it take to get EMT and paramedic license?
EMT is typically a semester, paramedic is typically 12 months straight through.
Does the semester that you take for the EMT go towards the year to become a paramedic as well? So they're separate and apart?
Yes.
And so then that would be a year and a half that you studied in order to become an EMT and a certified paramedic as well?
Yes.
What is the difference between an EMT and a paramedic?
Scope of practice.
Scope of practice. What is the difference in the scopes?
A paramedic is able to treat and do more, interpret 12 leads, start IVs, administer medications.
Things of that nature?
Yes.
And an EMT is only able to do what?
They're typically the driver, and they're there to support their medic and, anything they can help them do during treatment.
Okay, fair enough. They are not allowed to administer medication?
Tennessee is different with advanced EMTs. I was a basic in Arkansas, so I know they're allowed to do some here. I don't know because I was never an advanced.
Okay, sounds good. So as a paramedic, though, you were able to administer medications?
Yes.
What year did you receive your paramedic certification?
2021.
So right before you came to Nashville to start at Linsey?
Yes.
And when you came to Nashville to start at school, I'm assuming you started as a freshman or you had credit already?
I had transfer credits.
Okay. Were you still a freshman?
Yes.
And were you working during that time?
Yes.
Okay. And would that be 2021?
Mm-hmm.
And where were you working?
When I first started school, I was at Emerson Ambulance back home, and then I started working at Hobby Lobby for a little bit to take a break.
One of my favorite places. Okay. And what about when you came to Nashville?
That Hobby Lobby was here in Nashville.
Oh, okay.
Yeah.
How long did you work at Hobby Lobby?
Roughly 5 or 6 months until I started at Vanderbilt.
So we're 3 minutes behind the live feed, meaning I can speed it up slightly to 1.1 speed for now. For now, it might catch up, you know what I mean? Oh my word. This defense. Alright, defense, you win. You got the most stamina and annoyance level of many of the attorneys we've seen.
When did you, so did you have any employment between Hobby Lobby and Vanderbilt? When?
I don't know why the judge didn't say, you can't just play the whole 50-minute thing. You bring what you need to bring. You show the part that you want the jury to see. You know what I mean? You really have to listen to 50 minutes?
Did you start at Vanderbilt?
March of 2022.
And what position did you start off? Paramedic. Paramedic. What department? Would that be emergency?
Yes.
Did you work in any other department at Vanderbilt outside of the emergency department before February 2022?
No.
Okay. So by the time that by the time it's February the 25th of 2023, you have been at Vanderbilt working as a paramedic in the emergency department for almost a year. Is that fair?
Yes.
And I'm assuming you were going to school during the day?
Yes.
And then working at night?
Yes.
What were your hours?
Scott 88SH said at least it's a video, not audio only. That's true. Silver lining, you know what I mean? OMG Becky 50 said the rule of completeness. Damn it! 50 minutes. Instead of putting on the stand, they're showing a 50-minute deposition. If anyone's just joining now, this is a deposition. This is not how the court feed looks today. We're just watching 50 minutes of whatever the defense wants to show here.
If it was I started on night shift from 7P to 7A, and I moved to a mid shift from 3P to 3A at some point. I think I was working mid shift by then.
Okay. So 3 p.m. to
3 a.m.
and I'm assuming you guys work 12-hour shifts. How many days per week were you working 12-hour shifts?
3 to 4.
So it's full-time, and full-time still?
Yes.
Yeah. Could you tell us exactly what your title was from March of 2022 to February of 2023?
Paramedic.
And nothing else in between?
No.
Did you hold any supervisory roles or anything of that nature?
The last 2 months that I was employed in the ER, I became paramedic lead.
Okay.
That's it.
And can you tell me when would the last 2 months be? I know you said
August and September. I left September 24th.
September 24th. So September 2024, that's when you moved to your current position?
2023.
23, yes. Okay. So September 2023 is when you left the emergency room department and came to your current position?
Yes.
And your current position again is?
Critical care medic for Lifeline.
Is that viewed almost as if it's a promotion, if you will? Or it's just like a lateral move?
Lateral transfer.
Okay. In your position as a paramedic in the emergency department back in 2023, February, tell us exactly what your daily, average day responsibilities were.
So I would come to work, clock in, check off all of our equipment throughout the department, look at the board, see what patients we had, get offgoing shift report from offgoing paramedics, and just help wherever the nurses need me and whatever I was told to do.
Don't mind me while I doodle, listen, zone out. Thank you for being here. Stay with me. Don't you go anywhere. We're all in this together. Okay?
When you say check equipment, what type of equipment are we talking about?
Our crash carts, our trauma equipment, all of our cabinets, all of our carts, make sure everything's stocked for the shift.
Okay. And is medication in any of these cabinets or no? So what would be in your carts and cabinets and things of that nature?
IV supplies, I'm trying to think, like bandaging things, basic things.
Almost like support supplies for the nurses and things of that nature. Okay. So you would come to work, you check the equipment, see what patients are there in the emergency room, and then I'm assuming you then wait for someone to give you instruction as to where they would need your support.
Yes.
Who would primarily be the people who would come to you and ask you for support? Would it be the nurses, doctors?
Yes.
Both?
Yes.
Okay. Was there a particular doctor and or nurse that anyone was assigned to?
No.
Could it be anyone?
Yes.
How many, if you know, how many nurses would you say would be on duty at any given time at Vanderbilt's emergency back then?
I do not know.
Okay.
Thank you, Raven Wolfmoon, I think it was. Thank you so much for spoiling the mods. They're gonna need it. You gave them each a coffee, a full one. Thank you so much.
You know how many patients the emergency room department, in terms of rooms, how many rooms of patients do you guys take care?
I don't have an exact number. I know we go up to 38, like physical rooms.
38.
But it could be more. Not 100%.
Yeah, I've seen sometimes where the patients in the hallways. Who would have been your supervisor back then?
As our paramedic supervisor, it would have been Eric Frank.
Eric Frank?
I told Mr. Grizzly, you're on trial duty later. This judge is going late. He's like, how's the trial going? When I went outside, for my stretch break, he's like, how's it going? The judge said, we're finishing today. And that means we're going to be here all night.
Did you guys have more than one supervisor?
For paramedics, no. He was our overall paramedic lead.
So outside of Mr. Frank, everyone was in the same role and position?
Yes.
Were you supervised directly by any doctors and or nurses?
No.
And so you, on February 25th of 2023, I'm assuming based on your prior answer, the only reason you remember that you were working that particular dates because you checked the records.
Yes.
And that makes sense, right? It's 3 years ago. And you're stating that you were on duty there from 3 p.m. to 3 a.m. during that time?
I believe if it was my normal shift, then yes. I don't know exactly what my shift was.
And do you remember at all Ms. Benning coming to the emergency department on that evening?
I do not.
Do you remember which nurse and or doctor that you were working with on that day?
I do not.
Jackie Ferrara said, did the judge say the defense needs to finish the case today? He didn't. Well, he said, we're going to finish today. When they were talking about the order of the witnesses, the judge was like, oh, we're going to finish today. I'm like, Judge, no, you're not. If you've ever met this defense team, you're not. I don't know why you say that unless you want to go all night.
Do you remember whether or not during that time that there were more than 38 patients, or it was pretty hectic during that time, or if it was just a normal call that you remember anything?
I do not.
I should probably just ask you this. Do you remember anything about that day?
I do not.
And trust me, it's fair. That was 3 years ago, so that's fair. Okay. During your position and your daily duties at the emergency department, do you ever have interaction with family members or things of that nature?
Yes.
And what type of interactions would you have with individual patients, family members, and things of that nature?
If they're in a room treatment plan of what we're doing and what's going on and everything.
Would you be the individual that communicates that treatment plan to the family members?
It's typically the MDs, but if we come in and we start doing something, that's when I would explain what's going on.
And when you say that you would explain what was going on, you would explain what?
Like, hey, I'm about to start an IV.
Okay.
Typical things.
Not what the doctors are going to do, just what, this is what I'm going to do.
Correct.
Now, do you have any authority to, on your own, determine what type of medication a patient should receive?
Not in the ER.
Not in the ER.
So how is this testimony useful so far? Please tell me. I'm not hearing it. I'm not snarking at the witness, just the defense strategy. Gina Jamino, I want to say. Gina. It sounds very Italian, eh? Jamino. Thank you so much for your $4.99 sticker. I really appreciate your support.
Okay. Do you have on your own any type of authority as it relates to any type of treatment, not medication, but an IV and or a bandage or anything like that? Can you assess a patient on your own and say, this patient needs an IV or this patient needs a bandage?
I have to obtain orders from the doctor.
I'm sorry?
I have to obtain orders from the doctor.
From the doctors. Can you obtain those type of orders from a nurse?
No.
Only a doctor?
Yes.
And so when you looked at the records for Ms. Benning back on February 25th of 2023, I'm assuming you noticed, like we all, that you had pulled some medication that day. And you said before that you dispensed medication.
Yes.
Tell us again exactly what dispense means in the EMT emergency room department world.
Pulling it from the machine that stocks it, that had where it's stored, just pulling it out of the machine.
Okay. And so if anyone is like me, what do you mean pulling it out of the machine? What does that mean?
We go in, type in the patient's name, type what medicine we need, and like pull it out of the machine, and we have the medication now.
Okay. So I'm assuming then there is some type of machine that houses medication.
Yes.
And that machine, does it house all medications or only controlled substances or things of that nature?
It houses all medications. It's not only controlled substances.
Okay. And so if you are dispensing, which we now know the EMT emergency room department world means pulling it out from the machine that houses the medication for the emergency department, we can assume, can we not, that a doctor, because you said you cannot take orders from a nurse, right, that a doctor had to have told you to do so.
Correct.
Because you otherwise would not get medication out of them.
Correct.
What credentials must you put in order to obtain those medications?
The patient's name and the first 5 letters of the medication you're trying to access.
you have to give any identifying information from you?
Yes.
Okay, tell us what that is.
It's our login, our ID, and our password.
Anything?
Fun bucket. Here's your super sticker. I just see you sent an email to say where to go. Here it is. Sorry, I didn't see that one. You said, any idea why a video of Blaise interfering with first responders wasn't played by the prosecution? That seems like it would be crucial. They didn't have body cam, did they? Did they? They didn't have body cam, right? Is that why? Does anyone know the answer to this? I think it's because they didn't have body cam. But Marie Jubenville said, gee, are you ready for an all-nighter? Always. Do you know me at all? Shame. When I was younger, shame. When friends invite me for sleepovers, they don't know that we're going to be talking until the birds start singing in the morning. They're just like, oh my word, we're still going. Hell yeah. Yes, we want to stay up all night. No problem. Let me just see if I missed any others. No. Well, Mary said if it's not him, he's the unlucky. He is the unluckiest guy in the world. Okay, I think I got all of the others. Thank you so much.
Else besides your ID, your password, the name of the first 5 letters of the name of the patient, and the actual medicine.
It's the first 5 letters of the medication and the name of the full name of the patient.
You have to give the patient's date of birth.
No.
Do you have to put anything in there as it relates to the doctor who gave you the authority? And so we see that on February 25th of 2023 at 23:27, which is 11:27 p.m.
Yes.
That you first pulled midazolam.
Yes.
What is midazolam?
Another name for it is Versed, and it's just a sedative.
A sedative means that it does what to a patient?
It calms them down. We give it for seizures a lot. It just kind of relaxes their muscles.
Okay. Does it put them to sleep?
Patient dependent.
Okay, so it can make you drowsy, but it's not an agent that puts you under.
It can't. It depends on the patient. Everyone handles meds differently.
Okay.
So it depends on the patient.
Well, let me ask you this. If someone wanted to cause someone to go into an unconscious state, would they use midazolam in that type of arena to make that happen?
Yes.
And then we also saw that you also pulled fentanyl.
Yes.
What is...
John Hanks said HIPAA laws don't allow body cam during EMT procedures. I was just thinking of Brennan Banfield because they showed some of it, right? They showed some of him. Some of the paramedics' body cam was shown, but obviously not. The victims were blurred out. So, but yeah, that would be very difficult in this case to do. So, I think that would be why then. Okay.
It's fentanyl.
It is a pain medication.
Is it also used as a sedative?
No.
It is solely for pain.
Yes.
So one can assume then that if you were administering pain medication to a patient, then that patient had to have been in some sort of pain.
Yes.
And how would you know a patient is in pain?
That will tell us.
I noticed, if I could, you reviewed your records when you prepared for today?
Yes.
I want to show you what I'm going to mark as
True Crime Addict said, buckle up, we're all going to my mammogram. Okay, well damn, thank you for taking us with you. And good luck with it, I hope it goes well.
I'm going to mark Take a look at Defendant's Exhibit number 1. Have you ever seen that document?
Yes.
Okay. When did you see that document?
A strip of only what I had done under my name was emailed to me.
Okay. Who was it emailed to you by?
That I do not know.
Okay. Do you, what email would they have emailed it to you?
My work email.
Your parent work email?
Yes.
Are you able to go back and take a look and see who emailed that document to you?
I don't have the ability on my phone.
Not now, but at some point.
Yes.
Okay. Do you remember when it was emailed to you?
No.
Was it this year?
Yes.
Was it in preparation for your testimony today?
Yes.
And you just don't remember who it was? No. Who have you been in contact with in preparation for your testimony today?
My lawyer.
Who is your lawyer?
Let me show you how I'm listening. That's me. That's how I'm listening to this testimony. That's how I'm listening. While we're reading the chat, you guys are keeping me going. Okay. What? Are we supposed to be listening? What? Is this important? Defense? What are you doing? Oh my.
And bills.
Have you been in contact with anyone else?
No. I got the subpoena emailed to me and that was it.
Okay. So then the only person that you've been in contact with as it relates to your testimony here today was your attorney?
Yes.
In these records, you notice that your name was present?
Yes.
Do you also notice where it states ABS override pool?
Yes.
What does that mean?
It means if we have a patient coming in or a patient that needs emergency medication right in that moment, we can go in and override and just pull the medication that we need as told by a doctor.
Okay. Why would you need to override it?
Because they don't have time to go in and put the orders in the computer. Because it's an emergent situation and something's happening that we need those medications.
Okay, so is there another protocol for or dispensing, medication outside of this ABS override that would not require any override?
No.
So in every instance that you want medication, you have to do an ABS override?
Oh, no.
Okay. No. So what would you do if it wasn't an override?
The orders would be put in by the physician and we would go in and be able to pull them.
Okay, so then what you're saying is that the normal protocol is that a doctor would put in orders for medication.
Yes.
And it is because of those orders that you can then go to the machine that houses the medication. Does that machine have a name, by the way?
The Omnicell.
Omnicell? O-M-N-I? S-R-C-E-L-L?
Yes.
So, in a normal procedure or protocol, doctors put in orders into a system. That system somehow communicates to the Omnicell.
Yes.
And allows for you to go in and then put in the patient's name, the first 5 letters of the medication, your ID and password, and the medication is dispensed.
Yes.
But in this instance for Ms. Benning, there were no orders in the system.
Yes.
For the Omnicell to recognize.
Yes.
Because of the emergency situation.
Yes.
And so because of that, you implemented the ABS override pool.
Yes.
Okay. And what exactly is the override pool? What do you have to do there?
We hit, it's a button medication override and the reason, emergency, whatever the reason is for needing it overridden, so that it's all documented.
In that situation, what would the reason have been, if you know?
I don't know the exact reason.
Okay. Would it have been communicated to you?
Speeding it up.
Yes.
Okay. Who would have communicated that to you?
The pharmacist or doctor.
Okay. Is it required for you to put in that reason every time you do an ABS override?
Yes.
Without that, you cannot dispense it.
Correct.
Okay. And so then we can assume that when you did this ADS override pool, there was a reason stated as to why you were able to do that.
Yes.
When you put that reason into the system, are you also inputting the individual who communicated the reason to you?
No.
Just only the reason?
Yes.
Okay. How many doctors?
Gina Tamino said, I've been subscribed to your channel for 6 years. I think you mean 5. I only launched it at the end of June of 2021. Thank you so much. You said there's never been a dull moment with you. Say it with your whole chest, Judge. Please, Judge.
Doctors would you
Thank
say
you so much.
are on duty at any given time during the 3 p.m. to 3 a.m. shift?
I don't have an exact number.
Would it be more than 1?
Yes.
Okay. More than 5?
Yes.
More than 10?
I don't believe so.
Okay. So somewhere between 5 and 10. Yeah. Who would tell you the dosage of the medication?
The doctor.
When the doctor is communicating this information to you in this emergency situation where the orders are not put into the system, are you taking notes or are you just memorizing?
When we pull the medication from the Omnicell, it is the whole vial. So we go and pull the medication, we come back to the doctor and verify the dose before getting it.
Okay. So when the doctor is communicating to you before you go to the Omnicell, you're not taking notes or anything at that time, you're just remembering as you go.
The medication, yes. All I need to know is the medication.
Okay. So because we see in these records that there was a fentanyl pool, there was a midazolam pool, in an override situation, then we can, based on what you just testified here today, assume that there was a doctor who communicated this information to you in terms of what the patient needed.
Yes.
Okay. Now, when you dispense the medication, who administers the medication? Meaning, who gives the patient this medication?
Either myself or a nurse.
Not the doctor?
Typically, no.
Okay. And how is fentanyl and midazolam administered to a patient?
Through an IV.
And just so that we're...
I mean, what is the defense strategy exactly? Yes, they poked holes, but now in their case, what is the strategy? Who are you trying to blame? The hospital? The friends because they didn't go through a metal detector or what? The one friend? What is it? What is your defense actually?
Clear for the sake of the jury. When we're dispensing medication in this setting, that means you're taking it from the Omnicell. When you're administering medication in this setting, you're actually giving it to the patient.
That's correct.
Okay. And so, at some point, based on your testimony, it was determined that this medication would not be given to this patient, correct?
Correct.
Okay. Now, who would have told you that? So someone had to have told you to get the medication, dispense it. Who would have told you not to administer it?
The doctor.
The same person?
Yes.
Is there anyone else who could have given you the authority not to administer that medication?
Yes. Another doctor.
Okay, but it had to be a doctor?
Yes.
Okay. Not the RN?
No.
Or a nurse practitioner?
No.
Okay. And again, as these doctors are communicating to you, you're not taking notes or anything. You're just on the spot. You're moving.
Yes.
Okay. So, it is now determined that you did not administer, the doctor makes the, based on the records, make the determination that you're not going to administer these medications to the doctor. What do you do with those medications?
They are wasted.
Okay. Are they wasted immediately?
Yes.
Okay. And
ABQ777 said to make things a little more interesting, here's some snark bucks. Well, thank you so much. I really appreciate that.
how are they wasted?
We have a system in the Omnicell where we go in and waste it with a witness, and then they are disposed of. And it's called a cactus. It's a drug disposal thing that we sort medication into.
Okay. Is that in the Omnicell as well?
It's beside it, yes.
Right beside it. Is it a separate machine?
Yes.
Okay. And does it require any information on your part in order for you to dispose of the medication into that machine?
Yes.
And what is that machine called?
It's a non-machine. It's just a waste receptacle.
Oh, it's just a waste receptacle.
Yes.
Is that those red things you see with the danger?
A little different.
Okay. Okay. And you said, I'm sorry, medication answer? Are there things you have to put in there? No, it's just, you're putting it in.
Correct, it's documented in the Omnicell.
Okay, so first you document the fact that we are going to waste this medication in the Omnicell.
Correct.
You then go to the receptacle, for lack of a better word, and you actually squirt that medication from the syringe into the receptacle.
Yes.
What do you do with the syringes?
Throw them away.
In the trash or something. Okay. Is there a special place for you to dispose of the syringes?
Yes, we have trash cans and biohazard trash.
Okay. When you dispose of the medication and you're inputting it into the Omnicell, are you also putting the reason that you're disposing?
Yes.
And where are you getting that reason from?
The doctors.
Or are you having to list the doctor's name that told you that?
Judge, are you trying to say something? Say it, Judge. D does graphics. Said, girl, even if she had a drink of alcohol and you put the cocaine, Coca-Cola in that. Sorry, YouTube, I didn't mean it. Does that not mean that he didn't kill her and the baby? Right? That does not mean it. Yeah, exactly. Baby kisses, welcome back.
You stated, I think you said something about the patient changed, and that's how you knew that you disposed of it? How did you know that you disposed of that medication? From Ms. Benning particularly?
Yes, in the report it states that I wasted it, and under the reason it states patient condition changed.
Okay. And what report are you speaking to in that regard?
It's a continuation of this report.
Okay.
Thank
A continuation, you mean medical records?
No, it's all of it's in the medication report.
Okay. On the document Defendant's Exhibit 1 that's in front of you, is that information on this sheet? So there's another document somewhere that states that?
Yes.
But it's not a VUMC medical record?
Yes, it is.
Okay. Would your name be attached to that as well?
Yes.
Have you seen that document?
Yes.
When did you see that document?
It's the same one I was referring to, or I don't know when it was sent to me.
I'm sorry?
That's the one that was emailed to me. I'm not sure exactly when I received it.
In addition to Defendant's Exhibit 1?
I only received a strip that showed my name and like what I did. Okay. I didn't receive anyone else's name. It just showed my name and like my involvement.
Okay. And that, was it a screenshot of the document?
Yes.
So then it would have been attached to it?
Yes.
Who will make it with me to the end of this day? Because we don't even know when it's going to end. See, some people are dropping off. Okay. How many will be left with me? Maybe I'll be alone.
Not the email itself. And what I mean by that is, you know, sometimes you'll receive an email and there's a screenshot within the email.
Oh, yes.
As opposed to an actual document that you have to click on and download to review.
Yes, I believe it was just in the email.
In the email itself. And just so we're clear, because I don't want to confuse that, what you received is different than Defendant's Exhibit 1.
Yes, it's less information. It is only it has these two parts on here and only what I was involved in. It doesn't have, it's not full of all the other medications. It's only what I was involved with.
Fair enough, thank you. And in Defendant's Exhibit 1, is it fair to say that Defendant's Exhibit 1 would be, if you look at just the two strips of where you were involved, would it be fair to say that the information you received is different than what's in those strips shown on Defendant's Exhibit 1 because it doesn't show where the medication was wasted?
Correct.
Because in Defendant's Exhibit 1, we don't see that, right?
Correct.
When we see the statement, do not to must always be secured, what does that mean? If you know.
Oh, is that on here?
Yes, ma'am. For the record, what she says is that on here, she's looking at Defendant's Exhibit 1.
Where on the, oh, there it is. I believe it's referring to not, you can't send it through the tube system in the hospital like we send labs, because it's a controlled substance, so we can't just send it through the hospital. If we were, for some, we would never have a reason to do that, but that's all that means. Okay. Is do not put it in the tube system.
Let's keep those separate and secure.
Yes.
When we see the status as active, what does that mean? On the right-hand side.
I do not know.
When you look at it, it says ordering mode standard. What does that mean?
I also do not know.
You see there where it says at the bottom package, and then it gives a number. Specifically under fentanyl, it says package 0409-9094-12. Do you know what that number pertains to? Fair enough. And finally, when you see frequency from 225.23 and 23.27 until discontinued, what does that mean to you, if anything?
We have approximately 7 minutes left of this crap. Not snarking at the witness in this deposition. Which, by the way, imagine people just joining now and thinking this is what the court feed looks like today. No. This is the defense's crappy exhibit.
I guess to me that's until they decide that we don't need it anymore, or until they discontinue the work.
Okay. And when you say they, you're speaking about the doctors?
Correct.
And to be clear, you would have nothing to do with the decision to administer these medications?
Correct.
Yes, okay. And you would have nothing to do with the amount of medication that is determined that needs to be administered?
Correct.
When you, and if you know the answer to this question, you can answer it if you don't. When you see fentanyl, well, let me back up. If someone was coming in for a potential overdose for any type of drug, would you expect to see fentanyl administered? If you know the answer, if you don't, that's fine.
I do not know the answer to that.
And reason being, because you're not the one who made those determinations, right? So that was an unfair question, I apologize. But what we can say is that we know for certain, based on the records you reviewed, that at 23:27 on February 25th of 2023, although it states that fentanyl was dispensed, you did not, and anyone to your knowledge, administer fentanyl to Ms. Jade Benning.
That's correct.
Because we already know they didn't in the ER and they did in the ICU. Thank you so much, defense, for wasting everybody's time with the same crap we've heard over and over. Thank you so much.
So, Ms. Smith, we're going to, I'm done at this time, but, and this is beyond your purview, but I want to say it on the record. We would like for you to grab that document, that medical record, where it states that you actually disposed of it, so that we can at some point talk to you again about it. And we'll work with the prosecution to that regard, okay? But we do want you to move. Okay? All right, at this time, the prosecution.
Almost there. We're almost there. I think we're at the end of this. Noto37 said, oh, Grizzly had so much faith in the defense last week, and now it's out the window. It sure is. I think it seems to be a bit of a pattern that sometimes when the defense teams are doing fairly well, they actually just don't know when to stop. Less is more. It's a very important lesson for defense attorneys, just from where I'm sitting, the peanut gallery sitting here in Switzerland with I'm not a lawyer, no legal experience like that. Okay, but according to some of these defense witnesses, I might be a lawyer. I may be qualified, you can call me. Anyway, they need to know when to stop. If they had just rested, it would have done better for them there would maybe even be some reasonable doubt on the table, maybe, then this is just going to expedite your client straight into his new 24/7 security, pristine, no truffle oil, Alwop Tartar room. Yeah, you're definitely not helping him out at all. And if they're trying to show the people paying the bills, because it's this private counsel, look, we're working so hard, this is not it. This is not this is not helping at all, right? Stefan said the defense was really good until they started the case. See? That. Sometimes they are so good at like keeping the eye on the target, poking holes in the state's case, and then, shh, the burden's not on you. It's on the state. If the state didn't prove their case, just say the defense rests. It's okay. Or have one witness, one that'll actually matter, one that could make an argument that you think might be like, jurors will think about that. But this is not it, okay? Everybody can read the room and know you're just wasting everybody's time, okay?
And I would just like to say that we're not done necessarily with this witness until we deal with the issue of this record we have not seen.
Okay, here we go.
Okay. Yeah.
That's a Bruccoleri.
And of course there can be no cross-examination because it was a freaking deposition recording.
And I believe, Mrs. Hollins, this is in the medical records, but you mentioned it during the deposition. Do you want this marked as a separate exhibit?
Yes, please.
All right, 360.
I mean, I know sometimes in some cases when the defense just rests, then it's like, oh my word, you didn't even put on one single witness. If I were defense attorney, I would put on one or two, just one or two. But make it quick, make it snappy, make sure that you bring in what you can to, I don't know, try to create the reasonable doubt you're trying to create. But like, don't go all out. Nobody wants it. No one likes it.
Your Honor, I would just bring in my request that
Depending on the case, sorry. Disclaimer, depending on the case.
Dr. Bruccoleri not be asked about any testing that's not admitted as evidence as an exhibit.
Okay. Step up.
Witness number 7 for the defense. Here we go. Make it snappy, defense. 7, 8, 9, 10. 4 to go.
Do you swear the testimony you're about to give to be the truth, so help you God?
Yes.
They've got 10 witnesses. This is number 7. And the judge said they're going to finish today.
Okay.
Good afternoon, Dr. Bruccoleri. How are you?
I'm doing all right.
Bruccoleri, I'm sorry. Can you please state your name and spell it for the record?
Sure, it's Dr. Rebecca Bruccoleri, Rebecca Bruccoleri.
And how are you employed, Dr. Bruccoleri?
I'm employed by Vanderbilt University Medical Center as the medical director of the Tennessee Poison Center and a medical toxicologist.
And how long have you been employed with Vanderbilt?
Since October 2018.
And I want to ask you a question in regards to the treatment of Jade Benning. Are you familiar with the patient at Vanderbilt by the name of Jade Benning?
Yes.
And do you remember about the time that she was being treated at Vanderbilt?
Yes.
Was there an occasion where you were involved with her treatment?
Yes.
Can you explain to the jury exactly what your involvement was?
Yes. I was called shortly after she was admitted to the ICU to assist in drug testing because there was concern that Ms. Benning had been poisoned.
And do you remember about the time that she was admitted to the hospital?
She was admitted at about 9 to 10 p.m. on February 25th, 2023.
And who
contacted you, well, let me ask you this. What is your role there at Vanderbilt directly?
I provide inpatient and outpatient medical toxicology consults.
Okay. What exactly does that mean?
So I can provide advice on toxicologic cases, so whether or not someone's been poisoned, intentional overdoses, unintentional overdoses, adverse medication reactions, and envenomations.
And you just stated something about unintentional overdoses. Is that what you stated?
Yes.
Okay. Can you explain to the jury what exactly that means?
So a prime example of an unintentional overdose is if a small child finds a pill on the ground that one of their caregivers has left and ingested it, and the management of that.
And so what would your involvement be in a case like that?
So I would provide advice on how to treat the poisoning. It could be a myriad of drugs that could be one, but for example, something like a blood pressure medication could be ingested by a small child, and then I would provide treatment recommendations to the team on how to manage that.
When you were notified, or let me ask you a better question, do you remember the exact day you were notified in regards to Jade Benning's treatment?
Yes.
And who contacted you?
The ICU team.
And for what purpose were they calling you in specifically as it relates to Jade Benning?
They wanted help with extended drug testing.
And what type of service did you provide?
I provided advice on extended drug testing.
Did you have an occasion to pull urine for or from Ms. Benning? Meaning, did you order a urine analysis or a drug test, drug screen?
I did help with drug testing.
Okay. And do you remember what day that was?
So I assisted in ordering, I don't remember the exact date and time for each time that I called the lab, but I assisted on add-on testing for urine that was already in the lab, and then at the end of her hospital stay, I helped order arsenic testing.
I want to draw your attention as to whether or not, well, let me ask a better question. Once that you order testing, where do you send your testing to? Meaning, where do you go? What lab do you utilize for your testing?
So for the add-on testing, there were 2 labs that I had advised or helped with ordering for. That was NMS Labs and Arup Labs. And then for the arsenic testing, that went to Arup Labs.
And I would like to show you what has been marked now as, well, I'd like to show you an exhibit, please.
What referencing?
No, I want to show you my exhibit that I'm handing her. It's not offering to evidence.
Your Honor, Dr. Bruccoleri cannot authenticate documents, but it's very specific. She needs to be called about what's already been introduced.
That's what you said it was an exhibit. What number?
No, it's not an exhibit that's already been introduced. She's a witness. I don't understand why I can't give her a document, and if she can authenticate it, why am I not allowed to enter it into evidence?
Let the jury step down the hallway.
Judge. Oh dear. In German, Scheiße. Diese Scheiße.
Is this something General Norman you referenced before this witness was called?
Yes, Your Honor, it's exactly what I referenced before this witness was called. This
And what, I don't know, what tests are you talking about that haven't been made exhibits?
I'm sorry, I thought you were asking me.
No.
Your Honor, work order 23078883 which is what this is about, it was not introduced as an exhibit. Dr. Mithun we did not submit it. Dr. Mithun did not testify about it.
What is it?
It is a urine test on a urine that was collected on 2/26/26 at 0922. We did not submit that lab test through Dr. Mithun. This is part of the MMS lit pack. Dr. Mithun is not here to testify about any of the test results.
Well, I mean, I don't know. I guess the question, why wasn't it admitted?
I'm sorry?
Why wasn't it asked about?
If we purposely did not ask about it because there was confusion about the date. And that was the limited testimony of Dr. Mithun, is that we showed that the work order was not the same as the one before, that there was one urine sample from that 2/25/23 at 22:59. It was a completely different sample, and that is what was sent to CFSRE. We have had no testimony.
And this
about,
one deals with what? Which one?
Deals with, that's the thing, it's not in evidence. It's a secondary urine sample.
2/26/1335 or 2/27/23 at 4 o'clock?
No, it's neither.
None of those.
I'm saying it's not either one of those. This has not been
That's
submitted.
only 3 I've seen or heard reference to in the medical.
Correct. There has not been testimony related to this, other than to point out that the work order was different, and she knew for certain that the sample transferred to CFSRE was from 2/25/23 at 22:59.
What are you wanting to ask this witness, Ms. Thomas?
Specifically, I would like to address 2 things with this witness. There is, in fact, an email between this witness and Dr. Mithun in regards to a sample, a designer opioid screen, from 2/25/23 at 22:59. In this email...
That's been testified about.
I'm sorry?
There have been references to that.
Yes, and there's been an issue as to whether or not that urine screen was in fact on 2/26 or 2/25. I have an email in front of me from Dr. Bruccoleri where she references a sample from 2/25/23 at 22:59. That date is extremely important to the defense.
No, it isn't, because you've been over this 50 million times, ma'am, in all the cross-examination in the state's case. We cleared that up. Dr. Mithun cleared it up. Why the F are you still going on about it? And they literally said before these experts were going to get on the stand, you're not allowed to introduce that which the state did not submit to evidence. My word is too much.
Because
that's 2/25/23 22:59 is not an issue.
it is an issue on our side, Your Honor.
But it isn't, because it was corrected, and yes, the hospital gave the victim Fent in the ICU, not in the ER. So if you're going to be arguing that, see, the urine had Fent in it. Yeah, because the date wasn't right there. We already went over this. Listen, man, don't underestimate the intelligence of the jury. Freaking defense. They know things. They heard things. They took notes, and they're ready to not hear it again. Sorry for speaking on their behalf, but if they're anything like us, which is human, we don't want to hear it anymore. We don't want to hear it anymore.
That's,
Your Honor,
is that the urine screen you're concerned about, John Moore? 2/25/23 at 22:59?
That 2/25/23 at 22:59 is a completely separate work order, and that is in evidence, and she's more than welcome to ask about that. She is trying to ask about this other urine sample that we've had no testimony about. It was not admitted as evidence in any way, shape, or form.
Then I guess I need to go back to Ms. Hollins. You've not told me anything that the state's objecting to, so what else are you wanting to ask this witness?
In addition to that, I would like to offer, there is a test from CSFRE where there is coca-ethylene that was found in the urine.
Ma'am, you're literally, I think your strategy is to drive everyone insane. Is that right? Yes, the jury's on a break right now. We're hearing it more than them, I know. But when they come back in, this defense attorney wants to subject them to that again. How many times will we hear about cocaethylene and all this and all this?
Of Ms. Benning,
That's been testified about.
not by this witness.
Okay, maybe you're jumping the gun. I don't know. She's apparently not asking about any other urine screen.
Judge, this email is about a urine screen that is not in evidence at all. NMS has not testified to it.
Well, that doesn't make.
Dr.
That doesn't
Larry
matter
cannot
if you mention.
authenticate anything about the results of this test because we would have to have the NMS toxicologist
There's
testify
not been
about it.
testimony about it. You're saying the only testimony about cocaethylene was from a blood test.
No, Judge, I'm talking about the emails in the first test that she wants to ask about.
There's been testimony about cocaethylene, right?
Okay, so we're talking about a separate issue.
Coming from where?
Judge, which CFSRE report are you referring to?
2023-0090.
I have no objection to her asking
That's
about.
what I said. It sounded like we were jumping the gun.
I was going back to the original because you referenced a urine screen, and
She was talking about a urine screen.
so she's not going to be allowed to.
Show Ms. Hollins the group of things that you're holding there when you're talking about objecting, and see if she has any plans of going into that.
I have one of these work orders.
Yeah, let's see them interact.
Yeah, I didn't realize that my evidence was confined to what the state offered into
Well,
evidence.
you would have to be, there would have to be a foundation for it. Who did it? And wonder what. So, what is your answer to her question?
I'm not trying to offer those test results.
She's not
I am
trying to offer.
speaking to this email written by this witness referencing a urine sample from 2/25/23. The purpose of that,
Is that an issue?
it is to
I'm
us.
not asking you.
Oh, I'm sorry.
It is if she is going to get into the lab.
She just said she wasn't.
Well, Judge.
Is that accurate?
Okay, let's
That's
see.
correct.
All right.
And in terms
I don't
of
believe her.
them wanting to get into the results of the cocaethylene
See?
found in the CSFRE.
So you are gonna.
In what?
Dirty,
one
dirty.
of those work order numbers?
This work order
No, the
is-
one she just showed you on her file there.
Judge, the defense is gonna get into it through this witness because of her email.
No, it's not.
On the manila file, you had two.
This work order that's, the email is about, is this work order that is not in evidence. The email is about something that is not in evidence.
Is that accurate?
I'm not trying to enter those results, Your
Oh.
Honor. I am trying to simply enter an email from this witness referencing a
Show this witness that email and she can clear up what work order it's about.
We know what you're trying to do, defense. You're trying to get it in through the email. It's so naughty. Okay, a reminder that Nightbot is a bot and that the mods prompt Nightbot. Just as reminders of our chat guidelines, don't take it personally.
And I included.
Don't be ugly to Nightbot.
Hang on. Is all of that information you're looking at, Doctor, concerning 225, 23, 22, 59 urine screen?
So, as best to my memory, it is not. This is in reference to a different specimen number. So at the time this was done, which was April 6, 2023, there was some differences in lab collection dates and times to what was matched in the EPIC record. I am pretty sure this is referencing the lab that was actually done at 2/26, 2023 at 9:22 a.m. And this specimen did not ever go to CFSRE because it went back to the crime lab. So
Okay.
this is
What
not.
about what you're wanting to ask about?
So I'm not interested in getting in the results of that test. I am simply interested.
She's saying this email applies to a total another work order that wasn't sent in MS.
Again, I am not trying to enter into evidence any results from any test. I
Then
am
why would you
simply-
want an email about a test that wasn't tested?
Because there's a date on there that is very important to
Ask
my
her what you're
client's
wanting to
case.
ask.
Thank you. Is there a date that you are referencing in your email, Dr. Bruccoleri?
Yes, and I am saying at that time it was incorrect because when you backtrace this work order to the specimen ID into the EPIC medical record, it is a different date and time, which was not discovered until after this email was sent.
And that's fine. I just want to reference the actual date that you have in that email. Back on April, I believe it's the 6th of 2023.
The date that I have is 2/25/23 at 22:59.
Thank you. That's all I needed. And
And
then,
she's saying that's not accurate.
I understand.
So you're
The
entitled to
state-
introduce relevant evidence, not evidence that's not relevant.
The state has made it an issue that that date is not accurate. They have made that
So that
an
date's
issue.
accurate.
May I finish, Your Honor?
220. You're saying the state's saying 2/25/23 and 22:59 is not accurate.
That is correct. They have stated that in their
No,
case
they're
in
not
chief.
stating that. That's accurate. But you're asking about another work order that's not been testified to in the record, so how do we know what the results were?
I'm not trying to get into the results.
But you're
of
wanting
that
an email
test.
to confuse the jury about what's going on.
Yes, there you
Sir,
go.
I'm not.
Okay, well,
Yeah,
I'm
you
not
are.
allowed this email, so they
You're
have.
not.
There you go.
That's fine.
All right, let the jury step
I'm
up there.
not done.
Oh.
I have another test. As
Okay.
I
Oh, dear.
stated, there is another work order that Dr. Bruccoleri is aware of where Ms. Benning tested positive for cocaethylene. I simply want her to have the opportunity to testify about that because
What
it goes
work
to
order
my
is that?
clients. It is work order number 2023-0090.
Is that tested
Yes, it was.
by Vanderbilt?
Yes, it was tested by Vanderbilt, but what's in question is what went to CSFRE, which is,
What?
it went to the Center for Forensic Research and Education.
But your hospital tested it and it showed what?
So it went to NMS lab. So our hospital drew it, sent it to NMS
The
lab.
hospital didn't test it.
Our hospital sent it for extended drug screening to NMS. I do not.
Vanderbilt Hospital test what she's asking about.
Could you repeat the question, Your Honor?
Did Vanderbilt Hospital test what this lawyer's asking about?
I don't know if they ran tests on that sample themselves.
She has personal knowledge that Ms. Benning tested positive for cocaethylene.
Is that accurate?
Yes.
From what source?
That's from the Center for Forensic Research and Education.
She didn't do the testing.
But she has personal knowledge, and
It'd be
she's a toxicologist, Your Honor. And she's treated Jade
But
Benning.
you want everything to be reliable, right?
No, what I would like is
I
for
don't want
this.
everything to be reliable.
May I finish, sir, please?
Just answer my question.
I
You
would
want
love-
all the test results to be reliable.
I would
right?
love for that.
Okay.
But
Well,
that's
we
not
don't
the
have
case.
the people that did this test. Did you subpoena them?
I don't need the people to be
Well, then
that
she
test.
can't testify about the results of someone else's test.
She can testify about her personal knowledge
She doesn't
because
have personal knowledge.
she just told you she did.
It's from another testing agency.
It doesn't matter. She got.
Okay, well, I
You can
think
make
it's
your
fine.
ruling, Your Honor, and that's
I
fine.
rule, so that's out.
And what is your
else do you
ruling?
want?
I rule, and that's out. Email's out. Oh, okay. Nice, Josh. All
You
right.
said it's out.
Thank
What
you.
else do you want to ask her?
There's nothing else.
Okay, let the jury step in.
Can I get my test back, please?
Sure.
Oh, my word. The judge is putting his foot
Somebody
down.
from the lab.
That's right. waiting for Friday. So see, she does want to bring it in. Yeah, she does. Through an email. So are they going to release witness number 7 now? Can we get to number 8 and then 9, 10? Eight, 9, 10. 3 more after this, and it's also doctors. N Q says, but Your Honor, why can't we gaslight everyone and run a smear campaign? Come on. She knows, she's got personal knowledge. She sent an email. Yeah, Stefan, she says, nothing else. Warrior Queen says, ooh, I feel an appeal coming if he's found guilty. Yeah, me too, a little bit. Just on my limited knowledge of it, I'm like, me too, a little bit. The judge is sure rushing this trial along. I understand why, don't repeat things, but still, damn, it's like, go, 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 go. Never seen a trial like this before. Oh dear. Oh. And now we know the jury's like, oh, because I mean, they just left. By the time they come back in, any more questions? No, I already asked all mine. Okay. State, no, Your Honor. Okay. Respectfully, ma'am, Dr. Rebecca, just get your ass all to stand. Next.
With the next witness.
The defense calls, Eric Devlin.
Yeah, get him, somebody. Let the lawyers step up.
Let the lawyers step up. Now, you hear me now, lawyers? Let me tell you something. Not on my watch. Look at him. He's like, do you think I'm going to be found guilty? Probably. Gonna be served some cold, horde Al-Wop tartar on a silver platter. Just with a little drizzle of truffle oil. Off you go. Lovely silver bracelets await you, sir. Mm-hmm. Yeah, he's definitely looking tired and worried. It's gone downhill for him. I think they're going to call a digital forensic expert now, is it not? Well, I don't know if expert. A digital forensics dude, from what we know so far. Ooh. Thank you, camera person, for showing us some of this side snark. Tracy says, cuff him. Your Honor, he's ready for his silver bracelets now. And a freshly pressed jail jumpsuit. Prison, in fact. And a little buzz cut. It's for free. It's all inclusive, you guys. All inclusive. You get bracelets. You get a freshly pressed, which could mean stomped on, I'm not sure, but freshly pressed prison outfit. Okay? You get a free haircut. You even get like a free medical checkup where you have to like do a couple of squats and cough, you know, and you'll have an audience to really give you that special attention before you go meet your new friends. Oh crap. Jurors are stepping out. That's right, Tracy, and shoesies. Maybe some Crocs, some prison slides, a little introductory package of how to order on commissary toothpaste that does not taste like mint at all. I like telling you funny stories along the way. The other day, okay, I have this Nivea soft cream is what it's called, and it's shaped the exact same way as my toothpaste. And you can imagine what happened. You can imagine what happened. Yeah, I just grabbed that. It was actually while we were on vacation. I just grabbed that. I was in a rush and I started brushing my teeth, and I'm like, oh my word, this tastes like prison toothpaste. And then Raphael, my husband, was like, how do you know how that tastes? I don't know. I just heard it doesn't have any mint in it. This is horrendous. Oh my word, I'm brushing my teeth with my face cream. Damn it. It's like Aqua's cream. I brushed my damn teeth for the first time in my life with some Aqua's cream, and now I know what prison toothpaste tastes like. Ew.
You have to sit back there outside, sir. Get a Mario or follow me.
Sorry, what? Are we voir diring? What are we doing? What just happened? Hope 8 Pierre said, jury's getting their steps in today. Mm-hmm. Yes, Tracy, yes. Moisturized my gums. Ooh. No one wants it. What did they go do now? Here they're coming back in. Okay, he's getting on the stand. Yeah, Tracy, moisturized teethies. Yes, they were glowing.
The attorney was going to ask you just some, I don't know about brief, but some questions in terms of the bottom line issue. They're wanting to call it, okay?
Yes.
Outside the presence of the jury. Okay.
Good afternoon.
Good afternoon.
Can you please state and spell your name for the record?
Mario San Bartolome, M-A-R-I-O. Last name is S-A-N-B-A-R-T-O-L-O-M-E.
And what do you do for a living?
I'm an addiction medicine specialist and family physician.
And can you tell this court a little bit about your education?
Sure. I'm double board certified in family medicine and also in addiction medicine. I'm also a medical review officer, which is the individual that is involved with drug toxicologies as it relates to substances of abuse. And I currently work as an addiction medicine specialist at a community clinic overseeing a treatment and any sort of substance use related things at a federally qualified health center.
Oh, so you've come here to throw the victim under the bus. Well, don't mind us while we don't welcome you with the red carpet. Oh, sorry.
And can you tell us a little bit about your education?
Yes, I went to UC Davis for undergrad and then went to medical school at UC Irvine, followed by residency training at Long Beach Memorial, and then pretty much started practice right around that time.
And have you published any articles?
I have not.
Have you dealt with or worked at addiction treatment centers?
Yes, I have.
How many?
Approximately, I'd say 5 or 6. I've been a medical director for every level of what we consider to be along the continuum for addiction treatment. So inpatient, hospital-based detox, inpatient rehab, outpatient, intensive outpatient, and partial hospitalization programs.
And what, if any, other specialized skills and trainings you may have?
Primarily just the added medical review officer, I think, to the addiction medicine board certification.
And do you have any experience treating patients with addiction?
Yes, I do.
Do you have any experience treating pregnant women with addiction?
Yes, I do.
One second. Do you have any experience in dealing with and or diagnosing substance use disorders?
Yes, I do.
And what would some of those be?
The substances? Is that the question?
Yes.
Oh. Methamphetamine, cocaine, opioids, alcohol use.
Sir, could you just not flag my YouTube channel like that? That's it. We're taking any carpet away, never mind a red carpet.
Cannabinoids, pretty much any substance of abuse, hallucinogens, inhalants.
And what is substance use disorder?
Well, a substance use disorder is a diagnosis that's related to a chronic illness that we call a substance use disorder based off of the substance, the primary substance. And it involves biological, psychological aspects that are typically defined by somebody continuing to do things despite negative consequences.
And have you ever testified before as an expert, as a medical review officer, and a addiction specialist?
Yes, I have.
No further questions at this time, Your Honor. Okay.
How riveting.
I would ask that he be tendered as an expert in.
No. Oh, sorry.
As a medical review
Negative.
officer,
Object.
as well as a addiction medicine specialist.
The state's not so much concerned with his qualifications, but with the relevance.
What are you wanting him to opine for this jury?
I want him to opine for
Yeah.
this. Oh, okay. Dr. Mario, in your experience, is pregnancy a automatic stoppage to substance use?
No.
Why not?
Well, because even though it is definitely a well-studied external motivator, in other words, if somebody is in the process of using substances and finds that they're pregnant, it is something that is associated with a higher likelihood of having motivation to stop using. But by itself, it's not something that's a guaranteed that somebody would stop using any substances.
And what is addiction medicine trying to understand?
Well, addiction medicine really deals with judgment. It deals with physiologic changes that drive somebody to have impulsivity, to have the kind of behaviors that can be harmful to them. And despite those things, there's changes in the brain that cause them to continue the behaviors that hurt them. So a lot of it has to do with judgment, and a lot of it has to do with how substances interface.
Can self-reporting in clinical settings, what is your opinion about self-reporting in clinical settings?
Well, it definitely is very valuable. That's what we base all of our screens with. People self-report. It has some limited value in that we are relying that the individual is being forthcoming. And that can be difficult in addiction because addiction also, or even without addiction, actually just with what we would consider substance use. That means no addiction, no dependence, just they happen to use a substance. But in the setting of screenings and things like that, there's a lot of stigma, unfortunately, that's attached to any substance use. And so sometimes people, they have reasons to fear being forthcoming with certain things that have to do with substances.
If you know, can you please explain what is an opioid epidemic?
Well, the opioid epidemic is currently something that we've experienced since around 1999. Currently, we're in our fourth wave of the opioid epidemic, and everyone's probably seen in the news drugs like fentanyl or heroin. These are class of chemicals that typically we use for pain. And the first wave of that really happened somewhere around 1999. And it was around prescription drugs that doctors would prescribe, and sometimes people could get dependent on them. Now, dependency is not the same thing as addiction. It can even just be dependence. It can be around pain. However, it does leave people where if they stop using it, they experience what we call withdrawal. And withdrawal can be a pretty severe neurologic type of reaction to not having the substance, access to the substance, which then, when we clamp down on that and reduce that from the standpoint of the system, it created the second wave. And the second wave was around heroin, where people found that they could no longer access prescription drugs, and so they went to use heroin, which was cheaper and more accessible. The third wave came somewhere around 2012, 2013, which had to do with fentanyl. And that was the beginning of what we see now, where you didn't even have to be addicted. You could just actually come into contact with a very potent opioid a synthetic opioid like fentanyl, not from a prescription, but something that was either adulterated, added to something that you thought was something else, or the very thing in question being the fentanyl. And that went on for some time, and now we're in our fourth wave. And the fourth wave involves fentanyl plus psychostimulants. And psychostimulants, that class, involves primarily methamphetamine and cocaine. And those are the kind of the second highest amount of prevalence that we see next to fentanyl in cases that involve fatal overdoses.
What scheduled drug is fentanyl?
It's a Schedule 2.
What about cocaine?
It's a Schedule 2.
What about marijuana?
It's federally still scheduled right now. This thing is a Schedule 1.
What about Adderall?
Adderall is a Schedule 2. That's a psychostimulant.
And if Adderall is a psychostimulant, does that mean it will fall within the fourth wave?
It is. It's an amphetamine.
And are counterfeit or fake Adderall pills contributing to the opioid crisis?
So that's the big thing that's happening now, and this is why the DEA has put out warnings about this. It's not that people are consciously seeking out, usually when they pass away, necessarily the combination of fentanyl with a psychostimulant. It's that oftentimes they think they're taking one thing, but it's adulterated. That means it's been added or spiked, if you will, to something else. And that can actually happen in both directions. It can happen to people that press pills and make Adderall, they'll add fentanyl, and it can also happen in the other direction.
And when clinicians assess risk, do they look at isolated events or overall behavioral patterns?
Well, an isolated event rarely leads to any sort of a diagnosis, right? So we're always collecting information. Some of the information comes from the patient. Some of it comes from corroborating avenues from other people or other things that are observed that contribute to the diagnosis. So generally it's an overall kind of a compilation of processes that we look at, not just one thing.
Just remember, the jury's not in right now. This is voir. This is for the judge to decide, is this going to be in? I hope he says, no, it's not allowed in.
And have you had the opportunity to review medical records in this case?
Yes.
Have you ever seen, do you know of a pregnant woman who normally would smoke marijuana?
Yes, that happens.
And are they always forthcoming about their use?
No. I mean, in pregnancy in particular, again, there's significant stigma, significant fear of consequences, child protective services, being judged. These things that are unfortunate that shouldn't exist, but they do exist, and I think they're even more marked in that group of people that have any sort of substance use. It doesn't even have to be cannabis. It can be any sort of substance.
And was any of that found in this victim's system? No. Did you ever meet this victim? No. Do you know anything about her? No. Are you a doctor to review medical records? No. Okay. Then, sir, respectfully get your ass off the stand.
In your expert opinion, who would be amongst the most stigmatized class of people when it comes to drug use?
I believe it would be the actively pregnant woman.
Would it be judges?
I'm sorry?
Wouldn't be judges?
No, I think that there are states that still, and we've had this historically, that want to put women in jail for substance use. So rather than looking at it as a medical condition, they look to remedy that by illegal action to put people away. So I think that's pretty severe.
Shame. He's like all flustered now. The judge says, wouldn't it be judges? What about judges?
We don't do that to any man that I know of in the same way. And so I think that they're particularly stigmatized because there's an element of another being, the element of a child. So the concept of, well, you're hurting the child, therefore you have a separate action against you. And that's where that comes from.
Are you trying to explain basic principles now?
And I think there's also social pressures. It's a critical, delicate time as well.
And could that stigma and social pressures lead to a pregnant person concealing their substance use?
Sure, it can.
Backtracking a little bit, what about mushrooms or psilocybin? What scheduled drug is that?
So psilocybin, or what's sometimes called magic mushrooms, is a Schedule 1. It's in a category we call hallucinogen, that people take it and then they can have psychedelic type of reactions to it.
Dr. Mario, I want to give you a hypothetical. If there's a pregnant young lady and she notifies her friend that she's pregnant, and that friend says, "Oh, you've been drinking," is that an example of stigmatizing a person?
Well, it can be that anytime somebody that is pregnant shares any information about any substance use, that this is why doctors get trained to have more of a poker face about it, that our concern is how do we evaluate what you need rather than judge what you did.
And in your expert opinion and in treatment, have you ever heard of someone being able to smoke mushrooms?
So in my practice, I have not heard of anybody doing that. After almost 20 years now of doing this, I think everything that could be smoked has probably been smoked by somebody at some point. However, in the case of psilocybin, combusting it or burning it actually would deactivate the active ingredient, so you wouldn't get what you wanted from it, and then you would also be inhaling a bunch of fungal spores into your lungs. So there's lots of reasons why it's something that people don't really do, even though certainly you can try it.
Don't try it. How about that? Certainly you can try it. No, sir. Don't try it. Don't try that at home.
And lastly, if you could just talk a little bit about how substance use impacts, if at all, the prefrontal cortex of a person.
Sure, that's really at the hallmark of all addiction. It's one of the most difficult parts to sometimes understand. People that have substance use disorders need help, and this is the reason we look at it as a disease, is because the parts of the brain that get affected, we know. We actually have studied it. We know the parts. And maybe the most frustrating part for a lot of people is how is it that somebody that maybe in other dimensions of their life function well, how is it that they can have this other component that is not functioning well? And the part of the brain that is involved in this is right in front of your forehead, right behind your forehead. It's called the prefrontal cortex, and that's the part that controls judgment. It controls what we call executive function. It's the part that keeps you safe. It helps you make decisions. And
sir, who are you talking to? Because the jury's not in the room. Okay.
Unfortunately, certain substances impact the part of the brain that controls a neurotransmitter called dopamine. So there's really two players in the play. The dopamine pathways, which we also call the reward pathway. When you do something that is good for persistence, it obviously doesn't exist for drugs to exist. They're there because of their survival things. So increases in dopamine decrease the function of the prefrontal cortex, which is why in substance use disorders there can be lapses in judgment.
And in your expert
We don't have a lapse in judgment right now. We're looking, we're judging, and we hope the judge says, nah.
opinion, if a person is pregnant, but they're engaging in, let's say, facilitating drugs, what would you opine about that person's judgment?
Well, that would definitely fall under, what we consider to be part of the clinical impression. So the clinical impression, without going into a diagnosis, because you really need to do a physical exam and do a comprehensive exam to come to a diagnosis. But risk-taking is part of the hallmark of addictive disorders. So engaging with a drug dealer in any fashion certainly would fall under that, whether you're an intermediary, whether you're buying yourself, whether even just associating. I think that would be one of the signs of many that we do include in our evaluation of what a substance use disorder might be.
And again, it's not uncommon in your experience, in your expert opinion, for a pregnant person to hide any type of substance use from their friends and family.
It's not uncommon for all people with addictive disorders, but I think even more so potentially with somebody with a pregnancy that's going on at the same time. There's a bit more to lose, I suppose, that is part of the thought process.
And along with drug or facilitating drugs, being around drugs, would a person's proclivity to engage in promiscuity be something that you would consider about the judgment? Could you assess that at all?
Well, it's something that can be, just as a general. It doesn't necessarily have to do with substances, but it certainly is any high-risk behavior where you can link, where there's typically the prefrontal cortex puts the brake on and it stops it. That would be something that could be in consideration.
You said lastly, defense. So lastly means lastly. Got anything else back there before the judge? Yes, this
Your Honor,
witness.
at this time, I would like to tender Dr. Mario as an expert, as a medical review officer, and an addiction medicine specialist.
Any questions from Mr. Taylor?
Yes, sir. Doctor, would understand by that by analogy, a pregnant woman should never work as a bartender? Was there being around?
I don't understand the question.
That they shouldn't be ingesting?
Well, so for somebody with an addictive disorder that has pregnancy, yes, my recommendation to that person would be working in a bar would probably not be the best, just because of exposure.
There is absolutely no proof in any record that you've reviewed that Jade Benning was addicted to any cocaine or any other controlled substance, is there?
Not of cocaine or no addictions.
And she was a casual user of marijuana, correct?
Well, so we don't use terms like casual user, so that would have to qualify that. I mean, we have what we consider to be misuse of drugs and then use disorders. We can't really make a determination on use disorders because a full evaluation wasn't done. The labs, the examination. She did not have a use disorder that I could state as a physician because that examination was not done. But these chats with...
I'm not asking you about misuse disorders. I'm asking you about Jade Benning. I'm not asking about other people.
I'm not talking about other people. I'm talking about Jade Benning as well.
Okay. Well, in California, is marijuana legal in California?
It is. Well, it's decriminalized, so it's...
Decriminalized, whatever. And actually legal in a number of states, from what I understand. Okay? Do you treat people with marijuana addictions?
I do.
All right. So do they come to you out of the blue, referred by law enforcement?
Law enforcement doesn't give me many referrals unless there's court ordered. However, I do get referrals, and I do have people that come in that tell me that their cannabis use has gotten past what they can handle, and they feel like their life's out of order.
Gotten out of control.
Yeah.
Absolutely no indication that happened with Jade Benning, is there?
I would consider engaging with a drug dealer unusual behavior that would be linked to, in this case, cannabis.
That's my point.
That information.
From the text messages that she was having between Danny, the dealer, she was getting for her coworkers and for herself, cartridges of cannabinoids, all sorts of different species of cannabinoids, some magic mushrooms. I'm sorry?
She was getting them?
She was brokering them. Some of it was promised to her, but most of it was as an intermediary for coworkers. I would consider that to be unusual behavior, I think, for anybody to engage in that, because the risks are high. Not judging if it's a good thing or a bad thing, but to put yourself in a position to have to be an intermediary and then potentially be at risk for the consequences when you give somebody else a substance that somebody else brokered for them.
From the records you reviewed, we're talking about Adderall. There was no Adderall or any derivative of that found in Ms. Benning's system, was there?
No.
And you and I talked, and we have a time or two, at least we'll say hello, that you would agree, would you not, doctor, that she died from acute cocaine toxicity by oral ingestion, correct?
Well, I'm not here to actually, my scope is not to testify on cause of death, so I would leave that to the toxicologist and Dr. Larkin.
Well, did you not tell me that you would agree with that finding?
Objection, Your Honor. The witness has already stated it's so.
Yeah, I'll sustain it.
Right. And that, how many people have you ever treated at your clinic for being addicted to orally ingesting cocaine?
That's exceedingly rare. I mean, I know that people use it in their gums. They've had it in their mouth, but there's definitely not been a lot. That's not actually, in general, that's not a common way. Yeah. So.
Because they die.
No, that's not why. It's because it actually takes longer to get the effect, number one. Number two is because it actually deactivates a lot of it, so it's hard to get the same effect that you could get if you snorted it, you smoked it, or you injected it. That's the reason why. And there's quite a hierarchy that can be applied to most things, actually. If the particular substance isn't particularly absorbed well with how you take it, that's not how it's used.
There is absolutely no indication, doctor, is there from a medical record that Jade Benning consumed any drug or alcohol after she found out she was pregnant? Is there?
Correct, not medical records, no.
And so, nothing that you have testified about is based on any personal interaction with Jade Benning, correct?
That's correct.
Either during her lifetime or obviously the review of the records. There is just nothing there.
Yeah, I have not personally evaluated Miss Benning.
And the phases of heroin has nothing to do with this, does it?
No. Are you referring to the different?
Your epidemics.
Yeah, well, they're not mine. They actually are ours, but I mean, the heroin was just one stage of that, and so that was just one to kind of explain why there are different stages of that exist. That the most recent one is fentanyl and psychostimulants.
But your testimony about the phases, what was before heroin?
Before heroin was prescription drugs.
Okay, before prescription drugs.
Well, that's the first one. Prescription drugs.
Other than she was.
Okay, skip forward a little bit. Oh, because we caught up.
This testimony.
We were watching at 1 point something speed. Hold on.
Other than she was.
Oh.
Under Rule 7.
If I did, I misspoke, but you absolutely can't. You can be a casual.
Let me see what they're doing.
Yeah, I wouldn't use casual because in the context of what you were talking about, it was.
He's asking you can be a casual cocaine user.
So you can be. So if the definition of that is that somebody uses infrequently, if that's what your definition is, when we discussed the issue of the marijuana, I thought you were talking about something more like diagnostic. I just wouldn't use those words for something diagnostic. But they both can be used with low frequencies, for sure.
Doctors, about the cocaine, you said someone told you about that.
No, I've seen it in the reports from one of the labs, but again, I'm not here to testify my scope about that. I think you have a toxicologist and you're going to have Dr. Larkin on that.
And did you prepare a report about all of this?
I did not. I don't have a report.
That's all right.
Anything else? Oh, okay, you stepped up.
Yeah, you can step down, judge. I don't know about that. Do you guys think it should be allowed in?
Yes, Your Honor. Yes, Your Honor. The state would renew its objection to this doctor testifying under Rule 702. It's been nothing that he has testified about. In fact, knowledge of this incident, no knowledge of Ms. Benning, other than she was not addicted. All this testimony would have to come under Rule 702, that it is would substantially assist the trier of fact jury. And Merriam-Webster dictionary, synonym is important or essential. But this testimony is not anywhere close to being essential. It's irrelevant.
Agreed.
It is designed to, if anything, just attempt to paint Ms. Benning as
I agree.
someone she was not.
Do you agree with the state?
Therefore, to exclude this testimony.
Exclude it, Judge. Do it.
Sure. Donna, it is not only important, but it's a vital and critical issue that the state has put before this jury through multiple witnesses, which is the fact that Ms. Benning would not engage in any type of drug use or behavior because she was pregnant. And so it is very...
They didn't say that. They said there's not even proof that she did.
And, Your Honor, we believe the contrary. We intend to get into that.
But this gentleman doesn't know that.
Yes, he does, Your Honor. He has reviewed text messages that suggest she was offered drugs while she was in fact pregnant.
Wow, text messages. But then there's nothing in her system like that besides the huge amount of you know what that somebody gave her.
We haven't gotten to the text messages, but if those come in, then they come in. He doesn't have to interpret them.
No, but certainly they are evidence of the lifestyle that Ms. Benning was engaged in. The state certainly has taken the position that it is a barrier to her being involved in anything illicit because she was in fact pregnant. And so the defense has a right to put on evidence before this jury that simply being pregnant is not a reasonable statement of sobriety in and of itself.
I have to state that too.
Again, let's say that the victim in this case drank every day and took mushrooms and smoked MJ. That's not what killed her. Okay? And there was no evidence that she ever took, from the text messages, that she took cocoa. The snow. Shouldn't take that. So no one said that the victim has to be an angel. No one said she has to have the cleanest record ever, that she never ever touched a substance in her life. That's not what killed her. What killed her was a huge, huge, huge amount of liquid cocaine. So this will not help at all to try to tarnish her name and be like, see, she was dealing it, she was obtaining it, she was asking questions about it. You still have no proof that she took it, especially when you look at the toxicology reports.
They agreed with you.
But Your Honor, they can take that position because they have rested. They've already paraded a bunch of witnesses before this jury.
Paraded.
Do you think you need this person to tell the jury that women that are pregnant can still use drugs?
And that they are stigmatized, and that may be a reason that they would not disclose to family members and loved ones.
Okay. Thank you. All right. And in terms of the cocaethylene that was brought up on redirect and then recross, as the own witness said, he's not here to interpret he knows what it is, but he's not here to say one way or the other about what that means for Ms. Benning. The other proffer involving pregnancy, not being an automatic stop to using drugs, pregnant women can still use drugs, the testimony about fentanyl overdose or epidemics, I don't know if that word was used, the detective's already been asked about and testified. There's no proof, and this witness has said he doesn't assess Ms. Benning as being an addictive disorder person, patient, if she were one of his patients. So he's a fine gentleman, useful in his field, I'm sure, but 702 requires the court to assure that there is some issue that the jury wouldn't know about and that his testimony would substantially assist the trier of fact in some issue to be determined, and the court just doesn't find that. So no need for Dr. San Bartolo.
Yeah.
Is
what? I would like to say for the record, offer proof that...
We've already had the offer.
There's one other thing that I would like to add, and that is the state has put an issue that since Ms. Benning has become pregnant. She is now leaving this clean law. Ms. Benning is
Like I said to your co-counsel, they're putting on proof that there's no proof she did use.
However, Your Honor,
Based on toxicology results. They're not putting out a narrative. The defense is trying to put out a narrative. That's not going to defeat the evidence that there was nothing in her system besides that which killed her, which she didn't even take, based on the evidence of her never. They looked at all her text messages and everything, even though she was talking to a dealer, no cocaine. And definitely not ingested like that. Okay, so you know what, defense? No.
she is heavily involved with the sale of drugs.
Right.
That is dangerous behavior in and of itself.
Okay.
If she was a dealer, she's probably not taking it. That's another dumb argument, defense.
The jury needs to be educated in regards to...
And what proof is there that she was involved in dangerous drugs on the day or in and around the day she died?
Because on that very day, she reached out to her drug dealer. The very day she passed
Any proof that she met with him?
We don't know.
Okay. Well, your Dr. Larkin says on the day of her death, text messages indicate that Jade met with her drug dealer. You just said that inaccurate.
Well, I think an inference can be made that she did.
You just said she didn't.
And you asked me, is there any proof that she did?
That's what we deal with, is proof.
Well, we have to be able to put on a defensive theory. So all I
Sure,
have to say...
I haven't figured out relevancy-wise what it is, but that's where I'm trying to get to.
What's relevant is...
But I've already ruled on Dr. San Bartolome.
If I could just say, what's relevant is what Dr. stated about the most stigmatized person when it comes to drugs is the pregnant woman,
Okay.
which means that she will do whatever she can to hide her interaction, use, dealing with drugs, such that her family
Just
will not
present
know.
proof.
Where's the proof that she would know that that's the most stigmatized statistic? Where's the medical records that say that she took any of that? Oh my word.
You have it that she was using drugs. That's all you have.
There's
to do.
no proof Mr. Taylor did this either, but there is an inference being made. In that same instance, we would like to make the inference in regard to this video.
Okay, and I ruled, like you've asked me to do. Now, what did the state determine about Bumble?
Your Honor, Tom Miller is on his way over. I do not believe that this is active use for Bumble. I do not think it should be admitted. I would like to have a jury out on it.
Okay, where is Mr. Kevin? Bring him in. We'll hear what he says this means. And is the state opposed to the other text messages?
I am opposed.
Some of them have already been mentioned and introduced or talked about.
I am.
So the judge is not letting Mario onto the stand, right? I mean, he rules so quickly, we're like, what? Right, it's out, right, it's out, okay?
Opposed to the one on 120-23.
121-23 dealing with what? They've got them categorized as discussion with Blaise.
I'm sorry, it's like it's under the drugs category.
Okay. Which is there 8, I got a 5, a 6, and a 7?
4.
4. That's the metadata with the message. Could I get an 8 with top shelf?
Correct.
What is your...
So if the 8th witness is out, we've got 2 to go, potentially. Judge, just yeet them all and and let's close for the day. How about that?
Your objection?
My objection is she's not ordering this for herself. It's in January and it's not relevant. We've already had testimony related to the same thing.
Correct, but they can put another proof. What's your other objection?
On page 5, that is a received message, not a sent message.
I don't know what Mr. Edmonds going to say. So it's received, but it's still drug related, right?
Correct.
Okay. Anything else?
Yes, on 6, it's from 11/5 of 22, and it's received. And the state submits it's not relevant.
Okay. What else?
Also number 7, it's received, it's from January 18th, 2023.
Okay. Anything else?
On page 8, the reference to Adderall, I feel like we've already been through. This is not Adderall that Ms. Benning was requesting for herself, it was for her friend that was
Right,
on
we just confirmed that, right?
I'm sorry?
This just confirms that it's
Yes.
for someone else.
No. Right, this is like someone else is asking for it, not Ms. Benning.
Okay. Anything else? Anything else?
Number 8, I feel like actually clears up the
That's the
Mario
one you
situation.
just asked about.
My word. Like, I wonder what's going to come in here. Bumble messages? Can we see some Hinge messages just so we can snark a little at Blaise over there? Mary T said the jury's been out far more than in today. Have we ever done another trial where the jury's always out? I don't know. Some come to mind, but not the jury's definitely been out a lot today.
I'm sorry?
That's the one you just mentioned.
I'm sorry, that was number 9, was the one that kind of clears up the Mario situation because she wasn't ordering it herself. On number 10, there's no date on this. Also, it just seems cumulative. So there's no date for the message sent. There is a date. They just cut it off. And the thread, they included 235 messages, which doesn't seem useful, but it doesn't tell you what date this message was sent.
Okay. We'll see what they have to say in their prompt. Anything else?
Number 11, like everything, he's printing stuff without the usernames in it. This message would have a username, but it's clearly someone else asking for narcotics. It just seems like it's Mario, and that would be important to the other texts.
Anything else?
12, I don't have an objection. Pages 13 through 15, no objection. Communication with Blaise Taylor, no objection. Plans with Blaise Taylor. Again, I don't have a specific objection. I just have no idea why we would submit a message without the person the message is sent to. And then the Bumble, I have a giant problem with.
Okay, we'll hear about that.
And the Jerry Porter messages, the state's objection is that these are not relevant to any issue before the court.
According to the defense theory, it shows you talking with another guy, texting another guy.
These are texts from December.
Right.
The first page is from December, so she's not even speaking to Mr. Taylor then.
All right, if you'll step up, Mr. Devlin, raise your right hand if you swear.
You swear to tell the truth, what we got.
I do, Your
Another voir dire?
If you will, in your proper clear up whether your person here, witness, knows anything about page 23 and what that means, 22 and 23.
Mr. Devlin, could you please state and spell your name for the record?
Sure. My name is Eric, E-R-I-C. Last name is Devlin, D-E-V-L-I-N.
And Mr. Devlin, how are you employed, sir?
I'm currently the managing director of the Lone Star Forensic Group, a digital forensics company based in Houston, Texas.
And could you give the court your credentials in regards to the digital forensics?
I have an undergraduate degree in history, political science, and film out of Southern Methodist University. I have a law degree out of South Texas College of Law. After graduating from South Texas College of Law, I took the bar exam, passed the bar exam, became a prosecutor at the Harris County District Attorney's Office, which is Houston's DA's office. I was a prosecutor there. I tried everything from traffic tickets to death penalty cases, but spent most of my time as the chief of the cybercrime, human trafficking, and child exploitation divisions. After I left the DA's office, I opened a forensic company, and I've received thousands of hours of forensic training. I have certifications through a variety of platforms. I have examined thousands of cell phones. I have testified in state court, federal court. I've testified in, so far I've testified in Ohio, Texas, Florida, South Carolina, and Indiana.
And have you had any specialized training in regards to cell phones particularly?
Yes, I have specialized training from Celebrite. I have specialized training from magnet forensics. I have specialized training in generic phone forensics. I also have advanced smartphone training.
Have you?
How much did you spend on this witness defense? Probably everything, right? Whole budget going here.
Have you had any occasion to publish any publications and/or articles?
Yes.
Have you been certified as an expert in forensics, digital forensics, prior to today?
Yes.
And will you be opining and/or giving information today from the cell phone and dump and/or forensic download of Ms. Jade Benning's phone?
Yes, ma'am.
At this time, I would tender Mr. Delvin as a forensic expert with the cell phone of Ms.
Tell us what page 23 means.
It starts on page 22, but page 23 specifically is the activation of the application for Bumble, which is a social contact application. This indicates when you go from the springboard, which is the basic function of the screen, opening that particular application.
And does this, or do the notations that we find on page 23 actually state that Ms. Benning opened that application and interacted with it?
I can't say Ms. Benning did. I can say that this phone opened.
Thank you. And did they do so on each and every occasion? Did this phone, every notation that we see here, did it in fact interact with the Bumble application?
Each one of these is an interaction with the Bumble application.
And it's not simply just a notification?
No.
Interacting how?
Either opening it, closing it, switching it, adding in, making contact with the actual application.
Can you tell me that Ms. Benning was communicating with, accessing information about other men?
No, sir.
Can you tell us what is the purpose of the Bumble application? What is its purpose? What is involved?
The Bumble application describes itself as a social contact application. So while many people use it for the purpose of dating or hookups or other interaction, other people use it as a contact social media application of that type.
The defense wants this witness, who does seem very smart. I do like digital forensics too, hey? Okay. To say that Jade was using Bumble, but they don't have any evidence of her talking to other men, just that she downloaded the app. That's what it sounds like. Oh, okay. And that's going to be your proof to say, see, she was talking to other men. Yeah, she was also dating. And What can
you tell us she was doing?
I can't. Just that the application was being interacted with. And the application was installed previous, so.
Can you give us, can you give us a date that this application was installed on Ms. Benning's phone?
I show an application, an installation of the application on 2/17/23, and I see another installation on 2/22/2023.
Any other questions? Yeah.
I do. Mr. Devlin, did you pull out the information where Ms. Benning registered for Bumble August 6th of 2022?
I didn't see that part, so.
Okay, so you were searching specifically for user activity on Bumble, and you didn't just put Bumble in as a search term in the Axiom software.
When I was, sorry.
Did you not do that?
I did enter Bumble as a search term, that's correct.
Okay, but you missed where she got a text message from Bumble with her registration code on August 6th of 2022 at 12/17/27.
Your Honor, if I could just note, that might have been during the date-limited portion of our search.
No, you wanted to go back to January 2022.
I don't think we were allowed to go back on those issues. We were limited to certain issues that we could search.
Well, you're wanting this witness to testify about her accessing Bumble, and they're asking their question. Go ahead.
And so if This same database that you have here on page 23, if there's activity on here after Jade Benning's death and after the phone is in police custody, do you think you might change your opinion as to whether or not this is user activity or if it's just updates within the Bumble app?
The Bumble app can have updates, absolutely, as a part of it, depending upon if the phone is powered on and connected to the networks. I did see actually registration codes. I did see other messages that were what we call system-generated messages, but I didn't see any messages at all on here with her communicating with anybody on the Bumble app. So
no messages with Miss Benning communicating with anyone on the Bumble app?
not that was recovered, no ma'am.
So it's possible that she could have even gone in to look at one of her girlfriend's profiles just to give her some feedback as a nice friend.
Some people do that, yes ma'am.
And Your Honor, I would think that that is a point for cross-examination.
Do you have any other questions?
You're speaking to me? Are you speaking to me or this?
To you.
Yes, I do.
Did you find entries like this?
Speaking to me?
I haven't noticed it, Your Honor, so I didn't look for that particular, so.
You didn't look after 3-6?
No, ma'am. No, sir.
Okay.
When you looked at the Bumble application, did you pay close attention to whether or not the application itself was interacted with as opposed to just a notification?
These logs here are not notification logs. These are actual interactions with the application.
And when you say interactions, what do you mean?
That means the application was opened, the application was interacted with. I don't know what they did with it. I don't know if they searched for somebody. I don't know if they communicated with somebody, but there was an interaction with the application. That's as far as I can see on here.
So then it is a possibility that if she interacted with this Bumble, it could be that she was looking at dating men.
It's possible.
So in the same manner that she could have been trying to message a friend or a girlfriend to check on her, she also could have been messaging a man to try to date.
Could be. Yes, ma'am.
And who cares about that? Who cares if she was trying to do that? Blaise over there, Blaise, was already like, oh no, okay, you're pregnant, yeah, I'm out. And it doesn't matter which time frame they look at. They were never exclusive. The defense said it in the opening statement. So like, ooh, she was looking at Bumble. Yeah, she was looking at it. Okay. Ma'am, could we get a little Celebrite extraction of your phone, please? Oh, no? Okay, that's too far. Sorry.
Again, Your Honor, based on...
Do you have any other questions?
No, I do not at this time.
Does the state have any other questions?
Not related to the Bumble app.
Okay. All right, thanks, sir. You can wait for that back.
Okay.
Thank you, Your Honor.
Thank you, sir. You can see yourself out.
Pages Ms. Hollins 22 and 23 proves that Ms. Benning was dating other men.
I think it infers that she was dating other men. There are other...
We don't care about your inferences because it doesn't make a difference to the case. No one said she has to be an angel. We're in 2026. I think the jury knows that. Who on earth is an angel every single day besides myself? Who the hell are you guys? Are you angels, huh? Are we perfect? Is ever anybody perfect? I don't think so. That is not an argument to make. Defense.
Other messages that we also believe that she was dating other men in connection with that. And so...
What are you speaking of?
I'm speaking of in December when she was in fact pregnant and living a clean life, she sent naked photographs to 3 different men. These things...
That's not in what you said.
It's not...
No way. How would she do that? How could a 24-year-old send naked pictures to 3 other men? Again, it's 2026. Now, I'm not sending naked pictures to anyone, just to clarify. I'm sending no naked pictures, okay? That might have been a couple of decades ago. Not now, okay? But she was 24. What does that inference? Who cares? It doesn't make a difference. Blaise was out there getting other people pregnant. Like, and?
Because I did not want to put that type of information in here, but it is important.
So you're not planning on asking about that?
I do plan on asking about that. That's why I'm bringing it to the court's attention now, because the state
So
has...
what other texts are you wanting to introduce to this jury?
Outside of this, I want those text messages.
Where are they?
In December. I did not want to print out those types of photographs.
You're wanting the jury to see them, right?
No, I do not. I would just like for them to hear about them. That's why I never printed them. I was not going to print those text messages. Neither did I want to make them a part of the record. But I do want to talk about them.
You want to
It's
infer?
only fair
No, it's
that
not.
Mr. Taylor, who has been painted as someone who doesn't care, dating other women while he's with Miss Benning, that he is not afforded the opportunity to show.
Trash her.
Yeah.
They're trashing
Yes.
him, if that's the case.
Because he's the... Ooh, I almost swore. Felt myself hold it back. He's the defendant. Hello. I mean, it shows motive. That's why. Jade is not here to speak for herself because she died a horrific death when she was 5 months pregnant. Oh, my word.
So you want to trash her?
No, I want the jury to have all the facts, Your Honor. That is all.
That would be great if in fact it's proven.
Well, I can tell you those 3 messages are proven in December.
I don't think it's the proof they think it is. Like, he was dating other people, they painted him a certain way, and so was she. They're trying to trash him, we're going to trash her too. Well, that's childish. That's definitely not what's going on here. I don't think anybody cares that he was playing the whole damn field. Not as an NFL footballer. He was a scout, but like he couldn't play the field there, so he was playing the field in other ways, you know. I don't think anybody cares about that. No, ma'am. That's not the evidence we're looking at, really.
Has the state seen those?
No, Your Honor, the state has not seen them.
Well, I thought you downloaded her phone.
Well, I haven't looked at every single thing on her phone, and particularly whether or not she's dating men in December when they're broken up. The state's position is it's irrelevant.
That's the first time in 7 days I've heard that. So back to the pages 22 and 23. What does that show me under 401?
What it shows is that Bumble is known to be a dating application. It is not known to be a place where you go and say hello to a friend.
Yes, it is. I think Bumble has like 3 different types of Bumble. Am I mistaken? Because remember, Gabby Petito met her friend Rose on Bumble, right? That's the first time I heard of Bumble then. Okay. And there's like a friendship version, and then there's like a dating version. I don't remember what the 3rd version is. Let me look it up. Hold on.
He said it was.
He said it was one of the things you can do.
Well, then I'm saying it wasn't, because your witness just said it was.
He said that in response to the state's question if it was a possibility. He said yes.
He says that happens.
It's a possibility. But that is not the primary purpose of Bumble. That might be the primary purpose of Instagram, TikTok, Facebook.
Stop. Bumble, the dating or social app, has 3 main modes or uses. Number 1, Bumble Date, the original dating mode. 2, Bumble BFF, for making platonic friendships. And 3, Bumble Biz, for professional networking, mentorship, business connections, and career opportunities. Like LinkedIn, but more casual. Could somebody update actually the whole courtroom and say, hello, there's 3 different modes of Bumble. So which one are we talking about? Oh, the digital forensic guy, you can't say which one she was using. Okay, yeah, no. It could have been because she was a chef and organizing all sorts of events and going to cater for a wedding that she was using Bumble Biz.
But it is not the primary purpose of Bumble.
You're outdated with that, ma'am.
Would you acknowledge, I doubt you would, but I just ask it, that if you want to inquire with your witness, Mr. Devlin, about the application, Bumble application being installed on 2/17 and 2/23, that the state can also ask him if he looked at August of 2022 when it was installed.
Yes.
And your
I'm writing this for the state. State, is somebody watching from your team? You got that? You see that?
position is what?
If the state can talk about August of 22?
Just ask what they asked when the witness was in here.
We were confined, Your Honor, to a search period.
So is it fair to the jury to know that she also installed it on another occasion?
I don't have a problem with that.
Okay, that's what I asked. Okay, the other issues that the state had, you can cross-examine, find out dates, find out whether it's received. I mean, if it's received, some of these, quote, drugs and quote, involvements, it's received, so. It's like dating men. What does that have to do with 225? Lord, if I know, just like these others. That's one of their many theories. So remove page 23 from your PowerPoint and or exhibit. I'll let you ask your witness about these other texts and slides that you wanted to introduce. Is he the next witness?
He is, Your Honor.
Do y'all need a break?
But he needs to get on the plane, so I can wait if you don't mind, so that he can make his flight. I will wait for my break.
Okay. All right,
Okay.
Mr. Devlin, step back in and bring the jury down.
Judge, are you keeping out all three of the Bumble references?
I don't think you're talking about the one sheet that says Bumble?
Well, yeah, I don't know why I'd bring it up if you're keeping the other pages
Well,
out.
22
22 and 23 are the Bumble pages.
22 just confirms that, according to him, she installed it. So you can pull out 21 and 23 and ask him about 22.
Okay, so 20, because I have the presentation on my. So
Witness
22
number 9,
can
everybody.
stay in, 23 comes out.
And
One left after that.
21, 23 come out.
I don't have an objection to 21 and 22 staying in. I was trying to clarify that before.
But 21 is just some creep. It just doesn't matter. You can ask him about 22. What that means. All right.
The defense calls Eric.
Okay, there, we're not in here yet.
Oh,
Oh, where the jury at?
My digital expert is here, Your Honor. I'm assuming he can be present for this.
Okay. Thank you all for being here with me. Lara, you still here with
to be
me?
clear, what page
Nice.
are we taking out?
Do you have Mr. Grant?
Yes, I have it. It's page 23, if you want to do.
So it's this witness and then Dr. Lorcan, and then we're done with the defense's case, allegedly. Unless Blaise decides to testify. Will he take the stand? Maybe he will. It's up to him ultimately. Oh my word. Okay, going forward. Everybody stand, please.
You swear the testimony you're about to give to be the truth, so help you God.
I do.
Mr. Devlin?
Okay.
Could you please state and spell your name for the record, please?
Sure. My name is Eric, E-R-I-C. Last name is Devlin, D-E-V-L-I-N.
And Mr. Devlin, how are you employed?
At the present time, I'm the managing director of the Lone Star Forensic Group. We're a digital forensics company based out of Houston, Texas.
And where did you get your education, sir?
My undergraduate degree is from Southern Methodist University. My law degree is actually out of South Texas College of Law based in Houston.
And did you take the bar?
I did. And
Did you pass the bar?
I did pass the bar.
And after you passed the bar, can you tell the jury how you were employed?
I was employed at the Harris County District Attorney's Office, so that is the prosecution office for the city of Houston. I was there, I prosecuted everything from traffic tickets up to death penalty cases, but I spent most of my time as the chief of the cybercrime, child exploitation, and the human trafficking sections.
Have you had any specified training as it relates to digital forensics?
Yes, while I was a prosecutor, I actually began taking forensic courses to be a better prosecutor, present those cases in court better. While I was taking those classes, I actually realized I liked that better than the practice of law. So when I left the district attorney's office, I opened a forensic company, and I've continued taking forensic classes in a variety of courses, both cell phones, computers, as well as cell location analysis, as well as surveillance systems and other recording systems.
And have you had any specified training specifically to digital forensics?
Yes, I've received thousands of hours of specialized training, everything from Celebrite, Magnet Axiom, as well as a variety of other forensic courses specifically. I've also received advanced training in smartphone examinations.
And have you been published, or have you published articles in regards to digital forensics?
Yes, I have published articles related to digital forensics, cybercrime investigation, and child exploitation.
And have you had the occasion to testify before in digital forensics?
Yes, I frequently testify in Houston, where I'm based out of, but I've also testified in Florida, South Carolina, Ohio, and I think I'm missing a couple. So.
And have you had the occasion to testify on both sides, for the prosecution and the defense?
I more frequently testify for the state side than for the defense, but I do testify for both. So.
Thank you. At this time, I would tender Mr. Delvin as an expert in digital forensics.
Any questions from Mr. Taylor?
And I would offer Mr. Devlin's CV as an expert.
Okay, get that. Let's see, one. All right. All right, again, ladies and gentlemen of the jury, Mr. Devlin will be allowed to testify in his field of digital forensics. You can place such weight as you choose to upon his testimony. All right.
Mr. Devlin, have you had the opportunity to review the digital download of Jade Benning's phone?
Yes.
And in doing so, have we asked you to locate specific text messages, not all of them, but just a representative of some text messages?
Yes.
Specifically, I'd like to draw you to page 3.
Yes, ma'am.
Did you find any text messages within Ms. Benning's phone that dealt with drugs?
Yes, I examined an Apple iPhone 13. I was asked to examine and review the forensic extraction that was done by law enforcement. I did find a variety of messages related to drugs and other narcotics activity.
And can we start on page 4, if you will, and explain to us what is that we see there?
This is actually a Snapchat message. So this message was between Danny, the Snapchat ID, Danny Wallace Jr. and a Jade Benning. This activity occurred on 1/20/2023, approximately 6:53:47 p.m. This was in Central Standard Time, so that sometimes changes based upon the phone. This was a message that the user account Jade Benning posted to the Danny Wallace Jr., specifically stating, hey, could I get an 1/8 of top shelf and 1 Sativa or hybrid cart?
Do you happen to know what a sativa and hybrid cart is?
I am familiar with it. I am familiar that they are narcotics. I am not familiar with exactly what kind of narcotics they are.
Okay, well, draw your attention to page 5.
Yes, ma'am.
What date is that, sir?
This was 2/3/2023, approximately 9:57:21 p.m.
And is this message from or to Jade Benning?
This is a message from Jade Benning.
And could you read the message for us, please?
It says apple fritter with the emoji of a fire sign, $25 eighth, $50 quarter, $100 half, $150 zip.
Thank you. And on to page 6, please. Is this message to or from Ms. Benning?
This is a message that was posted inside the Telegram chat room, so it's not one sent by Ms. Benning, but it was received on this device.
What is a Telegram chat room?
Telegram is a social media site, a communication site. It's created by an individual out of Russia. It is advertised itself as to be super encrypted. It is not a good place. So.
And was this application downloaded on Ms. Benning's phone?
Yes, ma'am.
Oh my, Telegram, not a good place. And she had it. Okay, defense.
Can I draw your attention to page 7? Is this message to or from Ms. Benning?
This is a message posted in that gas station chat room on the Telegram application.
What is a gas station chat?
On Telegram, you can create all kinds of chat rooms and invite whoever you want to be a part of it. That's one that occurs, and actually in narcotics activity frequently occurs this way. It allows them to advertise sales or purchases or deliveries of different types of substances. And it's, again, believed to be encrypted and heavily anonymous. So,
And could you read for us the message that's on this particular date?
it says pressure plus with the emoji for carts with a fire $30 a pop, price cut on 2+.
Could I draw your attention to page 8?
Yes, ma'am.
Could you explain to the jury what this represents, what page 8 represents?
This is a
Rome with Thea Brago said, so the defense can have access to Jade's messages, but Blaise's devices are off limits. No, they didn't get the devices that were connected to the iCloud account. Those were missing, not trackable. They didn't get those. He got new devices and moved to Utah. You know what I mean? Thank you so much for your sticker. So this they got because they actually literally had Jade's phone.
an actual iOS text message. So this is a communication between this particular device and another individual. That individual they're communicating with is phone number 501-451-0608.
Public record.
And could you read for us the text message?
The text message start at 11/22/2022, 10:40:13 a.m. Do all of your coworkers get Adderall? The reply: Lauren has some. Message again: ooh, what MG? The reply was 15. Message to this particular device: ooh, ask her, can I buy some? And then the next was a follow-up. This is still a message to this particular device. And what color are they? And the reply from this device was orange.
And to the left there, who do you see is the sender of this text message?
The sender of this message is this number is listed in the contacts as belonging to, and I'm going to kill the name, Nijaha, Nijaiha.
Nigeria?
Yes, ma'am.
And what is the date of that text message, sir?
11/22/2022.
Can I draw your attention to page 9?
Yes, ma'am.
And could you read for the jury what page 9 represents with the date as well as the context?
This is an iOS text message, and this is between the Jade Benning account and Mario Gutierrez account. On this message, it occurs on 2/18/2023, 9:33:02. The message was from the Jade Benning account saying he's about to bring your weed. There's a reply from the Mario Gutierrez account. Says, I fell asleep, and I don't know if I'm allowed to curse in this courtroom or not. So.
That's okay. Thank you. Could you please turn your attention to page 10?
Yes, ma'am.
And could you represent to the jury what page 10 represents?
Page 10 is a iOS communication between the contact Danny, in parentheses weed, and this particular device. On this one, the message is, I have mushrooms right now. LOL, my coworker's wanting some.
And on what date is this text message?
I appear to have cut the date off on that text message. I can't tell you.
Okay, thank you. Would it be between the dates that you have listed there where it says first message, last message?
Yes, ma'am.
Thank you. And those dates would be between April 6th of 22 and 2/25 of 23?
Yes, ma'am.
Could you now go to page 11?
Yes, ma'am.
And what does page 11 represent?
These are text messages, specifically occurring on 2/25/2023, 9:10:46 a.m.
And what does the message say?
The message says, yo, can you holler at Danny? Your boy needs a half. Please and thanks.
Now, I don't see who this message was sent to. Do you have that information, Mr. Delvin?
I do not have that information.
And what date is on this text?
This text here is 2/25/2023 at 9:10:46 a.m.
On page 12, can you tell us what page 12 represents?
Page 12 is a text message between Jade Benning and the contact Danny Weed, and it occurs on 2/25/2023, beginning at 3:39:21 p.m.
And what does it say?
That's the day that Jade was poisoned. That's why the defense wants to show this.
Specifically, it says, hey, my coworker wants to get a half from you. The account Danny Weed replies, bet I gotcha when I get back. The account for Jade Benning replies, sweet.
Now, did you ever find through your research whether or not page 11 was a message from Mario Gutierrez?
I got to be honest, I don't remember. So,
Thank you. I want to draw your attention to page 13.
yes, ma'am.
Now, before we move on, were those all of the text message that involved drugs in between with Jade's phone from January of 22 through February of 23?
No, ma'am. They were a sampling.
Thank you. Let's now go to page 13. What section would this subject matter address?
I was asked to look for conversations about Blaise Taylor.
I want to draw your attention to page 14.
Yes, ma'am.
Please read for the jury the text message.
This is an iOS text message starting 12/31/2022 at 2:55:57 p.m. from the account 501-541-0608. Sent a message saying, I'm interested. Followed up with another message of, did you text or you just going to wait? The account belonging to this particular device replied, he called me back. And then a second reply of, I told him that I would call him when I get off. The account ending in 0608 replied, oh, I don't know, I didn't know you answered. And with a second reply of, how was his tone?
Do you know who this number 501-541-0608 belongs to?
I believe that's the same name that you gave me earlier that I butchered. So, yes, ma'am.
I want to draw your attention to page 15. And what is the text message thread, please?
On this one, it's a continuation from the previous page. It's the account belonging to this particular device replies, he sounded the same as always, but I could tell he had something he needed to talk about, of course. The account ending in 0608 replied, why am I anxious like I'm talking to him? This device's account replies, LMAO, because I've been waiting for this. The account with 0608 replied with, get off work already, LOL. The account for this device replied, right, I keep looking at my watch. And then the final message on there is a reply from the 0608 account, keep me updated.
Which is December 31st of 2022. So I think that's when Blaise got back in touch with Jade, right? Is that what we're looking at here? Because it's all over the place.
I now want to draw your attention to the next section. Could you tell us the subject matter of this next section?
On the next one, there's communications with Blaise Taylor.
And can I draw your attention to page 17?
Yes.
Can you please read that text thread for us?
Yes. In fact, I'm sorry, these are smaller, so I may read it from your larger screen. This particular account, the local user account, initiated a message saying, thank you for coming.
13th of Jan 2023.
To help/see the new place. I'm glad we got to talk about all that we did. It gave me a better understanding on some things I didn't have before. Hope you feel a little better as well, babes, with an emoji. The reply was from the phone number ending in 5738. Thanks and no problem. Just wanted to keep communicating and stay on the same page. The second reply of loved. Thank you for coming to help and see the new place. This account replied, 100% agree with you. Another reply, 100% also turns me on when we have our talks. The account ending in 5738 replied, laughed at 100%, also turns me on when we have our talks. with another reply of why, LOL. Then another message of, I feel like most of the time it's really me telling you stuff you probably don't want to hear.
Now, in regards to this text message, is this Jade Benning's phone in the blue?
It is.
Can we now move to page 8?
This is a continuation of that text thread, the account ending in 5738. I feel like most of the time it really me telling you stuff you probably don't want to hear. The next message was from the Jade Benning account. Not necessarily. You're just keeping it real at the end of the day, and that's all I ask of you. And because to see you serious, for one, LOL, and us being able to calmly communicate about the situations we have in front of us just lights me up. The account ending in 5738 replies, LOL, okay. Well, I said I'll always be up front and answer any questions you have. This account here for this device replied, urgent. And this device, this account, the one ending in 5738, was under the contact name of Blaise.
Thank you. Let's now move to page 19. And what subject matter is this section?
This specifically is related to messages regarding plans with Blaise Taylor.
And can I get you to turn to page 20?
Yes, ma'am.
And could you read for us the text message here?
This message was on 2/25/2023 at 12:03:10 p.m. The message was sent saying, okay, LOL, I'm going to plan to do a little at-home paint with Blaise tonight.
And what date is that text?
Hey, Jude Sales said, why did the prosecution not put up his text? They did put up text. They just didn't show it to us like this. They were just focused on the witness the whole time. They had their own forensic expert, Detective Miller. They didn't put up a lot from his phone because they got everything from Jade's phone because his devices, they couldn't find the devices that used to be connected to his iCloud account. So they had his iCloud account. They could see lots of messages and calls and things, but not much relevant to the case, especially not relevant to the time frame, because by then, remember, they arrested him a year later. He'd moved to Utah, and they didn't have any access to any of the devices he had during this time frame. So who knows where those devices went?
2/25/2023.
Can we now move to the next section?
Yes, ma'am.
And what section is this?
The label on it is Bumble.
Can you please
Let's see how they
identify
go.
page 22 and explain to the jury exactly what this is?
This specifically is a set of logs related to the installation of the Bumble application.
What is the Bumble application?
Bumble is an application that's on both iOS and Android devices. It's described as a social contact application.
And what day do you see that this particular phone installed the Bumble application?
There is an install of 2/17/2023 and another installation date of 2/22/2023.
And can I draw your attention to page 24?
Yes, ma'am.
And what is the nature of this section?
I was asked to find some communications related to Jarius Porter.
And can you read for us on page 25?
Yes, ma'am. On page 25, the communications start 12/17/2022, 9/17:30 p.m. The message from this particular device to the porterjarius@gmail.com. You've been getting it the last few. The porterjarius@gmail.com replies, yep, I'm on my way back to the shape I was before. I started dating a world-class chef. The message, this particular device replied, LMAO, I heard that. And then a second reply of, that's good though.
Okay. And can you move now to page...
Oh my word, you guys, gasp. Do you think the jury's like clutching their pearls? I don't think so. What? She downloaded the Bumble app? No way. She talked to another guy? No way.
26.
Yes, ma'am. And these are, there's a lot of messages in between, but it was designed to give basically an idea of the length of the conversations. So these messages occur on 1/24/2023 at 1:12:02 p.m. This message from porterjarius@gmail.com. That's good. I'm glad you have to.
Let me,
And you all switch.
Yeah, way to
yes,
go.
please.
Switch to the other.
I'm sorry, can I, do I continue?
Yes.
Oh, sorry. The message was porterjarius@gmail.com, 1/24/2023, 1:12:02 p.m. Message says, that's good. I'm glad you have to. I'm just honestly sad, but I know I want to be forever, and God make no mistakes. Glad you're feeling better. This particular account on this device replied, yeah, I know it hurts to know, but you can talk to me about your feelings if you want to express anything. I want you to take care of yourself better and not let yourself go down the path of just turning to drinking and smoking more to heal. The Porter Jarius account replied, of course, Shawty, and LOL, don't forget, working out too. It's some good going on too, but you're right, I've been planning on slowing down. This device's account replied, I know you're working out too, LOL, but still, don't be doing that extra stuff.
And the next text message that we have.
This was a message, actually, and I'm sorry it printed out in black and white, but this was a message from this particular device, specifically saying, Blaise told me last night he signed up for monthly subscriptions of diapers from this company, Kudos, LOL.
And what's the date, I'm sorry, on this text message?
1/10/2023, and I can't read the time, so I just need to move it over.
7:42?
Yes, 7:42:10 p.m.
And can we get you to read this text message?
Yes, this was a text message from the account 1-501-231-5975, asking the question of this device, does Blaise rub your belly, LOL? This particular device replied, sometimes.
And do we know who the number 501-231-5975 is?
I don't think I do offhand, so.
There were other messages. Oh, I'm sorry. What is the date? I apologize. On that text message, if you remember before I pulled it up.
I do not remember before you
Let me
pulled it up.
grab it.
Those messages were 1/25/2023, began at 9:30:11 p.m., ended at 9:30:35 p.m.
Mr. Devlin, in your search within Ms. Benning's phone, did you happen to run across a text message between...
Objection, Your Honor.
Okay, let the lawyers go.
Let the lawyers approach. Lawyers, get your asses over here. Blaise, what now? I like to watch the body language. We could go forward, but you know. Okay, we'll go a bit forward.
Regarding her posting about her baby, do you remember seeing any of those texts?
Sorry, what about her?
I vaguely recall that, but I couldn't give any details on it. I've seen a lot of messages, so.
Okay. And you don't remember if Ms. Jackson, Nigella Jackson, asked Ms. Benning when she was going to post about her baby?
I remember that specific message of when are you going to post?
When Ms. Benning responded, do you remember it having anything to do with Blaise Taylor?
I don't recall the response, so.
Thank you. I'm asking.
Questions from the state?
Thank you.
Defense is like, boom, but it isn't. Look at that mic drop. No, it really wasn't.
Mr. Devlin, you have gone through and testified about some random text messages. Would you agree?
Yes, ma'am.
Okay. And so when you said that you went through Ms. Benning's phone, did you actually take the text message that you have in your page 4 of your report, and did you actually look at the other messages surrounding it to see what context it was given? Which, Your Honor, I'm going to ask what he's doing right now with that tablet.
He's scrolling through his.
Are you looking at the report?
Yes, ma'am.
Okay.
I'm trying to see what was on page 4.
Yes,
So.
no, I'm happy
happy to. I just didn't know if you were looking at the extraction.
Oh, no. Did I see the messages, the context of the messages? I did not.
Okay, so you didn't look at the messages that actually preceded Jade's message to Danny, where one of her friends said, "We please top shelf an 8," and Jade responds, "Okay, I'll let you know when he's going to come."
I'm sorry. Yes, I did see all of that. That's absolutely correct.
Okay, so this message that Jade sent, like, "Could I get an 8?" She wasn't referring to herself because she was getting it for one of her friends.
My reading of it was that she was getting it for somebody else.
Okay. And then same thing with page 5. There are other messages that reference apple fritter. And Jade was seeing if anyone wanted this because she regularly would get different weed from Danny Weed for people that she worked with.
I mean, that particular set of messages was a frequent post within that Telegram group. So.
Okay. And going to your page 8.
Yes, ma'am.
Okay. And so your page 8, that is not Miss Benning. That is one of her friends asking for Adderall, correct?
Correct.
And did you actually read through that message thread with Miss Benning and her friend had a valid prescription for Adderall? Did you notice that?
I remember the discussion of that, yes.
Were you familiar with the Adderall shortage that the pharmacies were having during this time frame of November 2022?
I'm not familiar with that. So.
Okay, so if pharmacies were out of Adderall during that time, which actually if you read through the text between Ms. Jackson and Ms. Benning, they actually talk about the fact that Walgreens can't get it and everybody is out of their Adderall prescription from their doctor.
Okay.
Okay. And then, so this one, I would like for you to look at page 9, skip page 10 entirely, then look at page 11 and 12.
Yes, ma'am.
Okay. Did you connect page 9, 11, and 12 in any way?
Did I connect them? I don't guess I understand your question. So.
Okay, well, page 9 is actually the last message in a sequence of messages, but you put it first. And then when you go to page 11, you left the other person off of this thread, which is readily available in the extraction, but you left off Mario Gutierrez as the person asking Jade, "Can you holler at Danny? Your boy needs a half."
I do recall that. Yes, ma'am.
Okay, so that's Mario Gutierrez, but you left his name off of this.
When I pulled it, I don't think it was included in there, but that's correct. I believe it was Mario Gutierrez.
Okay, and then page 12 follows where Ms. Benning asks Danny very specifically, and this is on February 25th, "My coworker wants to get half." And Danny responds, "Bet I got you when I get back."
Yes, ma'am.
Which, and I apologize, page 9 doesn't actually relate other than it's from that Mario thread. The time that Mario gets anything is on February 18th, but your report listed 2 dates. It listed the 25th, which kind of inferred that the messages you included in 11 and 12 were on the 25th. But no one meets Danny on the 25th. You would agree with me about that, wouldn't you?
I have no idea if anybody met Danny on the 25th. So.
Because there's absolutely nothing in Ms. Benning's phone that indicates that happened. It's the opposite. Danny said, "I'm not here. I'll hit you when I get back."
I do recall that further messages where he said, "I'll hit you when I get back."
Okay. And on page 13, this section is labeled a conversation about Blaise Taylor. And that conversation, that's not the only one, correct?
There's quite a few messages about Blaise Taylor.
Okay. And this is from December 31st of 2022. And then again, the next section that you have that begins on page 16, that is not the only communication that they have, correct?
No, they had quite a few communications.
Okay. And then we get to page 19, which is plans with Blaise Taylor. And again, on page 20, for some reason, even though it's in the extraction, you left off the person Ms. Benning was speaking with. And this is from the date of 2/25/23 at 12:03. She messages her best friend, Nigella Jackson, to tell her that she's gonna plan to do a little paint with Blaise tonight. So you didn't put in the thread that they were talking about where to get the paint and maybe Dollar Tree would have it.
There was,
that may be connected to why she stopped at Walmart.
I remember all those communications. I know that there were some, even some pictures. I believe there was a picture of a crib as a part of it. There was talk about what they were going to paint. So I mean, there's a couple of those messages. Yes, ma'am.
Okay. And then on page 22, you have this Bumble information, which you have an install date. But you didn't include the message that showed that Ms. Benning registered for Bumble in August of 2022.
This was, when I ran this particular search term, this is what came up. But we talked about those messages before. I did see a message back in August of 22 that showed a previous registration for Bumble.
And
oh man, the state is doing so well with this cross-examination, right? Oh my word. Defense, you were trying to pluck together. That's how we would say in South Africa. You're plucking it together. You know, you're piecing together a whole bunch of things to try to take it out of context. And now it's just being put right back into context.
did you notice that the app was only in focus for 119 seconds?
Not very long.
It was very quick, wasn't it?
Yes, ma'am.
And you don't have any user data to show what was happening when she accessed that app.
Correct.
And so, like, if I thought that Kendall had a Bumble profile and I just wanted to go click on it to look at it to kind of give her some feedback as a girlfriend, it could have just been that.
Absolutely.
I really think the state should have said, if I, or let's say, wait, maybe Jade went on Bumble to look at the defendant's profile because, you know, she knew he was playing the field. Not playing on the field, but playing the field. Maybe she just got the Bumble app, looked him up. Maybe she didn't find a profile for him, or maybe she did and then just deleted it. How do we know? Yeah, instead of saying she could have looked at a girlfriend's profile, say Blaise, because that's similar speculation, but more relevant, you know what I mean?
And then you included some random messages with Mr. Jerry Porter. Did you notice that they were very close friends?
They appeared to communicate quite a bit, so during that period.
As very close friends.
I don't know enough about them. I just know I was asked to pull these messages. So.
Okay. And then the last messages that you apologize for being in black and white, so they don't have a page number. Do you know what I'm referring to?
I do know the message you're referring to. So.
Okay. So this is January 25th of 2023. And it's just a message from Jade's mother asking her, does Blaise rub your belly? And Jade responds, sometimes.
Right.
Did you keep reading the messages on where her and her mom actually message back and forth and draft a message from Jade to send to Blaise to tell her how much she wanted him to go to her OB appointment where she was going to find out the gender of their baby?
I recall something along those lines, yes, ma'am.
Okay, so. And you recall the messages where Blaise Taylor did not go to that appointment, correct?
I'm unaware if Mr. Taylor went to that appointment or not. So
you didn't look at those messages where he didn't show up?
I read through them. As to whether or not he did or didn't, I don't recall that. So.
Well, do you recall that he never went to a single OB appointment with Jade Benning?
Objection, speculation. This witness doesn't know that.
Okay. You can ask whether he reviewed any text about that. But
did you review any text messages where every time she had an appointment and asked him about it, he didn't go?
Objection. Counsel is testifying.
Do you recall any text messages about appointments?
No, Your
Honor.
No, Your Honor.
And the last message where Ms. Benning tells her mother that Blaise told her the night before that he signed up for a monthly subscription for diapers from this company. Did you find any other mention that proved that Mr. Taylor actually signed up for a diaper subscription?
No, I did not.
Thank you.
Any other questions?
Mr. Devlin, you were just asked the nature of the relationship between Jarius Porter and Miss Benning, weren't you?
Correct.
Were you aware that Jerry's
Objection, Your
Porter?
Honor, can we approach?
Well, she opened the door when she asked the question.
I don't know what you're wanting to ask, but you can approach the bench.
The lawyer is up here. Any more questions? The defense is absolutely. Oh dear, I think this witness helped the state more than anyone, right? Do you think this witness helped the defense? I don't think so. Look, see, he's got he's doing that face again. Where's that? This one. Here you go, we got it here. There it is. He's doing it. Do it again. There it is. Yeah. Sorry, it's late in the day, okay? I've got the giggles. Oh my. Yeah, it's not going well for you, Blaise.
Any other questions?
Were you aware, you stated on cross-examination that Ms. Benning actually downloaded Bumble first in August?
I found a registration message. It may have happened, Bumble may have been downloaded before that, but that would have been at least the earliest time that I know of.
Were you aware, or did you find out through looking through the phone that Blaise and Ms. Benning met on Hinge in the same month of August 22?
I did not see that. So,
in regards to Mario Gutierrez, did you notice through the phone that Mario Gutierrez is the significant other of Lauren Weber?
yes, ma'am.
And Mario Gutierrez on the 25th is the same one asking Jade to get her narcotics.
Yes, ma'am.
And that's Lauren Weber, the person who went inside of her home when was told not to, the crime scene. That is her.
Okay.
Damn, that was really misrepresented. Was told not to. No one said not to. It wasn't a crime scene. Technically, yes, but not deemed so. No one declared it a crime scene. Whoa, defense, you dirty defense.
There's disputes about it, so don't throw that up like it's true. So what is your question?
Your Honor, she said she did. In regards, she said she went inside of Miss.
We know. To blow a candle, get the keys. We know that. But she wasn't told not to go there.
Right, we've heard that, but there's nothing about police. We've heard all that today. The jury's heard it. So what is your question that this gentleman would have a foundation about?
Did you have an opportunity to look through the text messages between Jade Benning and Jarius Porter?
Yes.
Did you find that they were a little bit more than just friends?
Having read through the messages, I don't know if they were just friends or if they were what they call friends with benefits. I don't know. So.
In regards to the appointment of I think it was a February 2nd appointment for Ms. Benning to go to the doctor to find out the sex of the baby. Did you see any text messages where, well, let me first ask you this. Did you learn through the text messages that Mr. Taylor worked for the Tennessee Titans?
I don't recall seeing that, so.
Did you see through the text messages that on that very same day, he had to work or had an assignment at work with the Tennessee Titans?
If I did, I don't remember that, so.
In regards to the Bumble application, and I think that the question that was asked of you on cross-examination was that it could be an app where someone will go and say hello to a girlfriend. Is that what was stated?
I mean, I thought the question that was asked to me was, is it possible that somebody logged in to see if their girlfriend's profile was on there? I thought that was what was asked.
What is the primary purpose of the app Bumble?
They call it a social contact website, but for the most part, it is a hookup or dating application.
And this is the very app that Jade Benning registered for in August and then downloaded again. And I think you said February.
Correct.
Thank you. I passed.
Thank you. I'll pass the witness. That's right. She was trying to date other people. Again, your point is.
Any other question?
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
Have a good flight, sir.
Sorry, let the lawyer step up.
Yeah, let the lawyer step up. Now, let me tell you, lawyers, let me tell you right now. Your Dr. Larkin is not coming in. No, you didn't say that. I'm just joking, okay? So we're going to get our defense. You're going to rest now. We're going to get our asses out of here. Tomorrow doing closing argument. And that's it. Wow. Oh no, he's doing the, the teeth grinding. Yeah, that's right. It's not going well anymore, Blaise. Misty said, Blaisey boy was dating other people. Yeah, and they want to be like, the state said he was. Now we want to show that she was also. But only, one is in the courtroom. The other died from being poisoned, and he was the one lost with her. Oh, man. Tennessee Titans. The way the defense said that, like he was working for the Tennessee Titans. He's a good boy. He didn't do any wrong. While Jade was out there texting other men, like, okay, defense really not landing. Okay, I think they're coming back now. Wait.
We're going to recess for the day for your purposes.
Shame.
Remember what I said about not discussing the case, forming any opinion about it, looking things up, watching anything on the media, ignore all of that. And tomorrow, be back in the morning, 8:45, 8:50, we'll get you up here and resume the trial.
Okay.
Thank you very much. You can step down.
Thank you, Judge, for, not making us stay until 8 p.m. Tennessee time. Because for me, it's already 12:30. There's a lady in Switzerland, Judge. That's why I sent them home, right? It's for my purposes. Is that right? Judge, I know it is. Thank you so much. Let me make sure I set up our teleport. Okay. Listen, jurors, we're going to recess for the day. There's some lady in Switzerland who's covering this trial. And you know what that means. Switzerland is 7 hours ahead of our time. It's getting late, you know what I mean? There's a lot of people watching over there. So we're going to call it a day, and we're starting fresh tomorrow. Okay, Judge.
And I mentioned that bench conference about having a jury out hearing the state back to this document that well, let me ask this. Is Dr. Larkin out there?
Oh, we have more things to do here behind the scenes.
Okay. All right, well.
That was one way to put it. Your Honor, may I please use the ladies? I've been holding it. Oh, okay.
Take 10 minutes and then hear briefly from her.
A little comfort break. I've been holding it. Okay. So we've got now 7 minutes. The jury's gone home, but we're still here. Now they're going to be lowering it out. Let's see what they decide about this. Ooh, what are they going to decide about this next witness? That's going to be interesting. What if the judge said, nope, not allowing that in? Oh. Then that would mean tomorrow, when we start up again, they'll be like, oh, defense rests. Oh. Either way, the defense should rest tomorrow. Do you think there'll be rebuttal witnesses from the state? I think there should be. Does there need to be? Just in case. I think there should be. Especially, well, I don't know. I don't know if the toxicologist helped them at all in the defense's case. So I don't know. But either way, tomorrow, the defense will likely rest. We just don't know yet if Blaise Taylor will be testifying or not. Will he take the stand? Ooh, that's interesting. Because they'll be done with their witnesses. But then, And then, if he takes the stand, whoa, definitely have to make some popcorn for that. Oh, damn. Then, maybe the state's rebuttal witnesses. Then, I'm just speculating, Wednesday could then mean closing arguments, huh? And a verdict. Okay, sorry. Verdict by end of Thursday? It's got a few more minutes to wait. Yeah, Frankie said, ooh, I might stay a little longer for the after comfort break. Spiciness. It's going to be sehr good. Stay seated, everyone. We're waiting for them to come back and start battling it out in the courtroom. So, what did you think of the defense's case so far? I think it was so lame. I expected more, to be honest. That was terrible. That was a really weak attempt. Again, I'll say they should have just rested, honestly. In hindsight, just don't do that. Stefan said, I wouldn't call a rebuttal witness. The defense destroyed themselves with their case. I'd leave it like that. Right? I don't think there's probably not a need to call rebuttal witnesses. Don't worry about it. Just, no. Any rebuttal witness? No. Okay. Just a Grizzly Susie said the defense has done more bad than good for the case, in my opinion. Long Day said, yep, charging my headset now. Okay, nice. Hokuta with a crystal ball says he won't take the stand. How do you know? How do you know? Imagine if he does. Who was it again? Man, I asked this question the other day. Oh, I think I didn't cover the trial, but I was watching as much as I could. Right? There was the... What is his name now? Zachariah Rash. That guy. He took the stand. He took the stand. No one expected that. Sunk himself. Okay. My lips are sealed said, I was expecting more from the shameless defense. Yeah, this did not pan out very well for them. I wonder how they think they did. Do you think that they think they did well? Didn't go well. Is there lots of room for appeal? Maybe. Do you think there is? Fishy's 2024 said, no more toxicology. That dog's been run. Come on, just one more time. Sharpies, labels, different departments. Cocoa, ethylene. Angela Host, 2858 said, the defense was doing good during the state. And then, oops. True Crime Justice said, defense case was terrible. They sank their case. Yep. Now listen here, Joyce Brown. How dare you? Hasta mañana. See you all tomorrow. Thanks so much. Excuse me, Joyce. You take your seat. No. See you tomorrow. We're going to be waiting over here to see what they do next. Unless, of course, they cut the feed. Then we won't. But let's see. They should come back in 4 minutes or so. What silly arguments, especially with those text messages. And they just plastered a whole bunch together, tried to make some sort of sequence, but there was so much context missing. Leon Lately said, thanks Gisela for spoiling us all with your hilarious humor under this defense's desperate attempt to undermine Jade. She is the actual victim here. Right? They made like, but they were ugly to Blaise. Oh my word. Thank you so much for your €5.99 sticker. Here they come. I see movement. I also see a mosquito, and I don't like those. Leave me alone. Mosquito is like, got a bit of double thick milkshake somewhere here. Stop it. Okay. Brown Eyed Gal said, Blaise is toast in my opinion. Oh man, Linda F said if they call rebuttal witnesses, that defense attorney will get up again. Joy said, hold on, sorry, almost had a yawn. Sorry about that. Joy said, I'm sure the jury is questioning by themselves the protracted dismissals from the courtroom. I kind of bet they are over this malarkey. I mean, shame. They've really been out more than in today, hey? Wow. More. Lisa Braden said, I say double guilty. He was charged with 2 counts of first-degree murder and 2 counts of felony murder. Right? KK on YouTube, you can just look at the timestamps or the thumbnails. Thumbnails have clues. Timestamps have even more clues. The X was yesterday. Saturday. Day 5. And what day was the BFF? She's on the thumbnail. I think it was on day 2. Day 2. If you ever feel like when, just go through the streams. Look at the pinned comment, the one on top. I pin it for you. And then expand that timestamp and you'll see everyone that I put there for you, right? Nope. Libu Grizzly, and that's not who I was thinking of, but he also took the stand. Yes, that we say Gerard Koenig, but yeah, Gerard Koenig, he like a dumbass took the stand. Yes, he did. Tracy GTC said he doesn't have the courage to take the stand. He likes everything to be done for him. Is his mom going to take the stand? They'll be like, Mr. Taylor, will you be taking the stand or not? His mom's like, I'll do it. No, ma'am, that's not how it works. Come on. I've always spoken for him. Let me get on the stand for him. Nope, ma'am. Okay. KK on YouTube said, I know. What? I know timestamps, but I thought I'd jump to the day when the Grizzly myself. Well, don't jump. Don't leave. Just stay here. And then later, you can check out the whole playlist and see the thumbnails and see who's who and what's where. Okay, here we go. Judge.
All right, is there anything from the state's perspective, objection-wise, discovery-wise, about Dr. Linsey?
Do it. State. You object.
That's the...
We have absolutely no idea what Dr. Linsey intends to say because we have some handwritten notes that says red talk tube and some more.
She's being called for what purpose, Ms. Hollins?
She is a toxicologist who sent over a summary as requested to the state regarding what her subject matter would be. She is going to testify to the levels of concentration of cocaine, cocaethylene, and fentanyl in the samples of blood and urine of Jade.
She's going to be able to testify to an amount of cocaine that was taken?
She's going to be able to opine on the amounts that are listed on the toxicology reports and the litigation papers.
Okay, in terms of whether they are numbers that you actually rely on?
Correct.
Okay. So she's gonna be opining about what you asked Dr.
Yes, indeed. Same, Judge.
When you got into the 500,000, 98,000, those kind of numbers.
No, I didn't.
No, I'm not talking about you, I'm talking about the state.
Judge, I'm sorry, I have the same standing objection that she shouldn't be talking about any work order that is not entered into evidence.
We don't plan to.
That's fine, I don't think they're doing that. So, and then on Dr. Larkin, you now have this document, right?
Yes, so.
I'm asking the state.
Yes, sir. The report that we got today?
Right.
Yes.
So, is it the
Are they talking about 2 different witnesses here or 1? I don't know. I can't follow.
state's opinion that I can exclude Dr. Larkin from testifying because you just today got this document?
Yes, Your Honor.
Based on what?
On the prior motions that we filed last year, we have had, 0 notice. She's typed a report. She's trying to opine as to the cause of death, and we have had no notice. Reciprocal discovery as well. Your Honor was specific with them that if an expert was going to have a report, it had to be provided to the state pre-trial.
That,
Okay.
that is not a report. I did not get it until today. The court asked us to reach out to
Where
our
is Dr.
experts.
Larkin?
She's right here.
Let her step up.
Okay, Watermelon says, oh, pine is the courtroom air freshener. Stop it.
Stand right here, raise your right hand.
Don't be opining. So the jury's gone home.
Raise your right hand.
This is now Voire, but the jury's gone home. They're coming back tomorrow.
I swear. Do you need to do something?
You change out batteries.
Okay, go ahead. We waited on everybody else.
Thank you.
Did you generate this two-page document?
Yes, sir.
When?
This weekend, I guess.
And you gave it to who?
Weekend, okay.
I was asked this morning to send
Gave
my
it to who?
notes.
Did you give it to anybody this weekend?
No, I did not.
Okay, why did you compile this two-page document?
That is the way that I approach when I'm going to do something like this. In my
Why
mind, I
wait
need
for the
to.
last minute?
Yes, sir.
Why is that?
Because I'm going through what I've put together over time, and when it gets closer to me going to testify, I want to make sure that I clearly and concisely put my points. I was an engineer before I was a doctor, and
Okay,
that's how I
so
approach
when did
problems.
you send this to anybody?
This morning I was asked for notes, and so those are the notes that I have. So I sent those when I was at the airport this morning, about 10:30 maybe, and I sent that to Letitia and her team.
Okay. Any questions from the state?
Dr. Larkin, how long have you been working on this?
That was just very quickly putting that together.
No, she didn't ask that. You're talking about it, the case?
Right, how long have, you said that you just at the end put your analysis together that you've been working on. How long have you been working on your analysis?
I think I got asked to, I think when originally they were in Nashville a few months ago, I was told about the case, and then more recently I've done work on reviewing all the records, and that's probably within the past month or two. I don't know for sure, but...
You mean today? It sounds like today. All of it sounds like today. What is going on here? Oh dear.
More recent. It hasn't been years or anything.
Okay, so maximum 2 months, maybe a month, you've been reviewing records related to this case.
Approximately. I don't know exactly when I started. I'd have to look at when I started getting some information, but...
Do you have documents?
This past weekend, we need Jack Fox in here from Never a Truer Word. Sir? I'm detecting a bit of deception here in these statements. There's a lot of fluff going on. Ma'am?
Documentation about that with you?
I don't have it on me. I could find that out, but it's been several months.
Okay.
I would say on the outset, if you want a number, maybe, several months. Something like that.
Well, you said 1 to 2, and now you're up to several. Which one is it?
Yeah, I'm going to object to this
It's a few hours.
question. This
Is there something in your phone or something you have today that you could tell us? Look up and tell us.
I can tell you.
Okay, yes.
Letitia, I can tell you. And this witness, yes, you tell them. I don't want to lie on here. You tell them. Okay.
We reached out to her prior to the last trial. She was not officially retained at
That
that
was
time.
in January.
Yes, it was.
Okay.
However, she did not start actually digging into the trial until probably maybe 2 to 3 months ago, before she got everything that she needed.
Okay, what other questions do you have?
Did you take notes along the way?
No, I don't. I mean, I guess I put the notes into there. I don't have any other notes that I've taken, if that's what you're asking.
So no other notes, and you put that together this morning?
No, ma'am.
This weekend, last weekend.
Yes.
Last weekend, but you didn't send it to anyone?
I did not until today.
Were you instructed to not type up a report?
No, I object. I object to that line of questioning because what I tell my expert is confidential from Mr. Taylor and his constitutional rights. She
Do you have
doesn't.
any other questions other than that?
Not at this time, Your Honor.
All right. All right, thank you.
Thank you, sir.
The judge is like, okay, yeah, I'm going to deny that. Are you, Judge? Are you going to deny that?
Okay, here's what Rule 16, the Rules of Discovery under the Tennessee Rules of Criminal Procedure say, dealing with information subject to disclosure by defendants.
Judge, would you like an espresso? It seems like he would like a double espresso. Come to Ticino. Ticino is an area in Switzerland, the Italian side. Oh my word, their coffee is like, I want one of them right now.
Inspect and copy or photograph books, papers, documents, photographs, tangible objects, or copies or portions of these, if within the defendant's possession intends to introduce them. That's part A of that B1A. In terms of our discussion about what a report is, that's under B where it says reports of examinations and tests. And the pertinent parts say that the defense has to disclose upon the state's, the defense asks for discovery, then the defendant has to comply with reciprocal discovery, which the rule says inspect, copy, or photograph any results or reports of physical or mental examinations. That's what all the appellate cases mainly deal with, is insanity, mental health examinations, and of scientific tests or experiments made in connection with a particular case or copies thereof, if the item is within the defendant's possession, custody, or control, or the defendant intends to call as a witness at the trial the person who prepared the report. So, does this document deal with scientific tests or experiments?
Judge, she's giving her opinion based on the review of the tests.
Right. But did she do any scientific tests or experiments?
Well, I mean, I don't know, not that I'm aware of, but she refers to laboratory testing confirmed.
Okay. But then on the...
Thank you, Anita Butts, for the Canadian dollars, $24.99. Thank you so much for your support.
The second issue, if it should have been disclosed, it didn't exist till this weekend, which this is, what is this, Tuesday?
There's Nishaya.
So the state could have gotten it 48 hours earlier. So we get to the bottom line of, if there's a failure to comply with a request, the court may order the party to permit the discovery inspection. It's already untimely for that. Grant a continuance, prohibit the party from introducing the undisclosed evidence, or enter such other order as it deems just under the circumstances. So, if, I hadn't finished yet. If there is, I'm not sure there's a violation of Rule 16, but if there's a 48-hour violation, what is the state seeking the court to do?
Judge, we're asking that it be excluded just as we did in our pretrial motions.
Okay, but does it even fall under Rule 16?
It's your decision.
Did you carry her?
I do. How do I turn over something that I don't know exists? There's an email at 10:53. So it's not a report. She has done no scientific testing. She has done nothing of the sort. She made notes for herself to prepare.
Okay, then why are you calling her, ma'am? Sorry, what?
To testify. The court tells us, reach out to our people, find out if they have notes. Today is Monday.
And then,
I'm in the middle of trial, questioning witnesses, trying to get all the experts together to give the court what it asked for. That's difficult to do when I'm direct examining and putting on my case in chief. So at the break,
48 hours if she did it on a Saturday, which I don't, she wouldn't ask specifically. Go ahead.
sir, I believe she made those notes today. Okay, probably at the airport. Do you guys think that that witness made those notes this weekend? I don't think so. I think it was today.
and so we're complying with what the court asked. She didn't call us and tell us that's what she was doing. And as I stated, it's not even a scientific test. It's nothing that she conducted any type of test on her own. We don't intend to introduce it into evidence. So I don't understand what it is that we've done wrong.
Okay, anything further?
Judge, I have a secondary objection,
Okay.
depending on if you are going to allow it.
All right.
The state has a couple of other issues with this report, that is notes or report, whatever it is. Her report relies on information that is inaccurate and it's not in evidence. And it's specific to that urine test that Ms. Hollins keeps attempting to ask all these witnesses about, that is not in evidence. And the state is, again, asking that she not be allowed to testify to any of the lab reports that are not in evidence, but she based her opinion on a lab result that is incorrect. She also is opining as to the cause of death, and the state's position is that she's not qualified to do that.
Said she's an ER doctor. Where are you referencing a specific date about a urine screen?
So on her handwritten notes, it's kind of,
Oh, I don't have,
Oh,
who are
I'm
you
sorry.
referencing?
so
Dr. Linsey?
Dr. Linsey references that drug sample, and then Dr. Larkin, I believe, also references the urine sample. Right, it's on the bottom of page 2.
Fentanyl was detected in a urine specimen that was collected before fentanyl was administered in the emergency department. Is that what you referenced?
Yes. And then it says, therefore, the fentanyl identified in the specimen could not have originated from the hospital treatment, and instead indicates fentanyl exposure before her arrival at the hospital. And then she goes on in the third page, in the second paragraph, to talk about the opioid epidemic that has spread.
Yeah, I mean, I'm not going to let her testify about that. What about is that next to last and last sentence on page 2 accurate, Mrs. Hollins?
I believe that that is a question for the trier of fact. We were given discovery in this case, and when we were given discovery in this case, up until 10 days ago, the date on those lab reports were 2/25/23. 10 days before trial. They changed the date, and now we're precluded from being able to utilize that date.
Well,
So we believe that's an issue
the
for the
other
trial of
screen
fact.
wasn't tested, right?
All of them were tested. All of them.
Which one? I thought the Dr. Bruccoleri said no one that's been here tested that.
No one what?
No one has testified to the test result.
The work order 090 that went to some other lab hasn't been testified about.
Yes, it has been.
From who?
Katolsky, I believe it was. Dr. Katolsky.
Judge, we're referring to NMS work order 230788883. That is the one that this report is referencing, had a 2/25/2259 date. That is inaccurate. We did not correct it 10 days ago. We sent information to the defense months ago about the error on this date. We had the report corrected only in the event that it was somehow admitted during the trial, so we would not be sending inaccurate information.
From your deposition you introduced, say there was no fentanyl administered?
Correct, as well as...
I'm asking Ms. Holland.
Exactly. So what that means is when that urine test was tested.
What urine test?
The urine test that was tested before she was administered in
By
the
who?
blood test. In the blood test.
Tested by who?
Tested by NMS.
No, NMS did not
No,
test that.
They did.
It was CFSRE.
See, that's where this
Since when
courtroom's full of
Since when does a
confusion.
prosecutor call a lab and be able to change a medical record and we have to adhere to it?
No, I'm just asking you, is there proof
No, there's
that
no
you're
proof.
asking your expert to testify about?
Yes, for the last
Bring back in Dr. Larkin. We'll figure
Oh, dear.
what work order she's given his opinion about.
Oh dear. Dr. Larkin, no pressure. Diana B says, I don't agree with some of the chat, but I love watching you, G. But I mean, isn't that good? Imagine if we all agreed. That would not be healthy. The whole point is to have your own opinion, for people to agree, to disagree, to have different opinions, to have different insights, and that's what makes it so great to watch this together, you know?
What General Norman is the work order that no one's been here lab-wise to testify about?
NMS 2307
230.
78883.
You gonna be able to testify without anything in front of you?
No, no.
So my question is,
Oh dear.
is anything in this document, 3-page document, that has anything to do with work order 2307883?
I don't know. I think Dr. Yancey's in the back.
Who?
You're looking at the document that I submitted, not Dr. Larkin.
Stop it.
Why are you standing up?
Because
Just have a seat.
Okay.
Oh my.
So
Just have a seat.
I don't have any
You
reference
see
to any
those
work
last
orders
two
in there.
sentences in your report?
What is going on here? The judge, why are you standing up? Just have a seat. Sorry, who wrote that report now? I've got to, this poll has to end here. I said, when do you think the witness made a report? She didn't at all. Somebody else made it for her. Huh? Damn, today 73%, this past weekend 18%, a few days or weeks ago said 9%. How about the fourth option? She didn't make it at all. This is so wild.
It's not a report though, right?
This is so crazy. Judge, immediately just yeet this out of this trial. This is crazy. You said you were an engineer before you were a whatever you are now, a toxicologist or what? What is this lady? That is why you did, this is your process. It's not even your process. Oh my word.
Yes, I see that.
Where did you get that information from?
Yeah, where you got it?
From the toxicology records that I looked at.
From who? What lab?
I would have to look, I can't remember. These are just notes that I have.
How are you going to testify?
Yeah.
What are you going to use to find that out?
We will put those up when we put up the notes. I can ask to have that
She's
put up.
thinking about me.
So you have no clue where you got that information?
That's crazy.
I got them from I have all the toxicology reports, and I have summaries. I would have to look exactly where it came from.
Okay.
If this were a report, it would actually have reference to that.
Okay, well, tell me where that information came.
Yeah.
I would have to have the reports
Do
and
that.
pull it up.
Where is it? Is it the same report you asked about earlier, or this
Well, I
one?
can share this with you. What I plan to testify or have her testify about is
Where is the
I'm alleviating your issue.
You're not asking her about those last two
I'm not.
sentences. Oh, you said earlier you were.
No, I didn't.
Yes, sir.
Oh no.
Then why'd you put this in this document?
Yeah.
As she stated,
Those are just.
I'm not asking you.
Those are just notes for me to
So
look
you
at.
didn't
I would
rely on
never,
this-
if I ever
You
actually
didn't
produce
rely on
something
this
like
last
this.
paragraph for any of your opinion.
Not for what I'm going to be testifying to. No, those are just some of my thoughts I put down.
Okay, why don't we do
How are they your thoughts if somebody else wrote it? I think I have to hide under the table again now.
this?
If
You
I had-
asked her what you want her to testify about.
I'm going to tell you, she's not prepared right now to testify for that because I don't have my things together yet. She's going
What
to
do you
testify.
need to have together?
I'm going to tell you what the two reports that she's going to testify to.
Okay, give us those.
I don't have any problem with that, sir.
What?
231, 26,
But they were going to finish today, and what if the jury didn't go home? Then what are you going to do?
889 is one of them.
Damn, this is quite something.
And then 231, 292, 85.
Your Honor, that's the first blood in the comforter.
Okay. You have issues with that?
I do not have issues with that. I do have issues with this witness whose non-report that I consider to be a report relies upon false information. And
I don't know. Let me try to find out again. Your opinion that says the history, witness observations, clinical presentation, toxicology findings, and objective medical evidence support the conclusion that Jade's collapse is more consistent with respiratory arrest resulting from combined cocaine use and pre-hospital fentanyl exposure than with a primary sole cocaine-induced cardiac event. Is that your bottom line?
Yes, sir.
Where do you get the information that there was pre-hospital fentanyl exposure?
Yeah, where you get that?
Clinically, I can tell you in my 30 years of experience in treating patients with different types of overdoses, we have a clinical picture. We have the 911 call. We have the other witnesses that have spoken. We have the EMS.
You're talking about the sleepy, awake, talking, doesn't feel right, that kind of
Yes, and then, and the two reports that we'll be talking about on the comforter.
So, the,
Unfortunately, it wasn't tested for and everything.
what wasn't tested for?
She's not privy to it because I haven't had the opportunity to meet with her, which I had planned to do tonight.
What
The
wasn't
state-
tested for?
Why were you planning to do that tonight? When the judge said you're going to go through all these witnesses today? I don't understand how we're here at 6:10 Tennessee time. And the defense attorney, she wasn't ready, okay? She was going to meet with her tonight. They were going out for a lovely steak dinner, and they were going to talk about some things, okay? How are they going to, how does that saying go in Afrikaans? I think it's called spoeg and plak, which means spit and stick together, something.
Not everything about fentanyl was not necessarily tested for in
On what?
in the urine that's no longer done at 225.
But that's what I'm asking. You said you included your toxicology findings in making that opinion.
Your Honor, what is unfair is she's telling you that those are notes. Those are not her lasting opinions. That is not a report. So you're trying to commit her to something that she never intended to be that. So that's unfair to ask her for that. She has stated as a medical professional doctor.
Why
Those are
did you
her
include that paragraph?
notes. Those are her notes.
Those are just some.
But they're not even her notes. We just found out that somebody else stood up and said, I wrote them for her, right? Or did we hear things? Did we all just collectively hear things? What?
My thoughts, it doesn't mean they were
So
what
this
I'm,
paragraph on the bottom of page 2 means nothing to your opinion.
I'd have to look at it again. I just made some notes and I probably put,
This is jaw on the floor stuff. This is absolutely wild.
That's not the basis of my opinion, but.
So who wrote it? We know it's somebody in the back of the room. The judge is like, who are you? Take a seat, take a seat.
Again, they're just notes. They're nothing official. There's no report. I don't write a report that looks like that. I just was asked to give some notes and they were.
Let's do the bottom line thing the judge does. Ma'am, you don't know shit about what you're about to testify to, do you? And somebody else put together some notes that's not even your opinion, and you don't know what the F is going on those.
Things I just put together this weekend. And
So you don't know,
today.
Mrs. Collins, that you plan on asking her about any pre-hospital fentanyl use?
Yes, I do, because it was in the vomit. Their own witness testified that the vomit was the fentanyl was in the
From the
vomit.
lower level and all that.
It's hard, it's really hard. But what I'm saying is that the fentanyl was found in the vomit. That was testimony that came from that.
But you don't
state.
plan on asking this witness anything about that other work order?
No, I don't.
Okay. Any other questions?
Yes, Your Honor. The state, number one, that was not Dr. Mithen's testimony. Dr. Mithen was very specific.
Okay, do you have questions of this witness?
Yes, this witness's notes include a reference to the EMS guy said he thought it was an allergic reaction. We do not have those facts in this case.
Where are you referencing?
That is the last sentence in the first paragraph. Our EMS witnesses said the exact opposite.
I'm so glad that the jury went home and they don't have to wait for this.
Well, here's what I can't do. And again, if she testifies tomorrow in front of a jury on inaccurate information, then again, you have the Perry Mason moment and say, everything you've said, if it's based on inaccuracy, would be inaccurate. But she may not be asked that, so I don't know. So we'll have to wait and see what she's asked and go from there. Anything else?
Somebody going to do some cramming
May I
tonight.
ask that Dr. Carney be able to watch her testimony if she testifies tomorrow remotely so that she doesn't have to be down here because she's been here all
Oh, I
after.
get that, but it's important. She's willing to do that. We try like we did the direct link. I don't know what happened there.
I think he said he resolved it, right?
Sir, you will have latency like she did today. It all depends on their bandwidth.
Just get with that gentleman and provide that link to Dr. Carney. Is she going to be out of town or something?
Just go on YouTube and type in Grizzly True Crime. Dr. Carney can come watch with us.
I don't know, I just know that
She's
she has a
welcome
job
to
to
be
do
here.
because she does autopsies.
Well, she's employed by Davidson County. If you think she needs to be here, then have her here. All right, thank you.
Thank you.
Enjoy your dinner with the lawyers. Cramming tonight, are we?
All right, we'll be then in recess until 9 a.m.
Blaise Taylor looks like he's about to pass out. Look at him, look at him. He's looking weak. He's gonna faint. Yes, it's going that badly. That was crazy. Okay, well, thanks, Judge. Can't wait to see the state absolutely roast that ass tomorrow, meaning that witness. Good luck with that. Okay, so that's it for today, everybody. Wow. That's interesting. It should not be entertaining in this way. It should really be a lot more professional, right? Oh my goodness. So, everybody get some rest. Everybody stay in, please. We will now be going to nap. We're not having steak dinner and cramming. That's for that witness to do. She's getting no sleep. And if she does get sleep, shame. Good luck tomorrow. Good luck. All the jury and all of us will be watching. Ready for that. So let's teleport now to day 7. Let's see how that goes tomorrow. That'll be the defense's final witness. See if the state will have rebuttal witnesses. And then from there, what's going to happen, huh? Well, let's see if Blaise takes a stand. You never know. You never know in these trials. He might decide to. His mother might tell him, you get up there. And that will make him decide. If his mother says, you have to get up there, otherwise there's no chance, he's going to get up there. So, let's wait and see what happens tomorrow. I'll see you there. Thank you, mods. Thank you, patrons, members, everyone who's subscribed, everyone who supported the channel today. I really, really appreciate it. I look forward to reading your comments below. Bye, everyone.